And may I have your lordship's kind indulgence to mention a matter, my lord, which is not in your lordship's list, my lord, pray. So there is.
You have the leave to file.
Lordship, may I get
If
that
it may appear, my lord, any day, my lord, Friday, before Friday, any day.
No, vacation bench.
Kindly give us a chance. My lord, it's a contract which I have got from the Holdia Port Trust. They are not providing.
You haven't got the list for the vacation bench sittings? No.
It will not serve, my lord, the purpose of the petitioner, my lord. Something has to be done before Friday, my lord. I will not take, my lord, by the watch 2 minutes, more than 2 minutes.
When did you receive the notice for termination?
No, it's not a notice of termination. The contract is alive. But as and when the rakes are made available to me, I will have to execute the contract. But the Holdia Port Trust is not providing me the labor force at all. Permission. I've given them letter on
Last cause of action?
11th of May, my lord. I've given them the letter again that kindly make the workforce available to me. Because if the rake is given to me and I can't execute the contract, I will be blacklisted. They are not giving me the permission, my lord.
Yes, tomorrow. Have you filed the writ petition or not?
Yes, my lord. Filing it today.
Yes, leave granted, notice to the other side. No ex parte orders.
Yes.
May I get
Yes.
your lordship, kind leave lordship, the tender lordship, tender voted on 11th of this month, lordship, and bid submission date starts on 15th, Monday, lordship. Lordship, I have challenged the terms and conditions. Lordship, this time I do not want to file the late because last occasion I could not submit the tender bids. So that's I have approached late, lordship. That is why lordship kindly leave lordship to move tomorrow, day after tomorrow, any day, lordship.
Yes, leave granted tomorrow. Notice to the other side.
Much obliged.
May I have my lord's leave to mention a matter, my lord? I'm praying my lord's leave, my lord, to file and to move it, my lord. The urgency is, my lord, I am neither a borrower nor a guarantor, my lord. I have filed a civil suit and got an ex parte interim order because on contest, my lord, I got an interim order, my lord, from the civil court. Now, my lord, I have come to know, my lord, by making an application and RTI, the section 14 application has been filed by the bank, my lord, for taking possession. Now, my lord, already there is an order of status quo.
You don't have to be a borrower or a guarantor under
I know,
section 17(1) of the SARFACI Act.
Anybody.
17(1), anyone can go.
Anybody, my lord, anybody can go, my lord. But what I have challenged in the writ petition, my lord, is the action of the bank, my lord, that is, my lord, grossly arbitrary, my lord. Because after filing.
Mr. Deb, leave to move the vacation bench.
Very well, my lord. Kindly, my lord.
Yes, leave. Granted. Yes, call on the list, please.
For judgment, item number 1.
Mr. Bhattacharya at 12:30. I will dictate the order.
Item number 2.
My lord, I appear for the petitioner, my lord.
Microphone, please.
Okay, for the petitioner, my lord, I have instructions to withdraw the instant matter, my lord. My lord, the company has been merged with another new company, my lord. A new company doesn't want to pursue this matter, my lord.
Who is, this is not the petitioner. Who is Emaltech?
My lord, the second paragraph of my lord comes that we hereby inform that Mrs. Blastic Private Limited has been merged with Emultech, my lord. So the new company, the new transferee company.
Yes, learned counsel appearing for the petitioner hands up a letter of 22/2/2023 stating that the petitioner seeks to withdraw the writ petition. Stop the letter further. The letter is in the name of Emaltech Private Limited, which stop. The letter states that the petitioner Blastech India Private Limited has been merged with Emaltech by an order of the NCLT. Is attached herewith. Where is the attachment?
My lord, somehow they have not provided us the order, my lord, but this is the instruction we got.
Stop. The letter refers to the order of NCLT being attached, but no attachment has been placed to the court, placed before the court. Stop. Next, WPA 4582 of 2018 is dismissed as withdrawn. Interim orders again shall stand vacated. Are you for the respondent?
No, my not in this.
Grateful, my lord.
And all connected applications are disposed of. অনেকগুলো connected application আছে and all connected applications are disposed of.
Item number 3,
Ma'am, I am for this.
I can't hear you.
Madam, I am for the.
You're not supposed to be standing there.
Sorry, madam.
Please tell him where to stand.
I am for the respondents, madam. I am for the respondents.
You're for the petitioner?
Yes.
Sorry, I thought you're the
Mr.
you're the
Khushbu
petitioner.
Chattopadhyay was appearing in this matter. He has not
Madam,
been
on
able to
12th,
come.
madam, on
However,
12th, madam,
Yes, what is the
that
correction?
was only correction of page 2, my lord. Page 2, first paragraph.
Yes,
Last line.
Mic-
Which is
microphone,
presently
please.
pending in court, my last line.
yes.
But the writ petition is disposed of, which is
I can't hear you. Microphone, please.
writ application is not pending, but it's disposed of, madam, which is annexed P8 to the writ application, madam. Only, madam. This-
Learned counsel appearing for the respondent number.
Madam, respondent number 8.
Respondent number
6, my sorry, respondent number 6, my lord.
Respondent number 6 seeks a correction in the order passed by this court on 12/5/2023. Stop. The petitioner is represented. Stop. Counsel submits that the last line of the first paragraph at page 2 of the order should record that the writ petition filed by the deceased husband has been disposed of. Stop. Let this correction be incorporated in the order dated 12/5/2023 and be treated as a part thereof.
item number 4,
My lord, I am for the petitioner. My lord, in this case, my lord, I beg to your lordship that the withdraw the petition as the array of the parties, my lord, not properly arranged.
What do you mean by not properly arranged?
My lord, the Union of India, nobody is appearing neither for Union of India nor for the state. My lord, Union of India, my lord, it was not, it should be served upon the principal secretary. Principal secretary.
What is the matter about?
The matter about, we have challenged the violation of the ART Act, section 21G. My lord,
I've already passed a judgment on that. Same issue.
my lord, your lordship has passed certain order, but this particular, in this particular petition, the couple are beyond the age limit.
So that was the same fact before the other judgment which I've passed. I think one of the wife or the husband was beyond the age limit.
Well, in this matter, I'm only praying that the leave should be given to withdraw this petition and to file a fresh application. Only I'm praying, my lord.
Learned counsel appearing, what is the ground for withdrawing?
My lord, ground, sir.
What is the ground for withdrawing?
My lord, withdrawing, but only the cost title was not properly arranged. Cost title is wrong, my lord.
Cost title is wrong.
My
What? I
lord,
can't understand. What is the ground for withdrawing?
my the petition, my lord, not properly, my lord, the cost title was not properly arranged.
Upon costs.
My lord.
Learned counsel seeks to withdraw the writ petition on a ground which is not comprehensible to the court. Stop. According to counsel, the cost title is not properly arranged.
Yes.
Stop. WPA 2259 of 2023 is allowed to be withdrawn and is dismissed as such upon costs of rupees blank to be paid by the petitioners
My lord.
within a week to blank. Stop. All interim orders are vacated.
My lord, the liberty to file a fresh application.
Liberty to file a fresh. Next.
And cause of action, my lord.
item number 5,
Please, my lord. My lord, I appear for the petitioner. My lord, here the petitioner is a chartered accountant
Yes.
and he had audited the books of account of one of the chit fund companies for one financial year, 2011-2012.
What is one of the chit fund companies?
My lord, this is iCore Services Limited, and he had audited the accounts of one of the companies called Mega Mold India Limited. It's a group company of iCore. My lord, the matter was investigated by the Serious Fraud Investigation Office and
Affidavit of service, please.
Lordship. I've handed over, Lordship.
Who is the answering respondent? SFIO?
My lord, the Institute of Chartered Accountants, my lord, because it is their notification. They've relied on the SFIO complaint and they've held me guilty of misconduct. My name should be struck off the register for 4 years along with a fine for 2 lakhs. My lord, the matter cannot be finally disposed of without affidavits, my lord, but for the sake of the interim order, my lord, at least may I point out only 2 or 3 material facts, my lord, from the impugned order.
No ex parte order without the chartered
My
accountants.
lord, we have
being
served,
present.
my lord, in that case, as my lord pleases, my lord.
Yes,
My lord,
show me the impugned order, please.
Lordship.
The 11th January 2019 or 26/3/2023.
26/3/2020. I preferred an appeal before the appellate authority under the Chartered Accountants Act, and they have dismissed my appeal. I will only refer to that judgment, Lordship. And I had filed the writ petition before Delhi High Court. I got an interim order, but it is only a limited interim order till I move the.
Show me the
May
Delhi
I-
High
may-
Court order, please.
Lordship. My lord, that is page 1770 of volume 9, my lord, of the writ petition.
Why did you go to the Delhi High Court?
My lord, the appellate authority proceedings were held in Delhi, which is why I was then advised that I should move the Honorable Delhi High Court, and I filed it there. In the course of hearing, after I got the interim order, my lord, it was advised that I should withdraw it and file it.
Yes, give me the Delhi High Court order, please.
Lordship, page 1770, my lord.
Yes.
Lordship, may I draw my lord's attention to paragraph 2. The present petition has been filed by the petitioner challenging the order dated 26 March 2023 passed by the appellate authority. Just confirm the order of the disciplinary committee holding the petitioner guilty of professional misconduct and directing removal of the name from the register of members for a period of 4 years. On 26th April 2023, when the matter was listed before the court, it was directed that the notification of the ICAI to the effect that the name of the petitioner shall be removed from the register of member for a period of 4 years shall stand stayed till the next date of hearing, and the matter was fixed for hearing today. Today, after some hearing, Mr. Bokshi, Learned Senior Counsel, seeks permission to approach the Calcutta High Court. Paragraph 5, Lordship, at 1771, considering the fact that in the first round of litigation, the petitioner had made a challenge before the Calcutta High Court and the order of sentencing has been passed at Calcutta, the petition is dismissed as withdrawn with liberty to petitioner to approach Calcutta High Court. The interim order, which was
Very
granted
good.
on
Yes, till 30th of May.
till 30th
And
of
what was
May.
the first round of litigation, which was in Calcutta High Court?
My lord, that is when the proceedings were on. I had filed the writ petition, and it was disposed of on the ground that no order had been passed yet.
No, so why did you challenge the proceedings? On what basis?
My lord, I had challenged because the entire proceedings before the disciplinary committee emanates from a prima facie opinion formed by the SFIO. My lord, in the prima facie opinion, first of all, I was
Under
never,
which act?
Lordship.
Under which act?
My lord, this was done, my lord, under the this was under Supreme Court direction, my lord, by which the CBI.
No, this requirement of prima facie opinion under which act?
My lord, this is under the Chartered Accountants Act because they have to file SFIO has to file a complaint under the Chartered Accountants Act before the disciplinary committee, after which the disciplinary committee commences proceedings against any of its members. My lord, there I was not given any notice. The main reason was the opinion and the proceedings were based on 3 annexures to that opinion. Those 3 annexures till date have not been provided to me. Nevertheless, my lord,
Very well. Show me the appellate authority's order, please.
Lordship. My lord, kindly takes volume 1, page 142. My lord, I'll show from the order itself, it's I should have been exonerated.
Yes.
Lordship, kindly takes paragraph 2, my lord. The present appeal has been filed by the appellant under section 22 capital G of the Chartered Accountants Act. My lord, what punishment has been given has been noted, my lord. Now, my lord, kindly comes to page 143, paragraph 3.2.
Yes.
The appellant was the statutory auditor of Mega Mold India Limited for the financial year 2011, 2012, and various other companies, my lord, but there's no allegation with respect to those. It's only with respect to Mega Mold. Now, my lord, kindly takes paragraph 3.4 on the same page, page 143.
Yes.
On completion of the investigation as directed, SFIO submitted its investigation report to the central government, Ministry of Corporate Affairs, in terms of section 241 of the Companies Act. Pursuant thereto, Sri Nilmesh Badua, Director SFIO, by letter dated such and such, authorized Sri K.S. Kaushik to file and prosecute a complaint before ICAI against the appellant. My lord, that complaint was filed as per the rules framed under the Chartered Accountants Act, and my lord kindly notes the violations. My lord, 3 violations. First one is non-accounting of deposit collected in the financial statement. My lord, this is the only charge on which I was held guilty, because charges 2 and 3, my lord, there's no finding. Ultimately, I've been exonerated. It's only the first charge, non-accounting of deposit collected in the financial statement. Now, my lord, it proceeds, my lord, the facts are there. I'll straight away, my lord, come to the finding of the appellate authority. On merits, my lord, there's a technical objection. I'm not placing it right now. If lordship kindly comes to page 161.
That's a continuation of the order.
Lordship, that is where the finding of the appellate authority starts, my lord. Before that, it's all the submissions of the parties.
Yes.
My lord, paragraph 35. The appellant was the statutory auditor of MMIL for the financial year 2011-12, as also statutory auditor of other ICOR group companies. Before proceeding in the matter, we may note that as per Schedule B of the complaint and as per investigation report of SFIO, appellant was charged for the following violations. Now, my lord, this is noted, and then my lord kindly turns to paragraph 36 at page 162.
Yes.
The only allegation survives against the appellant pertains to non-accounting of alleged huge deposit collected in the financial statement of MMIL. Perusal of record shows that this allegation is related to receipt of rupees 202.27 crore allegedly received in the financial year 2010-11, my lord, before I was associated in any capacity with the company, on account of issue of debenture, and carried forward in the subsequent year 2011-2012. And rupees 63.59 crore received in the relevant financial year 2011-12 by MMIL from undisclosed sources. Nothing is on record to establish identity of depositors, nor it has been established that aforesaid money was deposited in the bank account of the company by way of cash or otherwise. Now, my lord, the first point is with respect to 202 crore. I did not account this. I did not incorporate in the accounts. I only carried it forward. Admittedly, there's no dispute about this.
When did you become associated with this company?
My lord, for the financial year 2011, that's 1st of April 2011 till 31st of March 2012.
So why are you saying that 2011, 2012 you were not involved?
My lord, 2010 and 2011, with respect to the amount of 202 crore, which apparently I have non-accounted, which is also not correct. Lordship will see in my audit report, it's a qualified report.
Your next point?
Lordship. Now, these are the only 2 allegations, my lord. I will see, Lordship will see paragraph 37. It itself records what I have recorded in my auditor's report.
Yes.
My lord, from a bare perusal of the audit report dated 3/9/2012, it is evident that the appellant has expressed his audit opinion subject to observations mentioned at point 3 and 4D of the auditor's report, as also observation given. Now, my lord will see that is set out. Lordship will see from the set out portion at
Show me the ordering portion, please.
Lordship. My lord, page 170, paragraph 45. But may I draw my lord's attention to only what I have mentioned in my audit report, which
No.
itself will show that there is no question of non-accounting here.
The petitioner is a practicing chartered accountant, capitals. and seeks temporary relief from a judgment dated 26/3/2023 passed by the Appellate Authority, capitals, constituted under the Chartered Accountants Act, 1949, the Cost and Works Accountants Act, 1959, and the Company Secretaries Act, 1980. Stop. The petitioner next. The petitioner approached the Delhi High Court from the impugned order by way of filing of a writ petition, and a single bench of the Delhi High Court by an order dated 28/4/2023 protected the petitioner in the interregnum from 26/4/2023
My lord, may I point-
until 30/5/2023. Stop. The order of the Delhi High Court records that the punishment of removal, punishment of the petitioner's removal from the register of members, capital R, for 4 years was directed to remain stayed by way of an earlier order passed by the Delhi High Court on 26/4/2023. Stop. The order further records that the learned counsel appearing for the petitioner sought permission to approach the Calcutta High Court on the ground that the Calcutta High Court, stop. The court was hence of the view that the Calcutta High Court, that the petitioner should be given liberty to approach the Calcutta High Court, since the first round of challenge to the disciplinary proceedings was made in this court, and the impugned judgment was also passed in Kolkata. Which is this order of sentencing?
My lord, the order of sentencing was passed in Calcutta by the disciplinary committee. My lord, this is
And the impugned judgment, and the order of the disciplinary committee was passed in Kolkata.
My lord, that is 11 January 2019.
Order of the disciplinary committee dated 11/1/2019
My lord.
was also passed in Kolkata. Stop. The interim order was hence directed to continue till 30/5/2023 for enabling the petitioner to approach the Calcutta High Court. Stop. Next. Upon considering the impugned judgment of the Appellate Authority dated 26/3/2023, this court is also prima facie of the view that the alleged violations of the alleged violation of non-accounting of deposits collected in the financial statement of
In the financial statement. my
Mega,
lord-
please, I will ask you to make,
Lord,
don't disturb the court,
I'm sorry.
of Mega Mold India Limited, MEGA Mold, MOULD, দুটো আলাদা কথা, Mega Mold India Limited, was done at a time when the petitioner was not associated with the said company. Stop. Mega Mold 143 te page jabe. Stop. Next, apart from the above, The protection given by the Delhi High Court, which was directed to continue till 30/5/2023, should also continue until is heard out, until the respondents are heard, or until further orders, whichever is earlier. Stop. Next, list this matter on 6 June 2023. Next, list this matter on 6 June 2023. Stop. The petitioner is to communicate this order on the respondents.
My lord, may I make just one submission, my lord? My lord,
Yes,
that is with after the 26/3 judgment, my lord, on 28th itself, this notification had been published on the basis of the 26/3 judgment that the name be struck off. So the word notification in the 28th April judgment, my lord, refers to that notification. If lordship kindly records that it's the notification.
no, have you not included that in the press?
My lord, because I have all consequential steps have been given, because this cannot stand without the judgment. I'm just pointing it out. I'll put this on
Very well,
supplementary.
but then not necessary. Yes,
Grateful, lordship. Great,
leave to file a supplementary affidavit.
grateful. Lordship.
Yes, actor line likha do. The affidavit of service shows that the respondents have been served. Stop. None of the respondents are however represented. Stop. Did you mention upon notice to the respondents?
Lordship, I did, lordship.
Yes, the respondents were put on notice when the matter was mentioned for urgent listing. Stop. The respondents were also present before the Delhi High Court when the petitioner was given leave to approach the Calcutta High Court. Stop. Next.
Grateful, lordship.
Item number 6.
I'm opposing.
The
Yes.
petitioner before your lordship, it is has a foreign liquor shop and as well as country liquor shop from 2004-5 till 31st March 2023. And thereafter, the excise department,
Is there a demand in this kind of heat? Is there a demand for liquor in this weather? I'm just curious. No, then I will put the matter after the vacation. That's all.
my lord, after my lord, problem is that 31st March, as your lordship, no problem, but 31st March
No,
2020.
no, I'm asking for your personal opinion.
Arjuna,
He wouldn't know, my lord.
my lord,
He wouldn't know, my lord.
my lord,
Do you want to disprove the general and the collective view? Do you want to disprove that?
no, my lord.
No,
No.
you don't want to rise up to the challenge.
That's the
Very
only
good.
point I will not join issues with him and if he makes that submission.
My lord, last date of renewal 31st March 2023. My lord, here what has happened, it is admitted fact the petitioner is the licensee from 2003-4 to 2023. My lord, problem arose when petitioner, my lord, inducted on a private power of attorney not binding upon the excise department, my lord, the private respondent. My lord, thereafter, my lord,
Inducted as a partner.
I not only partner, I look after my business in the by power of attorney, notarial power of attorney.
Yes.
Thereafter, that notarial power of attorney dispute cropped up in between the my lord private respondent and me, and there are case and counter case, civil cases, criminal cases, 138.
So this is what rule 14(6).
No, my lord, private dispute in between private respondent.
So then
And-
why are you before the writ court?
Because my lord, thereafter in the month of June 2023, in connivance with the some officer of the excise department, the private respondent changed the password of the my lord said excise shop. That password is essential.
So completely a private dispute.
No, to change the password by the admin of the excise department, my lord provided the password of the said shop for maintaining
Is it a cloud shop? What do you mean by password?
password. Nowadays, password is required for my lord purchasing the my lord liquor from the government corporation, my lord.
Password.
Password. My lord,
So
online.
it is not an over-the-counter sale.
No, my lord, password, my lord, for purchasing the beverage from the government, one password is required, my lord.
It's not a beverage. Yes.
My lord, my lord, password was changed by some officer of the excise department to the private respondent. The private respondent,
What is you're saying that there was a collusion between the excise department and the private respondent
yes, my lord,
in doing what? Giving the password.
but in giving the password, my lord. And thereafter, my lord, I was ousted from the business from June 2022.
How can you be ousted by disclosing the password?
The business transaction, selling, purchasing, all, my lord, beverage.
And when was all this done?
My lord, that was done from the first, my lord, password change in the month of June 2022.
That is why I'm telling you, Mr. Chattopadhyay, that let me put it after, let it complete an anniversary in June 2023. Yes?
My lord, I have your lordship, my lord. If your lordship
No, no,
decide
if
after
you-
vacation, no problem, my lord. My lord,
Because you have been suffering this.
suffering because of the
for
fact,
almost
because
last
of
year.
the fact, if my lord license, renewal of the license is urgent, my lord. 31st March 2023 is the last date.
31st March 2023.
Already expired, my lord. And I have, my lord, I requested the
So this
excise
is not a settlement of a permanent license.
my lord, for 1 year. From 2004 to 5, every year, 1 year, my lord. Renewal.
So this is not under section 37.
No, my lord. My lord, for 1 year, that is from 2004 to 2023, all license with me, my lord. I annexed the
Yes,
all
Mr.
licenses.
Ray, what is this? You're for the excise
Yes.
department.
Yes.
Then no, what will you say? Not maintainable.
Well, first of all, well, it's a private dispute. I was never informed that he has given a power of attorney. Well, he has disclosed the,
Under the rules, are you supposed to be informed?
well, he's not supposed to give it. He's the licensee. But
Yes.
what he has done is basically, Malad, this is the way licenses are being transferred now. That is what he is trying to do.
Yes.
Now he has got into a fix with his whatever the power of attorney holder is. Now he says that I've now revoked it in 2021. I am not made aware of that. Now there is a
2022. That's what he said.
2021 according to his petition, Malad.
He said June 2022. Did you not
June
say that?
2022, change the password. Excise department change the password, my lord, in favor of the private respondent.
Yes.
And June 2021, revocation of the power of attorney.
Yes.
I inform, page 60.
Para 21, Malad, he says, I state that thereafter on July 2021, I revoked and withdrew the said power of attorney executed in favor of Narayan Chandra Raha. But I get to know
That is Mr. Bhattacharya.
must be, Malad,
Yes.
must be. So that is what he says now in 2023. According to my, Malad, as far as got instructions, Malad, his license is still valid. That is what I've got to know.
But he's saying revoked in
But he said
2021.
that is what I'm saying, Malad. That is why I've got a written instruction, but I would like to put in the papers, Malad. Or what can be done, Malad? He has asked for, Malad, he has written to my commissioner, Malad. It can be sent back, let him pass an order.
Written when?
Malad, that has been written, Malad. Very recently, I'm so sorry, Malad.
Page 80.
80, Malad. কবে লিখেছিল বই আছে?
That
Not very
is
recent.
23rd March 2023, page 82.
Malad, the main point, why is he doing this, Malad? He doesn't have the password, user ID and password. Malad, that is given to him at the very initial stage, and then he can change it if he wants to. Now he has given it to his power of attorney holder. Who's changing it? I don't have a role in
No,
that.
I cannot change, my lord. Admin can change.
My lord, I
Admin
cannot.
means excise department.
Mr. Bhattacharya, you're for who? For the petitioner?
Admin change করে
Yes, Mr. Bhattacharya, in June,
June.
because there's no urgency. What is the urgency in the matter?
Renewal of the license.
The revocation is according to the statement made in the writ petition of June 2021.
Made within first,
Microphone, please.
then Lord, on the reopening, if Lordship kindly, on the first week of reopening.
First week. Very well. And in any event, come to page 80, please, Mr. Bhattacharya. Can I dispose of the writ petition on this basis?
Directing that to consider the
Yes,
presentation.
yes, I will. Within a
Because-
time,
That may be done, Lord, within
Because
time.
the merits are not very strong. Not very strong. In any case, I would have had to decide on the maintainability.
That representation needs to be decided. Without that, my lord, the real facts would not be revealed. What is department's role? Let it be done, Lord. Let it be done within 2 weeks after the vacation, and then we shall try.
I'll okay, my lord. That
Very
is what I
well.
also submit.
There is a suppression in the writ petition which needs to be pointed out. My lord, the writ petitioner carried a writ petition registered as WP 9406 of 2022, my lord, which he himself withdrew. And he has not disclosed, my lord, these facts. My lord, he should have come up with clean facts in the writ petition. And that centers around the same issue. He has disclosed the 144 proceedings, my lord, in the writ petition. My lord, he has also disclosed, my lord, at page 83, my lord, a representation addressed to the superintendent of police Bongao. But, my lord,
I will direct that the excise commissioner will hear both of
Yes.
you, and you can urge these points, suppression or whatever. Yes,
you like.
the grievance of the writ petitioner is directed against revocation dated which prayer? Revocation of June 2021. Is that
Yes.
correct? June 2021, which prayer?
no, representation is of 23rd March.
Stop. The grievance is also directed against the private respondent number 8 and the officers of the excise department, capitals, for an alleged disclosure of the password of the petitioner's liquor shop. Stop. The private respondent number 8 was inducted into the petitioner inducted the private respondent number 8 into the business. Stop. Next, after hearing learned counsel appearing for the parties, including the learned government pleader appearing for the excise authorities, comma, it appears that the petitioner wrote to the collector and the superintendent of excise, comma, North 24 Parganas on 23/3/2023. Is that the date?
Yes, yes.
23/3/2023. Ventilating his grievance against the respondents. Stop. Admittedly, comma, this representation has not been answered by the concerned respondents till date. Stop. Next, WPA 8316 of 2023 is disposed of with a direction on the collector of excise. Who will consider?
Collector.
The collector of excise, comma, North 24 Parganas, being the respondent number 4. To consider and dispose of the representation by way of a reasoned order upon hearing the petitioner as well as the private respondent number 8 within a period of within 31st May 2023. Stop. A copy of the reasoned order shall be made available to the petitioner by 5th June 2023. Stop. When do you want to come back? That's fine.
Disposing of them.
No, yes, by 5th June 2023.
Kindly keeps, my lord, all points kept.
Yes, all points agitated before the court are kept open.
May I make one request, my lord? My lord, if this could be disposed of by the 5th of June, my lord, because, my lord, 31st of May, my lord, if your lordship kindly
ওই
considers.
যেটা বললাম 31st May, সেখানে লিখে দাও 5th June. Stop. A copy of the reasoned order shall be made available to the petitioner by 9th June
Very
2023.
grateful, my lord. I'm sorry, my lord, I missed one.
Item number 7.
May it please your lordship.
I am for the responding number 1 and 2.
My lord, the short point, my lord, involved.
Yes.
My lord, short point involved, my lord, is my lord, whether, my lord, the National Commission, my lord, for scheduled castes, my lord, could have, my lord, initiated these proceedings or passed, my lord, the order, my lord, impugned here.
Yes.
Now, my lord, the respondent number 3, my lord, is, my lord, employee, my lord, of the state, my lord, in, my lord, the health department.
Yes.
My lord, disciplinary proceedings, my lord, had, my lord, been commenced, my lord, against, my lord, the respondent number 3.
Yes.
And, my lord, ultimately, my lord, it has resulted in an order of dismissal. Now, my lord, kindly see, my lord, I'm addressing your lordships only on 2 points. My lord, one is, my lord, there was nothing, my lord, for, my lord, the National Commission, my lord, to, my lord, exercise jurisdiction in the matter. Kindly first take, my lord, Article 338, my lord, of the Constitution.
Yes.
My lord, kindly come to 338(5), my lord.
Yes.
Lordships kindly sees, it shall be the duty of the Commission to investigate and monitor all matters relating to the safeguards provided for the scheduled castes under this Constitution or under any other law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. This is one. It's not, my lord, applicable here. To inquire into, now kindly note this, inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes. My lord, this is what is being sought to be, my lord, invoked here, my lord, Article 338(5)(b). My lord, the rest, my lord, are, my lord, not, my lord, really relevant. Then kindly see 8. The Commission shall, while investigating any matter referred to in subclause A, which is not applicable, or inquiring into any complaint referred to in subclause B of clause 5, have all the powers of a civil court trying a suit, and in particular in respect of the following matters. My lord, summoning and enforcing attendance from any and examining him in oath, requiring discovery, receiving evidence or requisitioning any public record, issuing commission for examination of witness, any other matter which the press. My lord, this is, my lord, the position. Now, my lord, kindly see what happens. My lord, while the disciplinary proceedings, my lord, are pending, my lord, first I want to show your lordship, my lord, what the disciplinary proceeding was, and, my lord, there is an admission on the part of the respondent number 3 of, my lord, acting, my lord, in, my lord, derogation of the rules. Kindly, my lord, take, my lord, page 95 of the writ petition.
Yes.
This was, my lord, the show cause notice,
Yes.
my lord, which was, my lord, issued, my lord, 21st of October 2022.
Yes.
My lord, kindly take penultimate paragraph. Whereas on consideration of the written statement of defense submitted by so-and-so, report submitted by the inquiring authority and records of the case, governor is of the opinion is guilty of charges and that penalty of dismissal be inflicted on the charged officer under so-and-so. Now, therefore, in pursuance of Rule 10(12), the governor is pleased hereby to call upon Dr. Sajal বিশ্বাস to submit within 10 days from date of receipt by him representation as he may wish to make on the penalty proposed, but only on the basis of evidence adduced during the inquiry. Copy of the report. So, my lord, this show cause notice is given. Now, kindly come to the reply, my lord, of 22nd November 2022 at, my lord, page 97. My lord, kindly come straight away to page 102.
Yes.
My lord, last paragraph. 102, last paragraph.
Yes.
I say that it was my first grave offense which I have committed, but considering the situation and mental state of mind
of mine and my service record, some other punishment may be imposed apart from dismissal or removal, and prays for imposing any other punishment apart from dismissal or removal. So, my lord,
What is the charge?
my lord, charge was, my lord, that he, my lord, abandoned, my lord, his duties. My lord, second, my lord, he went, my lord, and contested, my lord, an election while being a government servant, my lord, which is not permissible.
Very well.
Now, my lord, these were, now he says, first grave offense. And instead of dismissal, you please think of another punishment. This is, my lord, on 22nd November, and my lord, 5th of April, my lord, was, my lord, the dismissal order, which is at page 154.
22nd November 2022.
2022. And my lord, that's the reply.
Yes.
And my lord, the order of dismissal, my lord, is on 5th of April, 2023, which is at page 154.
Yes.
My lord, it's, my lord, after considering, my lord, whatever steps, my lord, the administrative tribunal, my lord, can, my lord, deal with this. So this was, my lord, the background. Now, my lord, kindly have a look at his complaint, my lord, which is, my lord, on 5th of July, 2022 to the commission. Kindly take, my lord, page, my lord, 103.
So the complaint was made while the disciplinary proceedings were going on.
Correct. I want to show your lordship that. And what the complaint said. Kindly come, my lord, to, my lord, 12 September 2022, my lord. My lord, this is, my lord, the National Commission, my lord, writing to, my lord, the Senior Special Secretary of the Health Department. Subject, kindly see, representation of Dr. Shojol Bishwas, Block Medical Officer of Health, Joshodanga Rural Hospital, Alipurduar, West Bengal, regarding injustice in service. Whereas a complaint information has been received by the National Commission for Scheduled Caste dated 5th July. Kindly note the date, 5th July, as enclosed, and the commission has decided to investigate, inquire into the matter in persons of powers conferred upon it, and so and so. You are hereby requested to submit the facts and information on action taken on allegation within 7 days of receipt, either by post or in. Please take notice that in case the commission does not receive reply from you within stipulated time, commission may exercise the powers of civil courts conferred on it under Article 338 and issue summons for your appearance in person or by a representative before the commission. Now, my lord, what is very important is this complaint, my lord, of at page 104. Kindly have a look, my lord, and my lord, are specific cases, my lord, that this complaint, my lord, does not, my lord, relate to, my lord, deprivation of rights and safeguards of scheduled caste. Kindly see. Respected sir, my lord, this is the only complaint. Respected sir, I, Dr. Shojol Bishwas, Block Medical Officer of Health, now officially posted at so-and-so Alipurduar, I am suffered a lot due to injustice from government machinery from 27 January 2021 till date, as I was participated in West Bengal legislative election 2021 with all due formalities and maintaining all legal perspective of service rules as well as constitutional provision. After this fact, till I am suffered a lot, as I am a responsible citizen of India with due respect to constitution, and I'm waiting for the law of the land. Also for your kind information, I belong to Namashudra community, which belongs to a subcaste of Motua community, but all my effort is not successful till date. No case, my lord, kindly note, of being deprived of rights and safeguards of scheduled caste. Then, my lord, so I'm requesting you to intervene in this matter on the ground of humanity, as well as deprived Motua member of the committee. And my lord, his case is that I followed all service rules, still this is happening to me. That is basically, my lord, there is no, my lord, complaint regarding deprivation of rights and safeguards, my lord, of scheduled caste. Now, my lord.
So, Mr. Mukherjee, the state of West Bengal is a petitioner.
Yes.
Yes.
Now, my lord, that's, my lord. And, my lord, now what happens, my lord, we respond. Then, my lord, one hearing we don't get to. My lord, that we are given another opportunity.
No,
we come.
we as in who?
The state, my lord. The state. Yes.
Yes.
The secretary, my lord. Then, my lord, kindly come to the order. 3rd February 2023, page 150.
That is under challenge.
Yes. My lord, the initiation as well as this order, my lord. Kindly, my lord, see, 9th February, we have, my lord, communicated, my lord, the order, my lord, of, my lord, the, which is, my lord, the minutes of 3rd of February, 2023.
Yes.
My lord, subject, kindly see, representation of Dr. Sajol Bishwas, Block Medical Officer of Health, Joshodanga Rural Hospital, Alipurduar, West Bengal, regarding injustice in service. Sir, please refer to the subject mentioned above and find enclosed herewith minutes of the hearing held on 3rd February 2023 in the chamber of the Honorable Vice Chairman, National Commission of Scheduled Castes, Headquarters, New Delhi. Action taken report on recommendations of the commission may be sent within stipulated time. Now, what is important is the use of the expression action taken report. Now, my lord, last sentence. Now, my lord, your lordships, my lord, are aware that the law is, my lord, the National Commission has no right to adjudicate. Number one, it has no right to pass interim orders. It can only make recommendations. So, my lord, in the first line, it says, these are our recommendations, but ask for an action taken report. Now, my lord, kindly come to page 151. This is the order which we have received in incomplete form. My lord, kindly turn over. My lord, I'll just show your lordship the operative portion. Para 5. My lord, at page 152.
This is the 3rd February minute.
Correct. My lord, which is, my lord, being forwarded.
Yes.
My lord, incomplete minutes, my lord, have been given, but my lord, the operative portion is here.
Yes.
My lord, kindly see para 5.
Yes.
In view of above mentioned facts, the National Commission for Scheduled Castes is recommending that Dr. Sajol Bishwas may immediately be allowed to join his duty and salary may be paid to him with effect from 23rd June 2021. On next scheduled hearing, the concerned competent authority of the department may appear before the commission. Then, my lord, para 6. The action taken report in the above matter may please be submitted before the commission within 15 days from date of signature.
So basically, this is a kind of a compliance.
Correct. My lord, therefore, my lord, the grievance and the courts have construed such language that a recommendation, my lord, coupled with, my lord, an action taken report order, my lord, is, my lord, a direction, is an interim order or a final order, which, my lord, they have, my lord, the National Commission has no jurisdiction, my lord, to, my lord, pass. Now, my lord, yeah, and my lord, para 4, my lord, of that very minutes, your lordship will find, my lord, that they go into a service dispute. Kindly see, my lord.
Which page was that?
My lord, 152. My lord, just above, my lord, that paragraph. For the petitioner had filed away before West Bengal Administrative so-and-so in the video letter had directed so-and-so to consider application of withdrawal sympathetically to be within 8 weeks of download after giving an on very made clear that if allowed to rejoin, he shall have to join at Alipurduar. That is it. So, my lord, there's no question now of, my lord, the state, my lord, considering direction is you please now, it's clearly, my lord, on the face of it, my lord, service dispute. And, my lord, we have, my lord, in response to this, my lord, then they write, my lord, kindly see 153, page 153. My lord, they write, my lord, I'm directed to refer to the commission's letter of even number dated 9 February. The requisite report in this case is still awaited from your end. It is therefore requested to expedite the matter and send the reply present status of this case to the commission within 7 days from date of receipt for placing the same for appraisal of the commission. So they're insisting, my lord, on, my lord, compliance, my lord, of that direction. My lord, we write back, my lord, page 157, 11th of April, 2023.
Yes.
My lord, kindly see, my lord, subject is action taken report so-and-so. In connection with reference and subject matter stated above, in respect of representation of Dr. Sajal Bishwas, Block Medical Officer of Health, so-and-so, and a recommendation, Governor has been pleased to pass an order that penalty of dismissal be imposed upon so-and-so. Then, my lord, last para, I would humbly submit that considering the approval of competent authority, including Public Service Commission, my lord, has my lord approved this as well for dismissal, so there is no scope to accede to the recommendation. My lord, it should, my lord, have ended there. Then, my lord, immediately, my lord, we start getting news, my lord, breaking news, my lord, in my lord, TV channels. My lord, kindly see, my lord, page 158.
This is about the complainant.
Yes, my lord, it's about, my lord, yes, saying, my lord, Shasto Jeep ke Griftari Parwana Patache National Commission for SC. My lord, that is, my lord, provided, my lord, here.
Yes.
My lord, what, my lord, the complainant, my lord, did, and my lord, this threat, my lord, is, my lord, breaking news. So, my lord, we thought, my lord, there's, my lord, nothing here. My lord, my lord, was, if they were only treating it as an order, my lord, could, my lord, this threat, my lord, be, my lord, have been leaked, my lord, to the press. Now, my lord, the law here is very simple. My lord, identical situation. My lord, I'll cite one, my lord, Delhi High Court. My lord, one, my lord, Calcutta High Court. And, my lord, one Supreme Court.
On which point, Mr. Mukherjee, that
My lord,
recommendation plus action taken
correct.
report
My
is
lord, is a
interim order.
direction, which is, my lord, absolutely illegal.
Yes.
And, my lord, copy to. And, my lord, my learned friend, my lord, also, my lord, asked me to, my lord, point out. Arun Haldarta kothay gelo? Kon page? My lord, kindly just take 164, my lord. 164, my lord. My lord, the person who had issued, my lord, the order, my lord, on behalf of the National Commission, my lord, he is being quoted. মেদিনীপুর কেন্দ্রীয় সংশোধনাগারের পরিদর্শনে এসে মন্তব্য কমিশনের ভাইস চেয়ারম্যান অরুণ হালদারের, my lord, his, my lord, কমিশনের পাঠানো সমনকেও অবহেলা করেছেন স্বাস্থ্যজীব মন্তব্য স্বাস্থ্য সচিব মন্তব্য কমিশনের ভাইস চেয়ারম্যানের. My lord, this is, my lord, provided here. Yes. Now, my lord, kindly have a look at. My lord, kindly, my lord, take the order once, my lord, the Delhi High Court order, 26 March 2019. Petitioner has filed the present petition impugning the decision of the National Commission for Scheduled Caste dated 21st April 2016, whereby NSCS has recommended that rosters of Maharaja so-and-so should be recasted as per Delhi University EC Executive Committee resolution dated 28th September, and the petitioner should be allowed to rejoin as assistant professor as per ADA. NSC has further directed that the action taken report be submitted to it within a period of 30 days. So recommendation coupled with, my lord, action take. Petitioner number 1 is one of the constituent colleges of University of Delhi. Respondent number 1, who is a complainant before NSC, was appointed as a junior assistant cum typist in petitioner number 1, college on so-and-so. Petitioner was thereafter appointed to the subsequently, was etc. Now, my lord, kindly come to para 5. My lord, what the respond number 1, aggrieved by decision, change, file representations, etc. Now, kindly see 6. This is, my lord, very, very important. 6 and 7. The jurisdiction of NSC is limited and is circumscribed by the provisions of Article 338 of the Constitution of India. The duties of the Commission are specified in sub-article 5 of Article 338 of the Constitution. Said article is set out below. My lord, it's, my lord, the very same article, my lord, sub-article which I placed. Then 7, the controversy involved in the cases ex facie a service matter. It is now a settled position that NCSC does not have the jurisdiction to adjudicate service matters. The Supreme Court in All India, Indian Overseas Bank so-and-so, reported in so-and-so, had examined the powers of NSC and held that although the NSC has certain powers of a court, it was not a court and thus would not adjudicate disputes. The said view was also followed by coordinate benches of this court in so-and-so. This court has also considered the powers of the National Commission for Scheduled Tribes under 338A of Constitution, which is similarly worded. Then para 8, the Learned Counsel for NCSC submits that the impugned order is only a recommendation and is not an order. The said contention is unpersuasive, as the plain reading of the operative part of the impugned order indicates that the petitioner has been called upon to submit an action taken report. Clearly, NCSC is insisting on the implementation of its recommendations. Even otherwise, the tenor of the impugned order clearly indicates that it is an order. Although couched as a recommendation, it is in substance an order. In view of the above, the impugned order is set aside and present petition is disposed of. Pending, it is however clarified, would not preclude respondent number 1, that's my lord the complainant, from availing his remedies before an appropriate forum. My lord, whatever remedies before the administrative tribunal. Now, my lord, kindly take, my lord, another order, my lord, which was passed, my lord, by the Calcutta High Court. Eight. Sorry. Naturally, unreported.
Yes.
My lord, kindly see, my lord, page 3 of the order, my lord.
Yes.
The factual conspectors of the matter.
Yes.
My lord, the second paragraph of the matter before the court makes it clear that the disciplinary proceeding initiated by the petitioners against respondent number 3 has no nexus with any of the provisions of so-and-so. There is nothing in the facts to suggest that respondent number 3 has been singled out for the disciplinary proceeding by reason of respondent number 3 being a member of SC/ST community. My lord, this is what is, my lord, at the heart of, my lord, 338B, deprivation of rights and safeguards. Moreover, impugned communication is also against Rule 7.41 of notification dated 25th March 2009, issued by the Commission itself, under which the Commission is precluded from taking action in any matters which are either sub judice or relate to cases pending in courts. I have that, my lord. I'll, my lord, show that as well. Further, the writ against the charge sheet is under challenge. Respondent number 3 through counsel is, my lord, I'm not. Then, my lord, kindly take the next paragraph, my lord, lower half of page 4. The impugned communication issued by the National Commission for Scheduled Castes hence lacks the constitutional or statutory basis which would justify the threat contained in the communication. Court is inclined to stay the operate, so and so. Now, my lord, Supreme Court, my lord, just one judgment, my lord, 1996, 6 Supreme Court cases, 606.
This is the one referred to in the Delhi High Court order? Or is this
My lord,
separate?
no, this is not the one. That's another one.
Very good.
My lord, I'm not, my lord, troubling your lordship. My lord. No, this is the one. I'm sorry, my lord. This is the one.
Yes.
There's another one I have, but I'm not, my lord.
Yes.
My lord, this is, my lord, the order is at para 2. My lord, there was a direction, my lord, in, my lord, this communication. Your lordship will find that at page 607. My lord, the letter is set out. Kindly take the penultimate paragraph of the letter. In view of the prima facie examination of the matter and considering the fact that the bank is reportedly going ahead with the promotion process, Commission and exercise of the powers conferred upon it under Section 2 of so-and-so Amendment Act 90 directs the bank to stop promotion process pending further and final verdict, so-and-so. Then, my lord, kindly, so here it was, my lord, interdicting, my lord, the promotion process. My lord, para 3, my lord, 608.
Yes.
The short question that arises for consideration in this matter is whether the commission had the power to issue a direction in the nature of an interim injunction. My lord, this is the issue. Now, my lord, 338, my lord, is set out. Then, my lord, kindly come to para 6. Subclauses A to F. Lordships have that, my lord?
Yes.
Of clause 8 clearly indicate the area in which the commission may use the powers of a civil court. The commission has the power to summon and enforce attendance of any person from any part of India and examine him on oath. It can require the discovery and possession or discovery and production of documents, so on and so forth. All these powers are essential to facilitate an investigation or an inquiry. Such powers do not convert the commission into a civil court. Now, kindly see what is meant by this. Kindly take para 5. It can be seen, that very page, it can be seen from a plain reading of clause 8 that commission has the power of the civil court for the purposes of, my lord, what is referred to. That's, my lord, the language. But it doesn't become a civil court. Then, my lord, kindly come to, my lord, paragraph, my lord, 10. Paragraph 10.
Yes.
Interestingly, here in clause 8 of Article 338, the words used are, the commission shall have all the powers of the civil court trying a suit. But the words, all the powers of a civil court have to be exercised while investigating any matter referred to in subclause A or inquiring into powers of a civil court are given to the or any complaint referred to in subclause B of clause 5. All the procedural powers.
Sorry, so Mr. Mukherjee, so 338A presumes jurisdiction.
338?
338(8)
Yeah.
presumes jurisdiction.
Correct. And my lord, your lordship is absolutely right.
Yes.
And my lord, it's applicable for a situation of A or B.
Yes.
Here it's not A. If it is B, my lord, it has to, my lord, relate to, my lord, the safeguards, my lord, which is completely absent, my lord, in the complaint.
Yes.
Secondly, in respect of a service matter, my lord, where, my lord, the matter is already, my lord, before the courts, my lord, service matter, it doesn't have jurisdiction. It cannot pass, my lord, an injunction. Your lordship will find granting injunction to do not inhere in the commission. That's, my lord, paragraph 10. My lord, here, my lord, if that recommendation is actually a direction, it's an injunction. It's a mandatory injunction. It's a direction, my lord, which they cannot pass. And they have no power to adjudicate, it being, my lord, a service matter. And, my lord, now, my lord, your lordship will find para 11, my lord, last 3 lines I want to just place. The order itself being bad for want of jurisdiction, all other questions raised in the appeal are redundant, justifying it. And, my lord, my specific cases, proceeding without jurisdiction, order without jurisdiction. My lord, this, my lord, with the greatest of respect, my lord, has to, my lord, go. That's, my lord, the submission, my lord.
So if the basis is not there, then the superstructure also collapses.
Entire thing, my lord.
Yes. Yes, Mr.
My lord, may I seek one indulgence, my lord? My learned juniors here, may I, my lord?
Yes. Yes, Mr. Bhattacharya, you're for the commission.
My lord. No, my lord, a lot has been said, my lord, regarding the role of the commission. Now, what has not been said, what has not been stated is that the essence of the writ application are screenshots of an electronic media.
Television.
Yes, covering certain news, which admittedly till date, my lord, there is no such warrant of arrest which has been issued, my lord. Now, what has
No,
not
the screenshots say that this the principal secretary will be arrested. That's what
that is
I haven't looked at the case.
states that স্বাস্থ্য সচিবকে গ্রেফতারি পরোয়ানা পাঠাচ্ছে ন্যাশনাল কমিশন।
Shastujib. Yes.
Excuse my learned advocate.
Yes.
I was asking the learned government pleader that why are you
It's always a beginning.
why are you luring the learned advocate general to read Bengali?
Yes.
So, my lord, this was not, my lord, indicated in its entirety, my lord. Now,
Yes.
thereafter, what has not been indicated is that, my lord, during the entire proceeding, which is pending before which is ongoing before the commission, now there was participation as regards the petitioner's hearing. At no point of time, the question of jurisdiction was raised. What has not been stated is that, my lord, accommodation or exemption of personal appearance on a particular day was sought for, or for a particular period was sought for by the petitioner's herein, citing Poush Mela, Gangasagar Mela, Christmas, leading the commission to believe that on a subsequent day, there will
So
be
you're saying
appearance.
participation?
Yes. So these
Participation
were
in the
not
proceedings.
indicated. Yes.
Yes.
My lord, a lot has been said, my lord, regarding the commission not having powers to go into service matters. If my lord kindly takes the language of Article 338A, ওটা কোথায় গেল? 338A, হ্যাঁ। কই গো? Yes, my lord kindly takes the powers of the commission.
Yes.
338(5)A.
Yes.
Power is, my lord, to investigate and monitor all matters relating to safeguards provided for the scheduled castes under this constitution or under any law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. Now, my lord, all is an all-encompassing, my lord, subject, my lord. Service cannot be singled out, my lord. Now, my lord, the rules of procedure pertaining to the commission, my lord, the functioning of the commission. Now, that also specifically covers issues pertaining to employment and service. Now, those rules, the wideys of the rules are not under challenge, my lord. I have a copy of the rules for your lordship, my lord. May I hand over, my lord? আমি পড়ে দিয়ে দিচ্ছি, আমার কাছে এক কপি আছে।
Yes.
Now, the constitutional provisions are set out, my lord, in the first page, my lord, that is 338(5)A, as I was indicating, my lord.
Yes.
Now, thereafter, if my lord kindly takes pen to come to
Yes.
page 30, my lord, it's at the bottom, the pagination is done at the bottom.
Yes. Yes. I've seen it.
Yes. Now, this is
Yes.
clause 7.2A by Roman 8,
Yes.
where the property, comma, service, employment of scheduled castes and other related matters are under immediate threat and prompt attention of the commission is required. The matter shall be taken cognizance by issue of telex fax to the concerned authority for making it known to them that the commission is seized of the issue, and the authority will be prohibited to take any action.
This is page 30.
But page 30, yes, page 30.
30, which one are you?
7.2, but the second last
Seven.
clause.
Seven.
Yes, 7.2A Roman 8. Roman 7, I'm sorry.
7. Yes.
Yes,
Yes.
yes. Where the property, service, employment of scheduled castes and other related matters are under immediate threat and prompt action of the commission is required. The matter shall be taken cognizance by issue of telex fax to the concerned authority for making it known to them that the commission is seized of the issue, and that authority will be prohibited to take any action till the completion of the inquiry in the matter by the NCSC. So, my lord, the rules of procedure, my lord, that also, my lord, categorically provide for, my lord, the commission causing inquiry into service matters. No, my lord, the facts, my lord, of the case will be also very germane.
Yes.
Now, the private respondent herein, he is, my lord, no doubt a member of the Nomoshudra community, which is a scheduled caste, my lord, which comes under the scheduled caste.
Yes.
Now, my lord kindly appreciates, my lord, the fact in which his case has been dealt with by the petitioners herein, being the state. I cannot say state respondent, state petitioner. Now, 5/1/2021, the resignation was put in by the private respondent while he was functioning as the block medical officer of health at Alipurduar. Now, 25th of January 2021, there was a show cause issued to him saying that why disciplinary action should not be initiated against him for unauthorized absence, because the resignation tendered by him was not tendered through proper channel, leading him to believe that if it is tendered through proper channel, it will be accepted. Now, on receipt of that, on 27th of January 2021, he submits a fresh resignation through proper channel.
Yes.
Now, upon receipt of that fresh resignation application through proper channel, on 30th of January 2021, he receives another reminder regarding now the show cause issue. Now, again on 11th of February 2021 and 26th of February 2021, now the state petitioners asked the private respondent in writing to join his duties. Thereafter, on the 25th of March 2021, a clarification is sought for from the private respondent regarding his absence.
Yes.
He replies to the show cause notice on the 2nd of June 2021. And on 4th of June 2021, he intimates that he had contested the 2021 assembly elections. Now, thereafter, my lord, it led to, he challenged the show cause notice, he went to the Central Administrative Tribunal, departmental proceedings were initiated. But my lord, if my lord kindly takes the inception, the conduct of the employers, leading him to believe first that if the resignation is submitted through proper channel, that will be accepted. Upon receipt thereof, he was asked to join his duties.
Sir Bhattacharya, the disciplinary proceedings are not under challenge here, I believe. Is that under
No,
challenge?
I'll come to that one. No, disciplinary proceedings are not under challenge.
Whether what the employers did and all that is not
That
under
is not
challenge.
under challenge. Ideally and essentially, but submissions should have been confined only to the proceedings of the commission. A lot has been pleaded, my lord, regarding the disciplinary inquiry, what happened.
I
thereafter.
will disregard it.
Yes.
In
Grateful,
whatever
Your
order I pass, whatever disciplinary proceedings I will have to. I will only confine myself to the
Yes.
commission. That's
As
all.
it had fallen from your lordship that the commission on the other day, my lord, when my lord was hearing, that very well I'll permit the commission to look into the question of discrimination. So far as service jurisprudence is concerned, the disciplinary proceeding is concerned, the court will be interfering. That had fallen from your lordship. Now
I don't remember. What did I say?
My lord had said that when I said that it is the aspect of discrimination that is being inquired into by the commission. Discrimination apropos the private respondent who is a member of the scheduled caste community. So it had fallen from your lordship that very well I'll stay the recommendation, but I'll permit the commission to continue with their inquiry insofar as the question of discrimination is concerned. So,
Mr. Bhattacharya, you don't have to be distracted. Yes.
Now then I am now trying to persuade your lordship, my lord, to show, my lord, that this particular recommendation has got nothing to do with the, my lord, service matters, my lord, which have been contested by and between, my lord, the private respondent and the state. That is my endeavor, my lord. So, my lord, having said that, my lord, the inception, my lord, as it happened, as the private respondent was, my lord, led to believe. Now, thereafter, my lord, we receive, my lord, the commission receives a complaint on the 5th of July 2022 from the private respondent. 12th of September, my lord, the petitioners are made aware about the complaint before the commission. 21st of October, the state petitioners, they respond to the commission's notice. Now, a report was submitted on the 22nd of November 2022 by the petitioners. Page 108, my lord, will find the report.
Yes. Page 108.
108, my lord.
Yes.
This will be important. May I place it, my lord, with your lordship's kind leave?
Mr. Bhattacharya, just the relevant paragraph.
Yes.
Your point is one of participation.
My point is there is, my lord, kindly appreciate, there is an ongoing inquiry.
Yes.
There has been a participation in the inquiry, leading the commission to believe that on a particular day, there will be inconvenience, or during a particular period, there will be inconvenience. I'm keeping it very, very concise, my lord, my submissions.
Yes.
Thereafter, the commission again finding the petitioners not appearing, issues a summons. Now, in response to the summons, my lord, there is no appearance. On the contrary, my lord, a reply is filed to the summons. I have not heard, my lord, that if the civil courts, my lord, serve a summon, my lord, summons are replied to by way of a letter. Now, thereafter, again, my lord, the date is fixed, requiring the appearance of the petitioners. They do not appear. But thereafter, again, my lord, on the returnable date also, they do not appear. Our recommendation is made. And if my lord kindly takes the language of the recommendation, my lord can record my submission, my lord. The recommendation is, my lord, directory, my lord. It is not mandatory. And, my lord, what is more relevant, which has not been my lord, pointed out,
Yes.
but the recommendation preceded the order of dismissal, my lord, on which, my lord, the state has tried to, my lord, buttress their contention, they bolster their case,
Yes.
my
So
lord.
you're saying that the recommendation happened first and the dismissal happened afterwards?
Yes, the dismissal followed the recommendation.
Yes.
So, my lord, it's an ongoing inquiry. There are documents that we have also come across, my lord, regarding differential treatment given, my lord,
Yes.
to two, my lord, members, my lord, at par with the petitioner, my lord, who belong to the general caste, my lord. So, my lord, these are the questions, my lord, these are the queries, my lord, that has to be answered. And they choose not to appear. It is a commission, it is a constitutional body. They have powers of a civil court. They are led to believe that the petitioners are in some difficulty, there is some constraint preventing them from appearing personally during a particular period. Thereafter also they do not appear. A recommendation is there. The recommendation contains the word that recommending that Dr. Sajal Bishas may immediately be allowed to join his duty and salary may be paid to him with effect from 23/6/2021. So, but unless and until it's an
So
ongoing.
what is this about a warrant of arrest, which you mentioned,
I do
Mr.
not know, but the
Bhattacharya?
commission.
No,
is
you mentioned it, a warrant of arrest.
I said that their application is founded on an apprehension, which is again founded on the basis of screenshots from an electronic news channel. Let them appear. As I said, my lord, on the first day, my lord keeps this pending, my lord, let them appear. Let the honorable court, my lord, the constitutional court, my lord, ask for a report. What happened after their appearance? My lord may accept my submissions, my lord, this action taken report, but this particular recommendation, my lord, but this is interim in nature and this is not mandatory. Let the state petitioners go and satisfy the commission which is conducting an inquiry. Because the state said that the state petitioner said that we have a problem during this particular phase. My lord keeps it pending, makes it returnable, my lord, at any point of time, calls for a report. We'll also file a report, my lord. Let them satisfy regarding the documents that the commission has come across regarding, my lord, a differential treatment, my lord, meted out, my lord, to members of the general community, the general caste community. So these are the aspects, my lord, which the commission is looking into. And if they satisfy the commission that after the recommendation, there is this order of dismissal, which is as per the recommendation of the Public Service Commission. These are points to be satisfied in an ongoing proceeding, my lord. But let us assume, my lord, a suit is, my lord, pending before the civil court, my lord. There is some apprehension on the basis of some news, my lord, which pops up on the TV screen, my lord. No matter the defendant suddenly comes up by way of filing a 226 application. But completely taking a diametrically opposite stand, my lord, when there is also not a degree. But this is the situation, my lord. This is exactly the situation that is happening. As on date, my lord, there is no warrant of arrest. Summons were issued. There has been constant non-appearance, my lord. It cannot be denied, my lord. The commission is, my lord, a constitutional body, my lord, deriving its powers from the constitution insofar as the powers akin to that of a civil court is concerned. and summoning the and enforcing the attendance of witnesses are concerned. This is the minimum respect, my lord, that, my lord,
Very well, understood.
my lord, I'm grateful.
Mr. Ray, 2 minutes.
Yes, ma'am.
2 minutes.
Yes, madam.
Yes, yes, yes. 2 minutes for you too. Yes, you're the complainant.
That I would draw your lordship's kind attention to
Microphone.
that I would draw your lordship's kind attention to my complaint appearing at page 104.
Yes.
Your lordship, kindly have a look.
Yes.
That is the complaint.
Yes.
104.
Yes. You're the respond number 3.
3.
Yes.
Kindly, my lord, do not bother about the English language. Kindly see, my lord, this is later dated.
Microphone, please. Yes.
Yes, this is later dated 5th July 2022.
Yes.
Now, my lord, I, Dr. Fazul,
I have read this has been placed to me.
Yes.
What is your point?
Yes. Point is this, my lord, since I feel aggrieved by the harassment caused to me by the authorities, therefore I was compelled to lodge this complaint before the commission, since I belong to the community, a particular community. Now, my lord, the commission started inquiry within the purview of the constitutional provision. The learned Advocate General was saying that adjudication. Commission is never adjudicating the service matter. But I am not bothered about the dismissal or anything else. I shall take recourse to law, which is provided.
So you couldn't have been bothered on the date of the
No,
complaint because the dismissal happened later.
No. Yes.
Yes.
Certainly. It is dismissal is not just a month back. Dismissal order has been issued a month back.
Very well. Continue, please.
Now,
Yes.
now thing is this, not the commission was looking into my complaint, started the inquiry. The concerned authority was directed to appear and not express their views. They never appeared. Now, my lord, I would just my lord, show certain pages. I am not reading. For your lordship's kind note.
Just give me your
Yes,
submissions. That's
Yes,
all.
Lord,
Yes.
107, the minutes of the
Yes.
commission, 107, 109, 137, 141, 143, 151, and 153.
What is the point?
Point is this, Lord, the petitioner was on several occasions were asked to appear and express their view, express their comment. That is within the purview of the constitutional power given to the commission. They never. They simply
Very well. They
avoid.
never appeared. Next
Yes,
point.
They simply avoid it.
Yes.
Therefore, where is the illegality committed by the commission? To start an inquiry to safeguard and protect the interest of the particular community.
Very well.
The
Understood.
commission is very much powerful.
Next point.
These are all not. I
Very
am
well.
not.
Mr. Ray, 2 minutes. Yes.
And the commission has never adjudicated anything.
Very well. Yes.
But first, Malad, just the facts to be cleared, Malad, kindly comes to page 151, Malad.
Yes.
Minutes of hearing, Malad. 1. The matter has been listed for hearing. Malad, I'm not going to that. Second sentence. During the course of hearing, the respondent authorities and petitioner was present.
Yes.
So, Malad, we were present.
Yes.
So, Malad, this allegation, which has been continuously falling from my learned friends, it's an admitted position that I was present. Now, this is Goa. Now,
Yes.
Malad. Malad, next, Malad, kindly appreciate.
No,
Malad.
so what is the point, Mr. Ray?
Malad, they are saying that I was not present. So now what fell from the learned.
Next paragraph would be also relevant.
Yes.
Malad, what they are trying to say is, Malad, that this summons was issued. I did not appear. I believe the next corollary is that is why the warrant.
Yes.
Which we are being apprehending. Now the point is why a summons? For a hearing? Malad, hearing has been undertaken and Malad, an order has been passed. Recommendation or whatever it is. It has been passed. Now, where are we today before your lordship? We are before your lordship challenging the initiation of the proceeding itself. My learned already placed that.
Yes.
If the initiation is bad, anything else later than that is also redundant questions.
Yes.
I am saying the initiation is bad, and your lordship also takes 151, Malad, There also it is accepted, it's a service matter. That is the recording. But a list of dates, if your lordship kindly see page 151, the last sentence of the first paragraph subject.
Yes.
24th May 2020, caste-based harassment and discrimination service matter.
Yes.
So, my lord, this is one. I must also show your lordship that we have stated specifically that the commission does not have jurisdiction. My lord, kindly takes page 108. So to say that I have acceded to the jurisdiction, that is first one, this is not possible because this jurisdiction is void ab initio. It's beyond the scope of that constitutional powers, my lord. But kindly takes the last paragraph. This is essentially an issue of departmental proceedings on violation of service norms. That has been our contention at the very beginning. And that is what we have come up before your lordship for. Now, my lord, and my lord, in 104, my lord, your lordship has seen what the complaint was of my learned friend's client, well, the private respondent. Not he himself says that there has been a violation of the service rules.
Yes.
So where is this harassment and what is the harassment? And my lord, he has proceeded in that service matter. And my lord, kindly takes 152 only once, my lord. I'm very sorry, my lord. I might have taken 1 minute more, kindly, my lord.
Yes.
My lord, sees paragraph 4, my learned advocate general has shown it. But my lord, kindly takes the last sentence of paragraph 4. However, it is made clear that in the event if the applicant is allowed to rejoin his duties, he shall have to join at Alipurduar, that is at the transferring place of posting. But this was an order which has been quoted by the commission of the West Bengal Administrative Tribunal. Now, what does the commission do now? Commission says,
no, quoted by the administrative tribunal. Where does that
quoted
come?
by the commission.
Yes.
My lord, kindly, then my lord, kindly says 4.
Yes.
Further, the petitioner has filed an OA before the West Bengal Administrative Tribunal. Is lordship got that?
Yes, yes.
And then, my lord, Administrative Tribunal had directed to secretary. Then, my lord, sees to consider. Has the lordship got that?
Yes, yes, yes.
That is in inverted comma. That is the consideration order passed by the Administrative Tribunal.
Yes.
Which has ultimately culminated in the dismissal. But what was the commission holding? Commission held that since this order has been passed, now kindly takes 5. In view of the above mentioned facts, has the lordship got that?
Yes, yes.
The National Commission for Scheduled Caste is recommending that HON'BLE Bishas may immediately be allowed to join his duty. Contrary to the order of the West Bengal Administrative Tribunal, they are sitting appeal, and that is the order. That is where we are saying, Malad, they're sitting and they are assuming jurisdiction of the service matter. They are sitting in an appeal. Now, Malad, for last Malad, my learned friend, the learned DSG has shown Malad the rules. Malad,
Yes.
may I just only show that rules once, Malad? Malad, my learned friend has shown, Malad, paragraph 7.2 A7.
Yes.
Now, Malad, may I just first show, Malad, 7.2A.
Yes.
Malad, all these fall under that inquiry and investigation as Malad set out by the Honorable Supreme Court in the judgment, Malad. 7.2A1.
No, this is the language of 338.
Yes.
Yes.
So, Malad, it has to be within that. Malad, kindly sees. The commission may hold sitting for investigation to matters relating to safeguards, protection, welfare, and development of the scheduled caste. For inquiry and investigation. Now, Malad, pending this, Malad, because this lays down the procedure for investigation and inquiry. This rule is only for the procedure. Now, kindly comes to 7.2A.
Yes.
There it says, where the property, service, employment of the scheduled caste and other related matters are under immediate threat. So, Malad, if in a procedure where there is, Malad, where there is any problem.
Mr. Ray, I've understood all this.
So, Malad, in those cases, well, let's say it does not increase the.
And
jurisdiction of
why
the
did you take all these exemptions of personal appearance by all these holidays?
Malad, one
All
of
these
them,
festivals?
Malad, they went, Malad.
And he
And
did
after
not
that, I've
raise,
said that the certificate has not been received. That
did
is
not
also
raise the point of jurisdiction at any point of time.
I said so, my lord, it's a service departmental proceeding. I showed your lordship, my lord, in my letter. And my lord, that is in response to the first letter.
Very well. Yes.
So, my lord, only one thing, my lord, I am challenging the entire proceeding.
Yes.
My lord, those are my
The learned advocate general, comma, and the learned government pleader, comma, appearing for the petitioners, as well as the learned DSG appearing for the commission, and learned counsel appearing for the complainant / respondent number 3, have made their submissions with regard to the impugned. What have you challenged? Which one?
The
Which
entire
document?
proceeding and one of this order. My lord, kindly takes my prayer, my lord. Page 35, your lordship. I've challenged the proceedings bearing that file number, my lord. That is my prayer A. And my lord, I've sought for recalling of that order. And if there is any warrant of it.
No, which order? Just tell me, give me the page, please.
Oh, my lord. My lord, the order would be at
Page 150.
151.
With regard to the recommendations / minutes dated 3/2/2023 of the National Commission for Scheduled Castes, which was communicated to the petitioners on 9/2/2023. Stop. Next, list this matter on May 2023 under the heading for judgment.
And I hope, my lord, the learned DSG also, my lord, because we are threatened, my lord, if there is any apprehension, my lord, of any warrant of arrest, my lord.
Matter has been pending since quite some time. Since day one, I have been
If he
saying
says, my lord, I'm obviously, my lord, I'm okay with it.
my lord has never also recorded any interview.
No, I know that, my lord. So I'm just reminding him because it's not going to appear on the 19th, my lord, your lordship.
Yes. I'm sure if Mr. Bhattacharya has said that, then
I'm very grateful.
And I am very grateful, my lord, for the patient hearing, my lord, afforded by your lordship to all of us, my lord, in the last week before the vacations, my lord.
Very grateful, my lord. I should be more grateful because I'm for the petitioner.
thank you. Yes, call on the next matter, please.
Item number 8. 8 to 12.
Lordship, I am appealing for the respondent number 1.
Yes.
My lord, on the last occasion, petitioner produced the
Yes,
notes
yes.
of
There's
submission.
no further. I've dictated the order. Dictated the dictation. Yes. List this writ petition along with all connected writ petitions filed for similar relief tomorrow under the heading for judgment.
Item number 13.
My lord, I am appealing for the petition.
Mr. Bandyopadhyay, where is the affidavit of service?
Yes, ma'am. These are the
And did you mention the matter upon notice, Mr. Bandyopadhyay?
yesterday, yes, I mentioned.
No. Did you mention it upon
Initially,
notice?
yes.
Yesterday, when you mentioned it,
Yes,
did you
yes,
mention
yes,
it upon
yes,
notice?
my lord. I have given the notice itself to the court officer. I handed over it.
Who is the answering respondent?
The answering respondent is the railway, my lord. That's a respondent number 4, senior divisional commercial manager.
All of them served?
My lord, all everyone has been served.
Yes,
Milord,
who is
this
the answering,
Milord, I tell-
answering respondent, respond number?
Milord, ask the respondent number 4, Milord.
4.
4, yes.
And what is the relief you are praying for?
Milord, I am praying, Milord, kindly, say, Milord, a tender, just as in very short, Milord, tender was invited.
You
I
want to participate in the
participated.
tender?
And all, Milord, in the technical bid, Milord, I have been, my case has been rejected. Kindly come to page 165. No reason is there.
No, but what are the dates for the tender?
Tender date is, my lord, tender was 6 January 2020, NEET floated. 2nd February 2023, my lord.
No, this is a communication of 24th April.
24, this is 24th April. 25th April 2023.
Mr. Bandyopadhyay, I have passed a similar order disqualified in packet A.
Yes.
Similar order this week only.
Lord,
I will give you the name.
the order
I appeared on behalf of the railway. My lord has been pleased to discuss the
Yes,
applications.
yes, Mr. Bandyopadhyay, you have to consider it and come back.
My lord, can I have the order? Yes, my lord. Day after tomorrow.
Consider it and come back. Yes, because I've dismissed identical. I forget who was appearing for the petitioner.
Mr. Subhankar Nag was appearing on behalf of the petitioner. Mr. Ranjan Bachawat was the
No,
private
railways, Miss somebody
I
else.
appear, my lord, I
You
appeared on
appeared for the
behalf-
railways. You're not appearing in this matter?
No.
Very well. Please give him the citation. Yes. The petitioner is aggrieved. The petitioners are aggrieved by a rejection communicated to the petitioners on 24/4/2023 that the techno-commercial bid against a tender floated by the Southeastern Railways was rejected. Stop. Learned counsel appearing for the petitioner submits that the rejection is without any reasons. Stop. Next, upon considering the impugned communication, counsel appearing for the petitioners is requested to consider a recent judgment passed by this court in identical facts. Stop. List this matter, Mr. Bandyopadhyay.
Tomorrow, if let's.
And Mr. Bandyopadhyay, I'm
WPA 10716.
In WPA 10716 of 2023. Mr. Bandyopadhyay, let me do this. No litigant should suffer because of an order passed by a particular court. If you want, I can release this matter.
No.
No, Mr. Bandyopadhyay, I have to be fair to the litigant. Just because I have passed an order on similar facts.
May I tell you, my lord, lordships have passed the order. I will consider, my lord, I will look into that. And I am having that trust on every court.
No.
My lord, I just tell you, just
Mr.
let me allow me to finish it. Just allow me to finish it. If I will try to pursue your lordships with my arguments if I have anything. And I am sure, my lord, if your lordships have delivered a judgment, even if your lordship is persuaded by the other reasons which are in accordance with law, then your lordships may pass a new order. My lord, it has happened. It has happened, my lord, very recently. It has happened in this High Court, my lord.
Because that judgment, now it comes back to me. I have construed this packet A, whether it's an essential condition, etc., all of that. That is why I'm telling you, if you want, I can release the matter.
No. Very core reason. Your lordships have gone into the very core things into the matter. And there's no dispute. I am not that, my lord. I have a completely different experience, my lord. Your lordship may be persuaded by me, my lord, or by legal argument. And if your lordship is persuaded by giving an argument, your lordships may differ from your lordship's reason.
But you take a chance because
no, why try? I am not a forum chooser, my lord. I don't do this.
No, you can't forum shop because it
Hello.
will be assigned to a particular
No,
court.
that's right. My lord, it's not that since a one court has against me only one view, and I don't believe, my lord, it has happened very recently in 3 courts. I am telling to a lot, before Justice Mantaj, before Justice Kaushik Chandra, and before Justice Division Bench Orijit Banerjee, my lord. They delivered judgment against my clients, and Justice Mantha said, read the judgment, come tomorrow. I completely different. Justice Kaushik Chandra dismissed 8 writ petitions. Mr. Vikas Bhattacharya argued, Mr. Soma Majumdar argued. In 9th petition, in my petition, Justice.
So that's a
I
comment.
believe in that.
So
If
that's
I
a
can
comment
pursue-
on yourself or on the courts?
Pardon? Pardon, my lord?
That's a comment on yourself or on the courts?
No. If the court is persuaded, why the court will not change its order? Court may change. I may be wrong.
Very well. I wanted to give you that chance.
No. That will not, no, that is not very palatable to me, my lord,
When
at
do
this
you want to
stage.
come back, Mr.
At this
Bandhavati?
stage, after completion of 42 years practice, my lord.
When do you want to come back, Mr. Bandhavati?
Tomorrow.
Please, this matter tomorrow. Mr. Please.
Yes, Lord, he has
please
sent it,
go ahead.
Baba.
Yes.
Why he says
Yes,
by
and,
WhatsApp?
thank you. Thank you for the
Keep love life.
reference. Yes.
Well, let it retain its position. Well, can I?
Yes, it will retain its position. Yes. Call on the next matter, please.
Item number 14.
But I beg to appear under this statement.
Microphone.
Yes, my lord, I appear under the petition. My lord, the issue before your lordship, my lord, we have participated in the tender floated by the competent authority. Thereafter, we have become successful. We have been issued the work order. Pursuant to that, my lord, we have executed the entire work. Thereafter, we have raised the bill before the competent authority, that is West Bengal Agro Industries. They have physically verified. Thereafter, they have raised the bill before the state authorities to disburse the bill. Till today, it has not been disbursed. In a similar circumstances, my lord has already passed an order. If your lordship.
No, where, who is the respondent who is supposed to pay you?
Respondent number 6 and 7. And my lord, in a similar circumstances, my lord has passed an order, my lord, on.
My lord, respondent number 2 is the disbursing, releasing authority.
Respondent number 2 will release the fund to the respondent number 6 and 7. Thereafter, they will. That is at page 62. My lord has passed the order, my lord, in similar identical issue.
My lord, if your lordship kindly takes the date, my lord, if your lordship kindly comes to page 42, this is the work order issued, my lord. And my lord, work order issued on, my lord.
Page 42.
Page 42, my lord.
Yes.
My lord, work order issued on, my lord, 6th December 2019, and time allowed 90 days.
Yes. Yes.
Thereafter, your lordship kindly takes, my lord, annexure P4, that is page 44.
Where are you getting the date of the work order?
Lord, at the top.
At the
6
top,
December. Yes.
6
that is
December 2019. They
Yes.
are supposed to finish the work on, my lord, 6th February, my lord, 2020. But, my lord, your lordship kindly takes annexure P4.
Yes.
My lord, completion, my lord, first, second,
Give
third,
me the
fourth.
page, please, Mr. Mitro.
Page 44, my lord.
Yes.
My lord,
Yes.
has your lordship got it, my lord?
Yes.
Completion, my lord, 24th January 2023.
Where are you getting that?
My lord, annexure P4, first, second, third, fourth, fifth column, my lord.
Yes.
And my lord, my lord, bill have been raised, my lord, on, my lord. Your lordship kindly takes annexure P5, page 54. My lord, in the meantime, they have not sought for any extension of time, my lord, to complete the job, my lord. Page 54.
Yes. What is the interim order you want, Mr. Banerjee?
Lord, I am not paying any interim order. My lord, we have already completed, and my lord, learned friend is showing that the document that has been furnished by the West Bengal Agro
Very
Industries.
well. So what is the amount you want now?
My lord,
There is nothing indicated in the prayer.
My lord, here, my lord, I am entitled, my lord, 22 lakhs, my lord.
Yes, but the prayers don't say that.
Yes, my lord, according to the, my lord, the calculation, my lord, that is that the page, my lord, I have annexed, my lord, that is that the page, my lord, 54, if your lordship kindly sees. page 54 at the top, serial number 1 and 2. Bill value. That is I am entitled. I have executed within time. Thereafter, my lord, West Bengal Agro Industries, they have raised the bill in the year 2023 and ultimately it has been furnished.
Work
Due
completed.
to their work completion certificate, already it has been completed much prior to that.
Very well. What do you want to do, Mr. Mitra?
My lord, they have, my lord, sent a representation, made a representation at page 58, my lord, and prayed for, my lord, admissible amount.
Yes, that is, my lord, admission.
59.
Yes.
Admissible amount. And my lord, your lordship kindly takes page 61. My lord, we have already asked for, my lord, fund. To the, my lord, written communication has been made to, my lord, the respondent number 2 for releasing the fund, my lord.
Additional district magistrate, that is respondent number 6.
Penultimate paragraph, your lordship kindly takes page 61.
Yes. The petitioner
Right.
claims to have completed the work given to the petitioner for completion in terms of work orders issued in
2019.
2019. Stop. The petitioner raised bills. Part payment or not?
No, full payment has to be done.
The petitioner raised bills in terms of the work done to the
West Bengal Agro Industries.
West Bengal
Agro Industries Corporation Limited.
West Bengal Agro Industries Corporation Limited, comma, one of the respondents before the court, comma, but the petitioner's demands for payment were not acted upon. Stop.
My lord, according to what tender, I have to, page 24, my lord, we have to pay back to back basis. Since we did not
The
get the
petitioner
amount,
has not paid, the petitioner has not been paid any amount till date. Stop. Next, according to learned counsel appearing for the state authorities, as well as the respondent numbers
For 4.
Respondent as well as the additional district magistrates including the additional district magistrate, comma, the arrangement appears to be according to a comma, the said respondents were to pay the petitioner only upon receiving funds from the West Bengal Agro Industries. Stop. Is that correct?
No, my lord.
I can't understand. Speak, please speak clearly into the
my
microphone.
lord, West Bengal Agro Industries Corporation to receive the amount from the authority, ordering authority.
That is, my lord,
respondent number.
Which is your ordering authority?
my lord, additional secretary to the government of West Bengal backward
According to
classes
learned
welfare
counsel
department.
appearing for the respondents, Bakira Kedala, comma, the arrangement was that the petitioner, the arrangement was that the West Bengal Agro Industries would pay the petitioner only upon receiving funds from the additional secretary, comma, Department of Tribal Development.
Lordship.
Stop. Next. The petitioner also made a representation before the authorities on 11/4/2023, before several authorities on 11/4/2023 for release of the admitted payable amount to the petitioner for the work which was successfully completed by the petitioner. Stop. The respondent number 3 replied to the representation appears to have been appears to have resulted in a letter issued by the additional district magistrate to the additional secretary to the government of West Bengal on 26/4/2023, asking the latter, LATTR, to put the sender of the letter in sufficient funds for making payments in respect of the schemes and memos stated in the letter. Stop. Next, the documents make it clear that the petitioner's completed work has not been disputed and no complaint was made in respect of the work done by the petitioner. Stop. The letter of 26/4/2023 from the respondent number 3 to the respondent number 2 further makes it clear that the petitioner was not paid simply by reason of the district magistrate not having funds to pay the petitioner and the additional secretary not transmitting the funds, not transferring the funds to the district magistrate for the said purpose. Stop. Next, WPA 11685 of 2023 is accordingly disposed of with the direction on the respondent number 2 being the additional secretary, Department of Tribal Welfare, to transfer the funds in respect of a calculation sheet annexed at P5 of the writ petition to the respondent number 6. District magistrate will take the funds, will receive the funds
Lordship.
to the respondent number 6 within a period of 8 weeks from date. Stop. The respondent number 6 shall inform the petitioner as soon as the funds are put in with the respondent number 6 or within 10 days thereafter, whichever is earlier. Stop.
Your Lordship kindly says, my lord, admissible dues.
Yes, যেটা বললাম
admissible dues.
যেটা বললাম as given in a calculation নাকি admissible dues.
My lord, Lordship, grateful.
Yes, next.
পরেরটা আমি দেখি।
Item number 15.
Yes, my lord, I beg to appear on behalf of the petitioner. Identical issue. Claimant is different. Issues are same.
I am appearing on behalf of
Instead of P5, it will be P6.
What about the dates?
My lord, same date, identical date.
যেখানে P5 বলেছে এটা P6 হবে.
Yes,
Disposed of,
last part. I'm grateful.
Next.
My lord, only thing the money should be disbursed to the West Bengal Agri Industries Corporation.
Yes, call on the next matter, please.
Item number 16.
Lordship, I appear on behalf of the petitioner. This matter was taken up yesterday.
Yes.
This matter was taken up yesterday. Lordship, I am the owner of a plot of land situated on the Egra Solpatta road. Lordship, the road is
Can't
maintained.
hear you, microphone. Yes.
Lordship, I am the owner of a piece of land situated at the Egra Solpatta road, which is maintained by the PWD, Public Works Department, Government of West Bengal.
Yes, at egress and ingress.
Yes, your Lordship.
Yes.
The private respondent yesterday pointed out that it might be a state highway. Lordship, my instructions are that it's a PWD land and your Lordship is determination.
Lord, may I? Lord, it appears, my lord, the executive engineer PWT, my lord, has taken cognizance of his complaint. My lord, he has directed the BLRO to produce the measurement report. My lord, একটু দেখেন না,
What report?
My lord, demarcation report. Demarcation report, my lord. My lord can dispose of the application directing the respondent number 5 to conclude the proceedings in terms of the 1962 Act. My lord.
Give me the full form that
I'll give it.
State Highways Act. Yes.
If the private respondents are alleging that the construction is within the domain of national highway, my lord may indicate, because that instruction today I don't have. My lord may indicate if it is found, he can transfer the case appropriately. Well, it appears primarily it is within the domain of 1962 Act, because the officer has taken cognizance of it. So my lord,
And where do I get it that the officer concerned?
my lord, will
Respondent number
kindly,
3 has
kindly see the signing yours faithfully, Assistant Engineer, PWD Kharagpur Subdivision. That is the respondent number 5 before your lordship.
What is the date of this letter? I can't
This is
make out.
24th of January 2023.
And Mr. Kothari, what is your complaint against the state authorities? Inaction.
Inaction, Your Lordship, I've made a representation to consider my representation, and if any illegal construction is found, to demolish the same.
Very well. Yes. The petitioner complains of
illegal construction on government land, my lord.
the construction undertaken by the private respondent on government land, as also the and also the inaction on the part of the Public Works Department, Paschim Medinipur, West Bengal. Is that correct?
Yes,
Inaction on this part or anybody else's?
Your Lordship, respond number 4 and 5.
Yes. Stop. Next, the initial controversy with the initial ambiguity with regard to whether the land belongs to the PWD, state PWD, or the national highways is substantially resolved by a letter dated 24/1/2023, issued by the Assistant Engineer, PWD, Kharagpur Subdivision to the issued by the Assistant Engineer, PWD, Kharagpur Subdivision to the Block Land and Land Reforms Officer, Paschim Medinipur, on the subject of demarcation of the PWD land in the area under consideration, in the area under dispute in the present writ petition. Stop. The letter has taken cognizance, the letter appears to have taken cognizance of the petitioner's complaint, and the BL and LRO has therefore been requested to submit a sketch map with encroachment details for further necessary action on the part of the Assistant Engineer, PWD. Stop. Next, WPA 27384 of 2022 is accordingly disposed of with a direction on the respondent number 3.
It will be 5 minutes.
Direction on the respondent number 5 being the Assistant Engineer, Kharagpur Subdivision, PWD, to dispose of the. Is there a pending application?
Your Lordship, there is a pending representation, 1st of September 2022.
To dispose of the representation of the petitioner dated 1/9/2022 in terms of the letter dated 24/1/2023 and the provisions of the capital, the West Bengal public land within brackets eviction of unauthorized occupants, close brackets Act, 1962, within a period of, yes, Mr.
We have to hear all parties. Malol can give us 6 weeks of time.
Within 6 weeks from today. Stop. The concerned respondent shall hear all the relevant parties before taking necessary action and dispose of the representation by way of a reasoned order, which shall be made available to the petitioner within a week from the date on which the reasoned order is passed. এটা ওনাকে ফেরত দিয়ে দাও এই একটা।
Grateful.
Mere passing of the subject to my kind mere passing of the reasoned order won't do. If he finds that there is a illegal construction
Under the Act,
under the
1962
act, he has to take.
Yes. Needless to say, if the concerned respondent finds any unauthorized construction undertaken by the private respondent on PWD land, the concerned respondent shall be at liberty of initiating necessary action under the 1962 Act.
I remain grateful, my lord.
Grateful.
Yes, call on the for judgment matter, please.
Item number 1. For judgment, item number 1.
The petitioner seeks a direction on the respondents, including the officer in charge of the Barrackpore Police Commissionerate, not to take any action with reference to the petitioner's possession of the premises which are in consideration in the present writ petition. Stop. Next, the undisputed facts are that the petitioner was inducted as an occupier of a government premises of which the private respondent number 6 was the tenant. Please correct the facts, all right? Was the tenant. Stop. The petitioner was inducted in February 2008 and continued to occupy the government premises till 2022. Stop. Disputes.
It is not admitted by us, Lord. It is alleged by.
Very well, yes.
I'm sorry, madam.
This is the case sought to be made out by the by learned counsel appearing for the petitioner. Stop. The disputes arose between the petitioner and the private respondent number 6 within brackets original tenant of the premises close brackets from 2022 on the issue of enhanced monthly rent. Stop. According to the petitioner, the monthly rent was enhanced from rupees 2.5 thousand to rupees 4,000, which was not. Very well. Stop. The private respondent thereafter made a complaint to the statutory to the state respondents, and the petitioner and the private respondent was served with a show cause notice on 2/3/2023 by the subdivisional officer, Barrackpore. Stop. The private respondent represented or not before the court?
Notice no.
Yes, the private respondent is not represented despite being served. Stop. The affidavit of service is on record. Stop. The next, the petitioner seeks, learned counsel appearing for the petitioner seeks an order permitting the petitioner to remain in the premises of the private respondent number 6 until a suitable government accommodation is made available to the petitioner. Stop. The petitioner is also an employee of the state government. Stop. Is that correct or not?
Yes.
Stop.
He's an employee of Air India. Of the government, but Air India.
The petitioner is an employee of Air India. What is it? Air India company? Air India? Air India Limited.
Air India Engineering Service Limited, page 21. He is the employee of this. Air India Engineering Service, column 4 of page 21.
Page 21 to देखिए नहीं. Yes.
Column 4.
Air India Engineering Service Limited. Stop. Next, learned counsel appearing for the state places the provisions of the থেকে capital, the West Bengal government premises within brackets tenancy regulation, close brackets Act, 1976, and particularly sections 5 and 6A, A capital A of the said Act. Stop. Council submits that the petitioner, that the private respondent was issued the show cause notice for inducting the petitioner in the government premises, and that and relies on an order passed by a coordinate bench in similar circumstances. Stop. Coordinate bench in WP 25225 of 2014 in similar circumstances. Stop. Council submits that the 1976 Act disallows subletting, which is held to be unauthorized under the said Act, and further submits that the petitioner does not have any rent receipts to corroborate the case sought to be made out, since all the payments, all the monthly payments were paid by the petitioner to the private respondent in cash. Stop. In cash. Next. The section 2 within brackets choto f of the West Bengal government premises within brackets tenancy regulation close brackets Act, 1976 defines tenant within quotation marks as any person by whom the rent of any premises is, or but for a special contract, payable. Stop. Inter alia একটা করে দিও. Stop. Section 3 within brackets 1 provides that every tenancy held by a tenant in respect of a government premises shall stand terminated upon the expiry of the period referred to in a notice to quit served upon the tenant. Stop. Section 5, which is relevant for the present purpose, provides for penalty for unauthorized subletting. Stop. Under section 5, any tenant who sublets or inducts any person in the premises occupied by him in violation of the terms of the lease governing the tenancy, both the tenant as well as the person in unauthorized occupation of the premises shall be liable on conviction to imprisonment or fine. Stop. In the present case, comma, the records show that the petitioner was enlarged on bail by the ACJM Barakpur on by an order dated 1/2/2023. Stop. Next. Section 6, capital A of the 1976 Act provides for eviction of unauthorized occupants and penalty for such occupation. Stop. Section 6A within brackets choto a also authorizes the prescribed authority to take any steps, including use of force, which may be necessary to take possession of the premises and also to enter into the premises for that purpose. Stop. Next. The undisputed facts in the present case is that the petitioner has been in occupation of the government premises of the respondent number 6 till 2008, since 2008. Stop. The tenure/longevity of the occupation does not make the occupation legal or permissible under the 1976 Act. Stop. The tenant in the said in the present case has lodged a complaint against the petitioner, which further leads the court to conclude the occupation being of an unauthorized nature. Stop. Sections 5 as well as 6A, capital A of the Act does not permit the court to give its blessing, judicial blessing, to the petitioner for the unauthorized occupation. Stop. The plea of the petitioner being permitted to occupy the government premises until the petitioner is able to arrange alternative premises is cannot be said to be, did you not ask for it? Cannot be said to be reasonable, and in any event is in any event not permissible under the statutory scheme of the 1976 Act. Stop. Mr. Chatterjee, how much time do we give the petitioner to vacate?
Yes, as your lordship, please. 6 weeks, you know.
WPA 11405 of 2023 is accordingly disposed of by directing, in terms of the above, and by directing the petitioner to vacate the concerned premises within 6 weeks from today. Stop. You want the matter to be taken up after the vacations? What is it?
And after the vacation, I wouldn't have got 6 weeks also. So kindly do not say all these things. Kindly protect me, my lord. My application is pending. Let them consider it in accordance with law. My lord, I am saying I cannot undertake. The petitioner is here. He is also realizing, my lord, the fiasco that he is in. My lord,
Mr. Bhattacharya, 8 weeks at best.
Do much.
8 weeks. Within 8 weeks from the date of communication of this order to
The state respondent.
State respondents now is a subdivisional.
वही तो state respondent है बाबा.
Subdivisional that officer, SDO something.
Respondent number 3.
Subdivisional officer and prescribed authority.
To the respondent number 3, being the subdivisional officer, Barakpur, who is the prescribed authority under the Act. Stop.
We are grateful, my lord.
We are extremely grateful.
Yes, call on the next matter, please.
Item number 17.
My lord, I am paying for not this. Lordship kindly stay after vacation, my lord. Yesterday, your lordship was pleased to hear the matter, my lord. I could not get the, my lord, APOT 116 of 2022, my lord, because the due to server was down, my lord. Server was down. I could not get it, my lord.
I had the
Lordship
What
kindly.
is, 1 minute, can't understand. What is APOT? APOT, what are you looking for? APOT?
It was also reported in
Microphone, please. Microphone, hurry up.
Lordship. It was also reported in 2010 14 Supreme Court
What is
cases.
reported? What is reported?
That is my Board of Works, West Bengal, and another versus Anish Fatima. That was decided even if any, my lord,
Section
order is
83.
passed. Yes,
83 and 95.
83.
Jurisdiction
Lordship.
of the Waqf Board.
Lordship. If your lordship kindly have a look, the paragraph.
Very well, yes. Learned
12.
counsel appearing for the petitioner seeks an adjournment in the matter. Stop list this matter on 6th June 2023 as prayed for. Next. Just hand up the judgment, please, to the court.
Well, this is the
Very
your
well.
lordship directed.
Yes. Next. Next.
Item number 18.
My lord, I am for the petitioner in this matter.
Microphone, please.
My lord, this application has been filed by the secured creditor bank
Under 14.
under
14.
14, under 14 against the inaction upon the part of the
Section 14 of the SARFAESI Act.
SARFAESI Act. My lord.
Pending since when?
My lord, it was filed on 9th February 2022. Thereafter, several reminders were made, my lord. My lord, kindly sees the reminder from
Mr. Chatterjee, 1419 second proviso fixes a time period. Why have you not done it?
The only thing, my lord, I have instructions. There is section 17 application pending and some documents.
Before the DRT?
Before the
But
DRT.
there is no stay.
There is no stay.
There is no stay.
But my lord, my officers during the hearing, my lord, found substantial document that could not be overlooked. That is the reason, my lord, they're not passing this out.
Very well. Give me a time
My
frame,
lord,
please.
it is a ministerial job, my lord.
Mr.
Yes.
Chatterjee, section 14 doesn't consider.
It's not an adjudication.
You just consider the application by the secured creditor and you're supposed to dispose it off within 1419 second proviso. Please. So do it. How much time do you want?
4 weeks from communication, my lord.
Yes, the writ petition is by a secured creditor who has filed an application before the concerned district magistrate under section 14 of the SARFAESI Act 2002. 2002. Stop. The application is said to be pending since February 2019.
2022.
Since February 2022. Stop. Learned counsel appearing next. Learned counsel appearing for the district magistrate submits that an application under section 17 is pending before the Debts Recovery Tribunal, and also that the district magistrate has come across several documents which has delayed the process. Stop. Next. Section 14 of the SARFAESI Act is essentially a proceedings in the of a ministerial nature, where the district magistrate is under a statutory obligation to consider it's called an affidavit, isn't it, under section 14? Consider the affidavit of a secured creditor. Stop. The section 14 within brackets 1 within brackets choto 9 second proviso. Acta dao to. Huh. 14 within brackets 1 within brackets choto 9 within brackets second proviso gives a time period within which such applications are to be disposed of. Stop. There has obviously been a delay in the matter. Stop. Next, WPA 5633 of 2023 is disposed of with a direction on which respondent?
Well, the district magistrate is
2, my lord.
2.
Response number 2 being the district magistrate, comma, Hooghly, to dispose of the application within 6 weeks. Within 6 weeks from today. Stop. Upon intimation to the bank, upon intimation to the petitioner.
We are grateful, my lord.
Next.
Time for respondent number.
Item number 19.
My lord, the petition, my lord, after it was filed, we have served a supplementary affidavit. If my lord, I'm praying for leave to file the supplementary affidavits in this reason, because after the petition has been filed, the petition complains of this, my lord. The Kolkata Metropolitan Development Authority, my lord, is a authority under Article 12 of the Constitution. Now, my lord, they float tenders. Now, what they do when the petitioner gets qualified in the pre-tender qualifications and the technical bit, the defendant number 12 writes a letter saying that
So defend number 12.
by the private party, the competitor, the another tender.
Yes.
Now, writes a letter saying the petitioner doesn't have pre-tender qualifications. Now, thereafter, it is shown to them that the petitioners have pre-tender qualifications, and sometimes the tender was given to the lowest financial bidder, which in several cases was the petitioner itself.
Who shows it to them?
Well, I show it to the authority shows it to them. There are letters at page 245, 46. Now, this process.
So it's all a happy family. You, the KMDA and the private respondent.
No, we were a happy family, my lord.
Yes.
Now, my lord, the situation today is this: the maintenance tenders, the tenders where, my lord, day-to-day activities are there. In some tenders, different number 12 was acting for 1 year. The tender was there.
No, this tender for what?
Tender for maintenance. My lord, kindly see two.
No, that's fine. Yes. Yes.
Now, where the different number 12 is existing for a limited period, the tender gets cancelled for administrative reasons after the financial bid was opened. But the next, another thing, the tender gets cancelled due to insufficient number of qualified bidders after the financial bids are open.
No, so what are you saying, Mr. Ray, that defend number 12 is being favored?
Yes, when he is making complaints, frivolous complaints, as a result of which there is delay in the completion of the tender work.
So are you the successful bidder?
Yes, in most of the cases are the successful bidders. And
so delay in completion of the tender work, what is the relief you want?
Well, the relief, delay, suppose pre-tender technical bid within 10 days, financial bid thereafter within 10 days. Tender should be given to someone. Total span is 20 days.
So what is the subject matter of challenge? Is it your rejection or is it something else?
No, my rejection in some cases, delay in some cases. The entire process is in challenge, my lord, because the tenders, when they are open, suppose they give a time period of 20 days.
Yes.
I am showing, my lord, due to the complaints of the different number, respondent number 12, it is taking about 72 days. Sometimes it is 111 days.
So what is taking?
The completion of the tender, the completion of the award of the tender work. Challenge is not tender specific. Challenge is on the basis of this process. The process is, my lord, in each tender, when the tender is floated, pre-tender qualifications, technical bid, financial bid. There's a time frame. Suppose the time frame in one particular case is 45 days. I have shown due to the complaint of the different number 12, which was not sustained,
It took 75 days to complete it, the tender process.
So even if it takes 75 days, is there any surety that you will be the successful?
No, I was successful out of 16, my lord. In the last one also, I'm successful. Whenever I am being successful in the ultimate process, that is the financial bit, he writes a letter and gets the process stalled. Sometimes it is directly benefiting the different respondent number 12. Why? Because he is the existing person who is doing the maintenance job. Sometimes it is not, but wherever I am successful, he is putting a spanner.
So what is the relief you want?
The relief I want, my lord, is a comprehensive report. It's a comprehensive report showing in respect of the details I have given that this tender process which is taking place, according to me, is not in accordance with law. Let the KMDA file it.
What is the law?
Law is, my lord, if a tender is floated on a particular date for a particular time period, then it has to be completed within that particular time frame. Otherwise, it has to be told that everybody should be on the equal plane. What is happening in the last cases, which are subject to, I have served them, if my lord give me the leave.
So in the report, they will say that everybody is on the same plane and the tender will be completed within time.
If that is so, my lord, then I get the benefit. If they say so, because today I am showing my prima facie documents to show that the tenders are getting delayed. Wherever I am being successful in the last phase or in the technical bit, they are making a complaint. Every tender.
Very well. That is your allegation. But what is it that you want them to state in the report?
My lord, so far as I want to state in the report the truth. Why are they delaying the process? Apart from the complaint of the respondent number 12, there is no earthly reason why they are delaying.
So you will believe whatever they state in the report?
No, my lord, it's for
as a truth.
My lord, if it's for my lord, if I can convince my lord that the process is not being followed, if they say the truth, because my lord, if they themselves at one point of time saying I have got the pretender qualifications, for example, electricity qualification, then the proprietorship, everything, and they are delaying it. But both things cannot. If I am
very well. So the respondent number 12 is the existing contractor
in many fields.
And what about you?
I am also existing. It's not tender specific. It's a process that is going on. In the process, the entire process is getting delayed.
So if it is delayed, it also suits you in some cases.
No. Because first of all, my EMD is blocked. That is another thing. Second is, I am the person who is coming in. He is the person who is existing. Kindly see.
And in some other cases, he's the person who's coming in and you're the person who's existing.
No, there is no such case where the complaint is being made. There is, there's a specific statement, where complaints are specific, where I am the L1.
Mr. Ray, you have to be more specific as to what you want them to state in the report. And I will come to you for that. Mr. Bandyopadhyay, what is it?
Lord, I have 3 points to make.
You're the KMDA.
I am for the respondent number 1 to 11.
Who is that?
Which are officers of KMDA, but KMDA is not a party. My lord, I have 3 points to make.
And who floated the tender?
My lord, KMDA. My lord, I have 3 points. First point is that this writ petition is based on sheer apprehension that something might happen on the basis of some complaints received by us in the tender process. Number 1. Number 2, my lord, the point is that this is an absolutely private dispute between the petitioner and the respondent number 12. It is a fight between Dronacharya and Ekalavya, and he has stated so very fairly in the writ petition. I will take your lordship to that.
He has said that in the writ petition.
He has said that. He has said that in paragraph 16, that it is pertinent to mention here that the petitioner is a seasoned, matured entity in the business since 1995. Respondent number 12 from around 2009 to 2010 came in contact with the petitioner.
Yes.
He came under his tutelage, then he parted ways. They are both aggrieved with each other. And the third, my lord, point is that, my lord, taking the apprehensions to be correct, my lord, the delay that they suggest that there has been a delay. My lord, in some cases, there has been some delay and we have missed the date when we had to finalize the tender. And my learned friend is also correct that we have received complaints against them from the respondent number 12 in 1 or 2 cases and from other bidders from some cases. Now, my lord, as far as one of the, for example, in one of the tender process where we received the complaint, we asked the private respondent that you please furnish documents to substantiate your complaint. They came for a hearing. We considered the matter. We rejected his complaint and gave the LOI to the letter of intent to the petitioner in November. There also there was a complaint. Well, it is not a case that we are totally biased against him. Well, if that was the case, we would not have rejected the complaint on response number 12. But another tender being tender number 04/EE, which is also one of the 3 tenders they specifically mentioned in the supplementary affidavit, Malad. They are also, Malad, at the stage of finalizing the financial bid. We received the complaint from the respondent number 12. Malad, there also we have asked them to give us the documents. We have sent the matter to the grievance redressal cell. Malad, we are awaiting a report from the grievance redressal cell. Malad, we can finalize. Malad, the problem is that if we finalize without taking care of the complaint received by the respondent number 12, next day, Malad, he will file a writ petition saying that it has been finalized without taking into consideration my complaint. So, Malad, we are only trying to assess the complaints, take a decision, and whoever is the best bidder, Malad, will give the LOI to that. Malad, today, Malad, admittedly, if your lordship kindly takes paragraph 25 and 26, the petitioner admits that he is petitioning on the basis of apprehension. He says that the respondent number 12 is making complaints to KMDA, and KMDA may bias the respondents in taking an action. And in 26, he says that the petitioner apprehends that the respondent authorities and respondent number 12 are hands in glove and acting in collusion and connivance. They admittedly it's on apprehension, but it is not a case that we are biased and we are hands in glove. Otherwise, we would not have issued the LOI to them. They are absolutely paranoid about the situation. In a tender process, they are both businessmen. I cannot stop respondent number 12 from making a
12
complaint.
is not paranoid, only the petitioner.
But for the timing, we are not receiving any complaint from the petitioner. He's a seasoned and matured businessman. He will not go against his Ekalavya. He is not as yet. But the Ekalavya is constantly going as Dronacharya. As a state authority, we'll have to take into consider the complaint at least. Otherwise, he will come tomorrow saying that it has not been considered. And the same allegation will be against us that we are biased and hands in glove with the
So
petitioner.
you're saying that there's no need to produce a report.
I say that this writ petition for the timing on an apprehension that we will not award the contract to the petitioner. What I am saying is that we have received complaints. We are considering it. In one case, we have already considered, rejected the complaint and given the LOI.
The complaints are all one-sided.
By respondent number 12, Riddhi.
Yes, very good.
Same complainant. But we'll have to, these are different works.
How many complaints are pending?
For the timing, from the supplementary affidavit that they have served me, I see that they have now reduced the entire quantity to 3 pending tenders. 3 pending tenders.
How many complaints are pending before you?
3.
3.
3 complaints.
More than 10.
10.
More than 10. More than 10.
Some tenders have been cancelled by us for technical reasons and for lack of bidders.
Yes.
And today the pending are 3, and out of that, one letter of intent has been given to them already. And your lordships will find in the prayer also, they have the prayer is limited to 2 tenders. My learned friend will kindly look at his prayers. I'm saying from his prayers, prayers A and B is for 2 tenders only. So, we'll have to consider that and take a decision. We have already sent it to the grievance redressal cell. We have taken note from all our departments.
Mr. Ray, I will just direct them to consider and dispose of the pending complaints made by the respondent number 12 against you within a limited period of time, and then to proceed with the tender.
Well, may I only pray for this?
Yes.
Similar complaints are coming 2019, absolutely identical every time.
Correct.
So I will give them, they are saying about 10 complaints are pending. So I will give them
all the complaints are within a particular time frame.
Yes, yes. Tell me what is the time frame.
But that will not stop the different number respondent. It will go on forever.
Yes,
Mr. Ray, I cannot pass an order speculating how many complaints.
No, not that. All I'm submitting is that if the complaints are identical on the basis of which earlier complaints have been rejected, then, my lord, a summary procedure may be taken. So otherwise, my lord, what is
very well? Yes, Mr. Bandyopadhyay, how much time? Shortest.
I'll tell you, Lordship. My lord, you will find in the prayer portion, the prayer is restricted to 2 tenders. For 2 tenders, kindly gives me 4 weeks, my lord.
And how many complaints for 2? 10.
1 each by the respondent number 12.
Why do you need 4 weeks for that, Mr. Bandyopadhyay? You do it before that. Why 4 weeks?
My lord, it is with the grievance redressal cell, my lord. Kindly give 3 weeks at least, my lord. 3 weeks at least. And thereafter, my lord, reasonable time to finalize the tender process.
The subject matter of dispute before the court is essentially between the petitioner and the respondent number 12. Stop. The dispute relates to 2 tenders floated by the Kolkata Metropolitan Development Authority, who is not a party before the court, but It's "11 officers are" stop, ARE, stop. The writ petition contains statements that the petitioner is apprehensive of several complaints made by the respondent number 12 against the petitioner, which may not only result in the KMDA being biased against the petitioner, but also that the tender processes itself may be stalled, may be delayed. Stop. Next, from the submissions made on behalf of the petitioner, the officers of the KMDA and the private respondent, it appears that the petitioner and the private respondent number 12 were had non-contentious relationship at one point of time, but that the private respondent number 12 started making complaints against the eligibility of the petitioner to participate in the tenders floated by the KMDA in relation to maintenance work of the metro railways. Stop. Next. A learned counsel appearing for the officers of the KMDA submits that there are presently 10 complaints under consideration in respect of the two tenders.
Two complaints, one each.
2 complaints in respect of each of the two tenders. Stop. 10 এর বদলে 2 হয়ে যাবে. Stop. Council seeks time to dispose of these. Council submits that the complaints are presently with the grievance redressal committee. What is it?
Cell.
Grievance redressal cell, capitals, and seeks time to dispose of the complaints. Stop. Next. Since the writ petition is admittedly on the premise of the petitioner's apprehension of the petitioner's eligibility being decided on the complaint made by the private respondent number 12, the court sees no immediate reason to sees no reason to pass any orders commanding the respondents to either open the tenders expeditiously or to act in terms of the tenders contained in the NITs. Stop. Conditions contained in the NIT. Conditions contained in the NIT. Stop. Next, WPA number 8157 of 2023 is accordingly disposed of with a direction on the who will do this, Mr.
There are various authorities, but senior to them, all senior to them is the respondent number 2, Chief Engineer EM sector.
Direction on the respondent number 2 being the Chief Engineer in charge, E/M sector, KMDA, to take steps in disposing of the complaints, 2 complaints within 3 weeks from today, and then to take expeditious steps thereafter to complete the processes of the 2 tenders. Stop.
May I only prefer one indulgence, Malad? After the petition was filed, the 3rd complaint was made. That is the part of the supplementary. After the same process will continue. So, Malad, the
2 এর বদলে the
may I suggest that page 25, prayer B mentions the 2 tenders, kindly direct us to Matlab dispose of all the.
Yes, to dispose of the complaints, dispose of the complaints relating to the two tenders within 3 weeks.
Lordship, the only thing.
This is a third tender, that's why I pressed it.
Then the supplementary is not maintainable because beyond the period.
Yes,
So, continuous process.
within the two tenders, within 3 weeks from today, stop. The writ petition refers to only two tenders. And the order is hence in relation to the tenders which form the subject matter of the challenge before the court. Stop.
Lordship, respondent number 12 may be given and Lordship, a copy of the decision may be given to us.
The copy of the decision will be made available to the petitioner as well as to the private respondent number 12 within 1 week from the date on which the decision is passed. Stop.
May I pray for the deepest of indulgence? Please complaint. I have filed it in March, served on April, complaint in May. After I have filed similar complaint, my lord, in May. That's the reason why I paid for this.
Mr. Bandyopadhyay, why can you not consider this in this
Absolutely,
other
this is
tender?
not part of the.
Not part of the.
No, but how can I pray? It's originated in May. I served it in April.
What I'm submitting, this came in May, my learner is right. After the cause of action of this, this is, this is
continuous process. Yes.
Today, they'll come again tomorrow saying that another, my problem is that I cannot stop them from making a complaint.
No, that's the reason.
Very well. Mr. Bandyopadhyay, also the tender you consider with which is part of the supplementary affidavit. Yes, the tender contained in the supplementary affidavit filed in court today. And any complaint made in relation thereto will also be considered by the respondent number, ki bolam, 2 na 3?
Two. Complaints are related to their eligibility. So if it is decided in my favor, everything goes.
Affidavit of services.
Lordship,
No mentioning now. Call on the list, please.
due to the death of my grandmother, Lordship, I could not come to the Honorable Court, Lordship. This is a real urgent matter, Lordship. Kindly 1 minute.
Which matter is this?
Which?
Death of your grandmother, you could not come. Now you're before the court.
No, Lordship, because I have taken the leave of this Honorable Court on 8th. After that, this matter was taken on 11th.
Which matter today? What are you saying? What do you want to mention?
I want to mention a writ petition, Lordship. You have granted a leave of that writ petition that was about to be taken on 11th. Lordship, I was not there. My senior was there, but he somehow misunderstood this court because you were giving the dictation and I have come to mention this case, Lordship.
Sorry. No. Yes, call on the list, please. Call on
Item number 20.
Lordship, I appear on behalf of petitioners. Lordship, on the last occasion, Lordship had directed us to file short notes of arguments. I'm ready with my the notes.
Which is this matter?
It's a Kenilworth matter.
Yes. Mr. Shoboshachi Chaudhary?
Yes. Was leading me in the matter.
Have you, is your note?
After vacation, I filed the same matter.
You are appearing for who?
State.
Mr. Shamrat Sen?
Yes. Mr. Rai. Anirban Rai.
Mr. Rai. Mr. Ray, sorry.
Ray.
Yes. The notes of the petitioners are taken on record. Stop. Next, learned counsel appearing for the state respondent submits that the learned government pleader will hand up the notes, will submit the notes after the vacation. Stop. Next, list this matter on 13 June 2023. Next.
Item number 21.
Lord, item number 21, my lord, I appear on behalf of the petitioner. My lord, things are slightly unfortunate so far as this matter is concerned. My lord, the petitioner before your lordship, my lord, he had been appointed in the year 2005 to act as, my lord, the assistant public prosecutor, my lord, in the district of Kagdip.
Yes.
Pursuant to an order. He had discharged his duties, my lord, for 12.
In respect of?
In the area, in Kagdip area, in the Kagdip court.
Kagdip,
he had
yes.
discharged his duties, my lord, from 2005 to 2017. He has raised his memos, my lord, to the respondent number 2, who is the LR, concerned LR. Now, my lord, his total outstanding.
Concerned LR? What is LR?
Legal remembrances, my lord,
Yes,
who was
yes.
supposed to make
Yes,
the payment.
yes.
Now, my lord, total billing amount was 42 lakhs and only 10 lakhs had been released in his favor. He is 72 now. So, my lord, he has discharged his duties as an officer of the court and should have been paid. Now, I cannot pray for an interim order. There is no scope for interim. What I respectfully pray before your lordship, kindly direct the state respondents, my lord, to file a report indicating the fact how much, my lord, is due, my lord. So far as the billing amount is concerned, what they have received and how much they have paid. Kindly, my lord, come to 2 pages, my lord, page 13 once. It should have been paid, my lord. Page 13, my lord, the appointment of the petitioner. Kindly see, my lord, the date of appointment, that is in December, my lord, 2005.
Yes.
Now, my lord, the representation, my lord, I had made in 2017. This writ application was filed in 2019, my lord. Somehow it got dismissed once, my lord. Thereafter, my lord, lordship was kind enough to direct the matter to appear in the list, my lord, after considering the urgency. That is the representation I have given, my lord, to the respondent number 2, the learned legal remembrances, my lord. I requested them to release the payment, my lord. Page 15. Kindly come to page 16 once, my lord, first paragraph. I have said the total billing amount, which was approximately about 42 lakhs. And I have said also that I have received, my lord, 10 lakhs. And the service I provided from 2005 to 2017. This is the, my lord, position. He was acting as the additional, my lord, assistant public prosecutor, my lord.
Additional Assistant Public Prosecutor.
My lord, he was acting as the APP, Assistant Public Prosecutor in
Yes,
Kakdi.
what do you have to say, Mr. Roy? Microphone. please.
My specific instruction is that he has already paid 9 lakhs and odd.
Yes.
That is what
That is,
Mr. Dev is
my
saying.
lord, rest of the, my lord, petitioner approach before the office of the district magistrate 24 Parganas with his bill, they will examine and they will, my lord, so enter decision will be taken. That is my instruction, my lord.
Which respondent is that?
The district magistrate. 24
District Magistrate, my lord, is the respondent number, my lord, 4.
This one of 4.
Alipur.
No, I'm sorry.
Alipur.
Respondent number 5, my lord. But I do
Alipur.
not know, my lord, my learned friend would be able to tell this honorable court whether they are the authority, my lord, who releases the payment or not. Probably not.
They are
Isn't
the
it the
authority on the
legal-
district court. They are the authority on the district court is concerned.
No, but what about the legal remembrance?
Legal remembrance, my lord, only looked up, they have sanctioned the amount to the district magistrate,
Yes.
concerned district magistrate, concerned district magistrate distributed the amount to the all the subordinate courts. This is the procedure, my lord.
Very well, then I can dispose of the writ petition, Mr.
Lordship.
Deb. Yes, the petitioner before the court was appointed by the district magistrate, South 24 Parganas by way of an order.
My lord, I'm extremely sorry. May I say, my lord, extremely sorry for this, my lord. Instead of, my lord, disposing of, because I do not know what will happen. Maybe it's an apprehension. If lordship directs the concerned respondent to file a report before the court, because it has been withheld, and keep the writ petition pending.
By the district magistrate, South 24 Parganas by way of an order dated 16/12/2005 to act as the assistant public prosecutor in the courts of Kakdeep, KKDWIP, South 24 Parganas. Stop. The petitioner served in the said courts from 2005 to 2017.
17.
2005-2017 and raised bills for services rendered. Stop. Next, representation made to the legal remembrancer through the petitioner's lawyer on 13/7/2017 states that the petitioner's claim of rupees 42 lakhs was partly repaid by the concerned authority, semicolon, the petitioner was paid approximately 10 lakhs on.
Not the exact date, my lord.
In, then give me the year, please.
Not exact date, my lord.
Stop. Next, learned counsel appearing for the state respondents submits that
My lord, the payment had been made after I filed the writ petition. Some payment.
10 lakhs after
Right.
filing of the writ petition
2019.
in 2019. Stop. Next, the state respondents are present, Kurda. Next, the state respondents are present, are represented. Stop. Next, who will file a report? Mr. Debroy?
Report, my lord. This one, our district magistrate is my clerk.
बोलते जाओ ना.
5.
5.
The respondent number 5, being the district magistrate, Alipur, is directed to file a report in the form of an affidavit, capital R,
5.
clearly stating whether the said whether the concerned whether the bills were received, whether the petitioner's bills for services rendered were received by the concerned respondents and the steps taken in pursuance of settlement of the bills. Stop. The respondent shall give the particulars of the bills paid as well as the bills which remain due and outstanding from the state respondents. Stop. Next, list this matter. The report shall be filed by 9th June 2023 with an advance copy to the petitioner. Stop. List this matter on 14 June 2023.
Petitioner will also, my lord, submitted some bill. Otherwise, my lord, it is difficult.
What?
Petitioner should submit a bill.
My learned friend is saying, my lord, that I should submit the bills. Bills have
Yes.
already been given. If,
Support they are not located the bill.
my lord, if the report is served on me, lordship has said on a prior date, then obviously I would produce, my lord, all the relevant documents if I have to controvert their statements made in the report. Lord, may I file the, my lord, affidavit of service?
The affidavit of service is kept
Grateful
on
to your
record.
lordship.
Deeply obliged.
14 June.
Item number 22.
Lordship, I am appearing for, on behalf of the petitioner, Lordship. We are supposed to file the supplementary, reply for the supplementary affidavit, Lordship, and we are not ready with the reply, Lordship. I request your Lordship to fix this matter any day after vacation, Lordship.
Learned counsel appearing for the petitioners seeks extension of time to file the reply to the supplementary affidavit of the respondent numbers 1 and 2. Stop. Next, list this matter on 13 June 2023. Stop. The reply is to be filed by 9 June 2023.
Your lordship, could we make it 14 June if possible?
14.
Deeply obliged.
Grateful.
কত তারিখ হলো? কত তারিখ আছে শুনতে পাইনি। Item number 23.
This is my application,
I
madam.
have been informed Mr. Devopriya Chatterjee is appearing for the state. He says that affidavit, there is a direction for affidavit and payment of cost was there. He has paid the cost and affidavit is ready. Just he is not here today. Just a not
Actually,
today.
this is going
Paying
on
for the-
since 2000 September, madam. They have paid the cost. I'm grateful, lordship. They have
He
paid the
says the
cost.
affirmation is ready,
But
everything
my
is
lord,
ready.
they are not filed. It's still not the opposition.
Why have you not filed the, where is the opposition?
Opposition is with him. Actually, he has not come to the court. He has
I'm
informed me.
keeping the matter tomorrow, file the opposition.
Yes.
But day after tomorrow, tomorrow after difficult.
Yes, learned counsel appearing for the state seeks an adjournment on the ground of counsel and states that and submits that the costs directed to be filed have already been paid. Stop. Counsel seeks time to file the affidavit in opposition. Stop. Next, list this matter tomorrow.
But the day after tomorrow. only
List this matter on 18th May 2023. Stop. The affidavit in opposition should be filed by the returnable date.
Grateful. Let it is his position, man. Very grateful.
Next.
নামগুলো দিয়ে যান। Item number 24.
My lord, I'm led by Mr. Subhasi Chatterjee, my lord. He is engaged in court number 13, my lord. I'm paying for not today, my lord.
Adjournment is prayed for on behalf of counsel appearing for the petitioner. List this matter on 7 June 2023. Next.
Item number 25.
Lordship, I appear for the petition.
But I appear for the state.
Lordship, this is an application under section 14 of the Surface Act for implementation of the section 14 of the Surface Act. You know, the last occasion, my lord directed us to add BLRO as a party respondent. We have added that and we have also served. Lord, may I file the affidavit of service? Lord, in this writ petition, my lord, we have requested for the district magistrate to implement the order under section 14 of the Surface Act. Lord, since we had filed this application under section 14 before the learned district magistrate, Lord, in the year 2000, Lordship, 1/11/2018. Lord, thereafter, repeated, my lord, requests were made to
No,
comply with the
why
order.
did you want to add the BLLRO as a part?
My lord,
Because they had
on the
raised
last, on the last occasion, Lordship, I sought for an instructions from the BLR as to whether the plotting question lies in the name of whom. My lord, I have the report. The report speaks, my lord, the plotting question is not in the name of the borrower. And another main difficulty is the mutation certificate which has been supplied to the bank and basing upon which the loan has been sanctioned is a fake document that has not been issued from the office of the BLLRO. That I can put it on affidavits also. I have the report.
No, but then under section 14, you will have to dispose of the application.
Yes, Lordship, we have to dispose of the application. That can be done, but it can, if it is,
Yes, dispose of the application by giving your reasons, please.
Lordship.
Or if your lordship, if my learned friend files in report, if a copy can be served upon us, my lord.
No, but
we
then
can
the court cannot take up
Lordship.
the function of section 14.
Lordship.
That is up to the district magistrate.
Lordship.
My lord.
The affidavit of service is kept on record. Stop. Learned counsel appearing for the district magistrate submits that the report of the BL and LRO indicates that the plot in question is not in the name of the borrower. And
And the mutation certificate, basing on which the loan has been sanctioned, is a fake document, not issued from the office of the BLR.
that the documentation involves forged documents. Stop. Next. Since section 14 of the SARFAESI Act, 2002 contemplates the district magistrate to dispose of the affidavit of the secured creditor by passing suitable orders for the purpose of taking possession of the secured assets, comma. These facts, the district magistrate being the respondent number.
Yes, number, lordship.
Two,
lordship.
Two, comma, the district magistrate, comma, Bankura, being the respondent number 2, is directed to dispose of the affidavit filed by the petitioner / secured creditor in terms of the documents available before the respondent number 2, available to the respondent number 2 within a period of 2 weeks from today. Within a period of 2 weeks from today. Stop. The order shall be made available to the petitioner within 4 days from the date on which the respondent number 2 passes the order as directed. Stop. WPA 21916 of 2022 is disposed of in terms of the above.
Lord, may a copy of the report that has been filed today be served upon us, my lord? That has been handed over today.
Yes, the report of the BL and LRO is to be made available to the petitioner in the course of the day.
I'm grateful, my lord.
A copy of the report.
Lordship, here and now I am submitting, my lord.
Yep, yep.
Item number 26.
Wait, please, Lord Simla. This is my application. Lord. Order for quashing an order passed by excise authorities on the ground that it doesn't contain any reason. And secondly,
Mr. Mitra, microphone.
my application for quashing an order passed by excise authority on my application made pursuant to order of court. Court directed to make an application to excise authority is excise of license. My client had got an excise license, and after selection of site, he took a shop, hired staff. Then within 99 days thereafter, his license, his workshop was suspended. On the ground election, election coming. General election over, even it was not restored.
No, suspended on the ground of the elections.
Election coming, the forthcoming election. And that only my guys were not. Then not then they said that your license will be granted under 4Q. Now, subsequently, rule 4Q, after granted, much long after, it has been repealed. So, my lord, a repeal may have effect on the future, but it cannot affect the license already granted. Anyway, Miller matter came up to court. Michael applied challenging repealing of 4Q. Court said, no, I am not going to repeal, but I'm not going to strike down, but I give you liberty and directive to apply the excise commissioner for a grant of an excise of license, excise of license.
You filed a petition before the court.
Yes, many people, including my client, it's a bunch of petitions filed. And court said that I'm not striking down repealing of 4Q, but I'm giving you the direction to apply for a.
So 4Q would continue.
No, 4Q has been repealed.
Repealed.
But
So-
then court said,
Yes.
when you apply, because you have used your license only for 9 days, and you apply, and they will consider giving you a fresh license under the excise law, and at the same site, existing site we apply, or otherwise. I apply for giving a license existing site within 10 days as directed by court. Excise authorities within not only 1 month, but 3 months thereafter, long after, has passed this order, saying that you are not, your license rejected on the ground, it does not comply the procedure. What procedure you do not know? Yeah, they excise rules. We cannot deal with application for new sites. Our application not getting a new site. New site require a lot of formalities. Mine is approved site. Therefore, my suggestion has been, you kindly quash this order and let him hear us. Let me hear me and giving reason dispose of my application. This
And,
order is there.
from which document, Mr. Mitra, will I get it that it's an existing site and not a new site from the coordinate bench's order?
Yes. We are already holder of a license. We have set up our shop, and we mentioned in application we want to restart our shop already existing and approved site.
Yes.
Nice. Kindly come to the order, impugned order, page 162. Then I show you lordship order of court, pursuant to which I had made an application.
We are at the interim stage.
162.
We are at the interim stage.
There is no scope.
No, well, this is it's third time coming today. Respondents today is available. No problem today. It's a urgent twice.
Yes.
This is to inform you that the application as per annexure list, several applications made under above captioned. Subject disposal application for issuance of license, category license under Bengal Excise Act. Reference order of Honorable High Court in connection with the appropriate number and similar given. Application for issuance of foreign liquor of category license submitted by erstwhile 4Q license could not be processed, as the said application were not in accordance with the procedure prescribed by excise selection. West Bengal said excise selection of new sites and grant of license retail sale of liquor and certain other intoxication rules 2003, and West Bengal excise selection of person for grant of license at new sites for detailed sale of intoxicating rules. Hence, applications were not approved.
Mr. Mitra, this is the nomenclature of the rules.
Rules, but rules have annex.
Yes.
The rule relates to.
So new sites is how the rules are called. That's the name of the rules.
Yes. And these are applicable when application is made for license at a new site. That is the rules I have got here. I have got here. That is my
Yes.
contention, and show your lordship that these rules have no application. But my lord, no reason why he doesn't approve. What procedure I am not which particular. If I do not follow a procedure, it is point out, then procedural law we can make up. Not substantive law I am not violated. But can you similar? Can you now come to the order and then I place the rules I have got. I'll show
Mr.
you.
Mitra, microphone, please. Yes.
Rule order of the court is at page 153. It starts at
Yes, says that their existing sites.
153. Yes, my lord. Can we come at page
Yeah, I've seen it at page
155.
155. Says existing sites.
153? Yeah.
Anything
Existing-
else, Mr. Mitra?
At the existing sites. And apply by existing sites. So when new site rule, and if my lord, I may now show that.
And this is your license lapsed or what happened?
No, license was my lord. No. License normally, first license given, lordship knows, for a period of 6 months.
Yes.
Subject to right of renewal. With out of 6 months, I could use the license only for 9 days. Only for 9 days.
Yes.
Therefore, court said, where I am not repealing, I am not affecting, but you apply and they will consider going full complete.
Mr. Mitra, I can't hear you. You have to use the microphone.
Oh, sorry.
Yes.
Yeah. Oh. Entitled to apply for fresh license at their existing site.
Mr. Mitra, I've seen that. That is page 155. I am asking you,
Yes.
did your license lapse? What happened?
No, license expired 6 months period.
6 months. So that
months.
means this is under 37, section 37,
It's 37. It will not apply.
37D or B or whichever.
And
Yes.
court felt that I, out of tenure of 6 months, I could utilize the license only for 9 days.
It was not a permanent license.
But
It was a temporary license.
All liquor license, law of license are for initially period of 6 months, subject to right for
No,
renewal.
there's a temporary license provisions under section 37 of the Bengal Excise Act.
All license temporary. License is never given for a 6 months, go on renewing by under the excise rules. But my grievance is not that. Grievance is that you reject my application if I am not entitled to on merits, provided in full compliance with required formalities. Well, what they have said is not in accordance with 2 rules, which are not applicable in our case, firstly, and secondly, how and where I do not comply with. No reason indicated that you don't comply with this rule because of this.
Yes,
These
Mr.
are
Shah.
conclusions. Well,
Yes.
I'm asking about hearing fresh application.
Yes, Mr. Shah.
The categories of licenses are mentioned in the 2003 rules under the rule 4. There are several categories, 4A to so many categories are there. Now, one of the category was 4Q. Under the category of 4Q, so many licenses have been issued on different times. Ultimately, the government has decided to abolish this category.
No, what was 4Q?
4Q was a license for consumption of all kinds of liquor. It's a kind of wide scope was there. All kinds of liquor except Tari and Pachui. So 4Q license were given. Ultimately, government thought it fit, my lord, that from one license, one can get so many, the authority to sell so many licenses categories. So government has decided to withdraw that particular provision. Accordingly, Act has been amended and that provision of section 4Q has been abolished from the Act. So all the license given under the section 4Q has also been cancelled then and there.
No, the Mr. Mitra said that license was cancelled because of some election or something.
No. That was the background. Initially, license was suspended due to the declaration of parliament election, perhaps in the year 2019. Declaration of parliament election, this was initially suspended. That was challenged, several writ petition files. Later on, the coordinate bench directed you consider since election is over. So later on, government come to a conclusion that we will not retain this category of license, that is 4Q. So that decision was challenged before the Honorable High Court.
Yes.
And during the hearing, the Honorable High Court has categorically held the order exactly reflected in page 153. The Honorable High Court, the coordinate bench has held the government has every power and this has been rightly abolished. So no interference at all. Holding this, and the last paragraph, if you will kindly see at page 155. The coordinate bench held the last but one paragraph from the bottom.
Yes.
Page 155. So this part is over. The 4Q, abolition of 4Q challenge, High Court has affirmed that that order has not ever been.
No, says shall be entitled to apply
Yes,
for
yes.
fresh
But I'm
license.
coming to that. I'm just kindly allow me 1 second to read this particular.
Yes.
But however, since the writ petition have been at one point of writ petitioners have at the one point of time granted a benefit under 4Q, albeit non-existent today, they shall be entitled to apply for fresh license at their existing sites or otherwise upon full compliance with all required formalities afresh. So he has to, my lord, file all formalities, comply all formalities afresh. If such application is made within a period of 10 days from date, the authorities shall consider and dispose of the same in accordance with the applicable rules and law within a period of 3 months thereafter. So there are two aspects. They have to file afresh following the procedure laid down in the law, and thereafter their applications will be considered by the authority also under the provisions which is applicable, the relevant rules and laws. These up to this was all right. Then, my lord, the petitioners, my lord, made an again mentioned this matter for correction in the order. But kindly come to page 156. The earlier order was corrected. The difficulty arose from here, lordship. Here, my lord, they said instead of fresh license, kindly put the expression off license, off shop license. Similar, the order was, the earlier order was little bit corrected or amended. Instead of fresh license, they have said it's off shop license.
Where is that?
Page 156.
Yes.
First, second paragraph from the top. In the fourth line of the paragraph of the page, the order dated 9 September 2021, after the expression for fresh license, the expression for off shop shall be included instead of that. Now here, Miller, the problem starts. Since Miller, off shop license we used to give under the two categories, 4A and 4E. 4A for country spirit off shop, 4E for foreign liquor off shop. Now, Miller, the rules, so far as the 2003 rules and 4 rules has categorically stated how the off shops will be declared. The off shop cannot be, fresh off shop license cannot be given at any existing sites. A new site has to be there. That site has to be declared by the government following the procedure laid down under the rule 9 of the 2003 rules. Not only that, after the selection of sites, the person has to be selected. Since so many persons for a particular site, so many persons can come with the applications. That has also been laid down under the rule 13 of the 2003 rules and also the 2004 rules, which has been mentioned in the order impugned.
Yes.
But these formalities or all these the applicable formalities have not been complied with. They have straightway filed their applications. But
No, so their application is of what nature?
Off shop, obviously, since they have amended the order, they have included the word off shop. Off shop license can only be given under the category 4A or 4E. See, if I took the for the sake of argument that they have applied on the 4E, that is foreign liquor, then Miller, the rule 2003 rules, 2004 rules will be applicable, and the Honorable Judge of the Calcutta High Court has specifically said that their application should be considered under the applicable rules. These two rules are 2003 rules and 4 rules, where new site has to be declared by the government, and the person has to be nominated or fixed by the government, selected by the government on several rules. Similar, they doesn't come under that scope. They have simply made an application. Not
so you're saying that they have to make a fresh application in terms of 4E and 4A and 4E of the whatever of the 2003 and 2004 rules.
2003 rules.
2003
the category 2003 rules. 2003 rules says how the new site will be selected by the government. Rule 9. Rule 13 says how the persons will be selected, will be given license to that particular site.
Yes.
And 2004 rules elaborately states how the persons to be selected.
Very well.
So these provisions have not been complied with. These are not applicable here in this petitioner's case. So accordingly, my lord, the Excise Commissioner hold that these applications are not in accordance with law.
So you're saying that the petitioner is required to file a fresh application under the 2003 rules
Yes.
for an off-shop?
But the off-shop is the difficult, my lord. The off-shop, we cannot give an off-shop license in an existing site. That is the policy of the government, and the rule also says off-shop, where the off-shop will be situated, that should be, my lord, determined by the government itself. The site has to be declared by the government itself. But there, at the initial stage, it was all right. The Honorable Coordinate Bench has said the existing site, fresh license. There are many categories of fresh licenses there. We could provide them. But they themselves invite the problem at the time of correcting the orders. They said, no, instead of fresh license, kindly put the word off license, off-shop license. But the off-shop license cannot be given under any provisions. Only 4A and 4E. An off-shop license cannot be given in any existing site. The new site has to be declared by the government. And the person has to be selected through lottery. Since if for a particular site, so many persons applied, whom we will give the license, that has to be determined under, with the process of lot. So these are the procedures laid down under the 2003 rules and 2004 rules. So the excise, the authority was had no other options but to say that the applications or whatever it is not in accordance with law. And so far as the applicable rules are concerned, my lord, they have not followed that. So we are not in a position to offer them any license.
Yes. Yes, Mr. Mitra. Yes, Mr. Mitra.
Sir.
That argument was made of license. That was what court made. Wrongly mistaken fresh license was given. Court has corrected that. So application has been, court has directed us to make an application for off license on the existing site. And that will be considered by them. Now, what the learned friends are arguing now today amount to saying the court order is wrong. Court has passed an order for grant of a off license at the existing site, which is not permissible in law. Then that's what they're arguing. Now, that is argument, court order is wrong. That's the argument. Now, let's see, my lord. Ladman has not shown how it is applicable. See, my lord, I thought application, rule number, copy it out.
Yes.
Similar, these applications are to be made. I have already approved. I've already applied for page industry. Let's looking at rule 2003 first.
Yes.
Yes.
Mr. Mitra, how much time will you take? Because I will not hear any matters beyond a certain period of time before the holidays,
So
last 3 days.
my notes of argument ready, my lord, I can hand up.
No. Notes of arguments I will not accept unless there's a direction for that.
Yes.
How much time will you take for your submissions?
Reply. I'm replying. Well, let me finish in 5 minutes.
5 minutes?
I'll let me
Yes,
finish.
yes,
But can you take the question applicability of rules?
yes.
And they don't say what have been submitted. Those are not the reasons given.
Yes.
So let them make an order giving this. Can you not come to rule 2004? Looking 2004
Yes,
rules.
yes.
Can you see the definition? Application. Sorry, my lord. 2 and 4. 2. These rules shall apply to grant of license for detailed sale of intoxicant mentioned in A, C, E, a rule of West Bengal excise rules of other intoxication placed of the sector in it. Then 3. In these rules, unless there is repugnant in subject to context, orders and expression used and not defined, shall be meaning expressed assigned to reason in another rule. Application.
Yes.
Can you sorry, Bill, assigned to them in the act and the new site rules.
Yes.
That new name is new selection of person grant of license at new site retail rules. And can you see section 3 definition? In these rules, unless there is anything repugnant to the in subject or context, words and expression used and not defined, shall have their meaning respectively assigned to them in the act. And the new site rules is not a new site. Can we come to the new site rules of 2003 now? 2003.
Yes.
These rules application shall apply to grant of license for retail sale of liquor other than the spirit and such other intoxicants as may be notified by the state government from time to time. It's not that. It is not public. I'm not I'm responding to a public invitation by the government, inviting them applications. I have already gone through that process earlier. I was granted license at an off-license shop. I was granted. I've gone through this procedure. I've been granted license in compliance with Rule 2003, Rule 2004. And now my license has stood suspended after 9 days and it could not occur. Court direct apply. Court order is apply for off license at the existing site. Can you see similar definition of new site? New site?
But Mr. Mitro, you substituted that by saying off-shop license in the subsequent order.
I had offshore license.
No. This corrected order at page 156.
Correct. That's how I corrected. It was not fresh license. It will be an offshore license, not a fresh license. Offshore license. What I have. Which had expired, and court has, due to suspension order of court, and court has said, consider my application. They apply these two rules which have no application. It was not a case where government had invited application for the public. And an existing off-license holder has, under court direction, upon expiry of that tenure of the license, has applied for off-license at the same site, which is approved.
Very well. Mr. Mitro, whatever the procedures are, you follow that.
I have followed. But let them indicate what procedure I have not followed. Please, that's my grievance.
Yes,
I have
Mr.
indicated by, if you also kindly see.
There's nothing indicated in the
Mr.
order.
Shah, let me do this. Let me direct the commissioner or whoever the respondent is to specify what violations, alleged violations, or what is the particular which they have to follow under the 2003-2004 rules.
Yes,
All
we
right?
will clarify the.
Yes.
Very good. That take correct order. Will you order any? Give them a chance.
The confusion in the present writ petition arises out of a correction made at the instance of the writ petitioners to an order passed by a coordinate bench on 9/9/2021 in WPA 1581 of 2020. Stop. The material part of the order directed the petitioners before the court to apply for a fresh license at their existing sites upon full compliance of all the required formalities afresh. Stop. The concerned authority was directed to consider and dispose of the application in accordance with the applicable rules. Stop. The court was hearing several writ petitions in the aftermath of withdrawal of Rule 4Q of the 2003
rules.
Of the 2003 rules, 4Q of the West Bengal excise within brackets selection of new sites and grant of retail sale of liquor and certain other intoxicants, close bracket rules, 2003. Stop. The direction/relief adverted to related to those parties, to the petitioners who had enjoyed a benefit at a certain point of time, but had their licenses cancelled after withdrawal of Rule 4Q. Suspended or cancelled?
Cancelled, not suspended.
Yes.
Then there is no existence of that particular license.
No, it expired tenure.
No, not exactly. Lordship.
Let them
Stop.
cancel. Document.
The petitioner however, applied for, the petitioner, however, mentioned for correction of the order and by an order dated 13/9/2021, comma, the fresh license, quotation marks, was substituted by off shop,
Sorry, Miller, that 11 is not right. Can we come to 156?
off shop license.
Expression for fresh license, expression for off shop will be substituted.
Stop.
For off shop.
Next,
Not fresh license.
the petitioners are now aggrieved. The petitioners say that the petitioner complied with the, that the petitioner pursued, that the petitioner followed up with the direction of the court and made an appropriate application before the
Excise Commissioner, Lordship.
excise commissioner. Stop. The petitioners are now aggrieved by an order passed by the excise commissioner on 21/2/2022, by which the petitioner's application for off shop license under the Bengal Excise Act 1909 was rejected on the ground of the applications not being compliant with the procedures prescribed under the 2003 and the 2004 rules, capital R. Stop. Next, learned counsel appearing for the petitioners submits that the petitioners made the application for an existing site, whereas the excise commissioner rejected the application on the new site rules of 2003, 2004, 2003, 2004. Stop. Next, learned counsel appearing for the state submits that the petitioner's application must follow the procedures and formalities and procedure laid down in the 2003 and 2004 rules relating to an off-shop license. Stop. Council submits that an off-shop license cannot be at an existing site, since the state reserves the right to select a new site as well as the concerned licensor, licensee for the off-shop license. Stop. Next. None of the objections raised or explanations given on behalf of the state are reflected in the impugned order of the Excise Commissioner dated 21/2/2022. Stop. The impugned order simply refers to, simply states that the petitioner's applications are not in accordance with the procedures prescribed under the 2003 and 2004 rules, capital R. Stop. Next, in any view of the matter, comma, the impugned order needs to be more specific in terms of the alleged non-compliance. Stop. The petitioners must know the correct / appropriate procedures under the 2003 and 2004 rules, which the petitioners allegedly did not, 2003 and 2004 rules, which and the specific procedure thereunder, which were not, which did not find place in the applications. Stop. Which did not find conformity in the applications. Stop. Conformity. Ekta kotha. Conformity in the applications. Stop. Next, WPA. Two 28013 of 2022 is accordingly disposed of by quashing the impugned order dated 21/2/2022.
Instead of quashing, if your lordship give us directions to clarify elaborately, in addition to these order.
Is disposed of by directing the excise commissioner, being the respondent number 3, to reconsider the impugned order dated 21/2/2022 and come to a fresh decision with reasons within a period of, yes, Mr. Shah?
6 weeks.
Within a period of 4 weeks from today. Stop. The petitioners shall be informed of the decision within 4 days from the date on which the reasoned order is passed. Stop. Needless to say, comma, the impugned order shall not be given effect to, shall cease to be of any effect till then. Stop.
Can I allow one submission only? Then because my submission has been that this rule 2003 and 2004 has no application in the instant case.
ওই যেখানে learned counsel for the petitioner লিখলাম submissions গুলো record করলাম ওখানে add করে দাও. According to counsel, comma, neither of the 2003 or 2004 rules have any application to the petitioner's case.
And also, can we allow them hearing? Can we give us hearing for the?
Yes, the petitioners shall be heard by the concerned respondent before passing of the reasoned order.
Then
As
kindly,
directed.
my lord, kindly give us 6 weeks times, my lord. We have to issue notice to them, my lord, if somebody pays for an
Well,
adjournment.
give us
Then, my lord, kindly
3
6
days
weeks time
notice,
will give.
4 days notice, whatever notice. Within 4 weeks.
4 weeks time, 6 weeks change.
4 weeks.
6 weeks করে দাও.
Grateful, lord.
Item number 27. 7, my lord, I am for the petitioner. I have received a copy of the opposition on Thursday, my lord. So I need some time to file a reply to, I want to file a reply to that opposition, my lord, which the CWC has filed. So kindly.
I'm appearing for
Yes, learned counsel appearing for the petitioners seeks to file a reply to the affidavit in opposition. Stop. Let the reply be filed, the reply should be filed, capital R, be filed by 9 June 2023. List this matter on 14 June 2023.
Grateful to your lordship.
I filed the affidavit in opposition.
The affidavit in opposition of the CWC is filed in court today.
Item number 28.
Could I appear for the petitioner?
My lord, I am appearing for the respondent number 6.
I can't hear you.
My lord, I am appearing for the respondent number 6.
Who is that?
My lord, is a association secretary.
Microphone.
Secretary of a Siddharth Point Welfare Association.
Well, this pertains to a building, my lord, which is where, my lord, I am a tenant. But I have a shop over there. Now, my lord, the tenants, the owners association, my lord, they don't allow me to, my lord, operate the shop on Sundays. And my lord, initially,
It's a residential building or a commercial building?
it's a commercial building. It's on Park Street, my lord, commercial building. Now, my lord, this is a jewelry shop, my lord, and my lord, initially, the association used to claim 5,000 rupees from me to keep the shop, to allow me to keep the shop open on Sundays. But thereafter, my lord, they had.
This is the association of the building.
Yes, owners association.
Yes.
But I am a tenant in respect of a part of that building. Now, my lord, to that, my lord, initially they allowed us to operate on Sundays, my lord, on payment of 5,000 rupees. Thereafter, my lord, they have stopped us from operating our business on Sundays. Now, my lord,
Despite your continuing to give 5,000 rupees?
yes, my lord, we had offered them. We have never said that we are not going to give it. Therefore, my lord, I went before the Shop and Establishment Act. My lord, today, my lord, I have permission from the Shop and Establishment Act to operate the business on 7 days a week or 365 days a year. Therefore, my lord, there cannot be, my lord, any ground for the, my lord, association to stop me, my lord, from operating on Sundays. My lord, I have been exempted by the, my lord, appropriate authority to, my lord, operate on Sundays, on all days. Kindly have a look to this.
You want to operate only on Sundays?
On all 7 days.
Yes.
And jewelry shop, I am told, my lord, the gathering is the maximum on Sundays.
Yes.
So therefore, the most profitable day, my lord, I am not being able to operate. Therefore, my lord, it's not impermissible in law to, my lord, keep it open on Sundays. Subject, of course, to, my lord, my permission. Yes. My lord, please have a look to my supplementary affidavit. My lord, it starts, my registration starts at page 4. Now, please have a look to my lord, clause number 15 at page
Have you
5.
served? Have you served your learned friend?
Yes, yes, right now. Yes.
Yes.
Please take, my lord, clause number 15 at page 5.
This is a registration under the shop
And establishment.
Yes.
But at paragraph serial number 15 at page 5.
This is an application. This is an application.
But this is the, my lord, permission that your lordship will find, my lord, from page 7.
Yes.
15 is exemption, exempted category, declaration of weekly close days in a case of shop and commercial establishment, exempted category. Now, please have a look to me at page number 8. Now, this is the circular which, my lord, the Labour Department of the Government of West Bengal has issued on 30th of October 2018. Please take the second paragraph. Therefore, in exercise the powers under subsection 2 of section 4 of the Act, the governor is hereby pleased to grant exemption to all classes of shops and establishments situated in the whole of West Bengal, notification number, etc., from the operation of the provisions of clause A of subsection 1 of section 5 of the Act in public interest until further orders.
What is that?
Yes. Now this here, lordship may kindly have a look to the Act.
Give me a copy, please.
Section 5(1)(a). In each week, every shop or commercial establishment shall remain entirely closed on, and every person employed in a shop or an establishment shall be allowed as holiday at least 1 day and a half day next preceding or the next following such day. No deduction, etc. Now, by reason of, my lord, this clause at the document at page 8, my lord, this exemption has been granted, which your lordship will find, my lord, from section 4, subsection 2. My lord, 4A says, my lord, this act shall not apply to A, B, C, D, E.
Yes.
With section 4.
Yes.
First, subsection 1 says this act shall not apply to so and so, my lord. We don't fall under that. 2, subsection 2. The state government may, if it thinks fit to do so in public interest, by notification exempt subject to conditions, if any, as may be specified in the notification, from the operation of any of the provisions of this act other than those under sections 8 and 9. 8 and 9, my lord, cannot be exempted. Other than those, my lord, those can be exempted.
Yes.
Therefore, my lord, today, my lord, there is no impediment.
Where are you finding 8 and 9?
My lord, in section 4, subsection 2.
Yes. Yes.
Well, 8 and 9, my lord, are for
Yes,
young
yes,
children,
yes.
young adults.
Yes.
Therefore, my lord, today, my lord, I am coming before your lordship, my lord, with a complaint that, my lord, an association is preventing me, my lord, from carrying on my business.
And you're relying on 30th October 2018 notification?
Yes, 30th October 18.
Yes.
My 7 is my registration.
And the registration, your lordship will find, my lord, from page 7.
From page
7
of what?
of the supplementary.
Yes.
And my lord, my
So this notification is for all shops. What is it?
yes, my lord, certain categories of shop, my lord, which they have said.
In the said exemption, referred to as the said exemption to all classes of shops.
Yes, yes. But your lordship will find, my lord, various shops which are open on Sundays. For example, I can give you a lordship example like pantaloons. Your lordship will find that open on every day. Raymond's, they are open on every day. But this is permitted because the exemption is granted. Otherwise, my lord, section 4 and 5 is a bar for keeping open the shops on every day. Because
But doesn't mention Sunday, says 1 day a week.
yes, 1 day. But usually, my lord, people choose to keep it closed on Sundays. Now, my impugned order or the challenge is at page 34 of the writ petition.
Page
34 of the writ petition. I used to pay, my lord, 5,000 that your lordship will find from page 36. For the present, your lordship need not look into that. Please take page 34.
Yes.
Now, the association gives it to all the owners and occupiers. We would like to inform you that due to urgent security measures, the association has decided to close the building premises on all Sundays with effect from 1/11/22. No shops, offices, banks shall remain open on Sundays. Lift operations will be closed. Main entrance to the building shall be closed. In case any shop owner wishes to open their shop on a particular week, Sunday, 1 week advance notice has to be
So,
given.
Mr. Dotto, why has it become so urgent in May 2023?
Every Sunday, I am unable to open my shop.
You filed the writ petition in 2022?
Yes, yes, it was filed in 2022. It was taken up by a coordinate bench. Then the coordinate bench released the matter. Therefore, it was moved before a coordinate bench. It was heard, then released. Therefore, we are before your lordship.
Lordship's was the view. This is the.
Mr. I will come to you, Mr.
private-
Mondal.
yes.
1 minute. Yes. Yes.
The coordinate bench had released I think
For want of determination.
yes, because there is no police inaction or nothing to do with the police. Therefore, what I respectfully submit, that since it is a prevention in carrying on business, this is a fundamental right. Therefore, I can move it against a person other than the state also. But the latest Supreme Court decision 4:1 has said Article 19 and Article 21 can also be enforced against persons other than the state. There are only 2 paragraphs of this judgment. It's a bulky one.
MP power.
No, my lord. This is a recent one. This is Kaushal Kishore versus State of Uttar Pradesh.
Yes.
2023, Volume 4, Supreme Court Cases, page 1.
You wanted to take a point of view. If he doesn't want to take, why do you?
But he has taken a point, your lordship has not heard. I could hear. That's
Yes, Mr. You want to take a point of maintainability.
Yes.
You read the judgment, then you come back.
Yes. Oh. Yes.
Microphone.
Yes, ma'am. Yes, ma'am. But actually, there.
No, you agree with what the judgment says.
No, let me
No.
go through the judgment. My entire, they file a writ petition. So not a civil suit. So authorities upon whom they have sought for the mandamus are police authorities. Kindly go through the law of police authority. They are complaining against the police authorities. Kindly see the law points and pair portion of the writ petition. Well, kindly go through the first law points in this writ petition. First page.
Does
points
writ
of law.
petition say that this is a law point?
Well, it's points of law. Well, kindly go through
Yes.
first page.
No, no, no. Please come to the praise.
Well, thereafter, well, pair portion.
Yes.
Pair portion B and C. Kindly go through. And who is the respondent 1 to 5? They're all the police authorities.
Yes.
And
But if it is
total-
police authorities, then Mr. Dotto said that the coordinate that coordinate bench released some matter.
out of court, I am saying, my lord, earlier, my lord, Justice Mantha, my lord, Honorable Mr. Justice Mantha, they, my lord, actually dismissed the writ application on the pair of the petitioner. It was, yes, my lord. Yes, ma'am. My lord, kindly go through the pair portion. My lord, kindly see the pair portion. And my lord, entire writ petition against the police authorities.
Yes. You could not show Kaushal Kishore to the coordinate bench.
Well, I think this has been delivered on 3rd January of this year. So, my lord, it was not available. But there were judgments. It's not that Supreme Court has said something new today. But this has become precise today, my lord, in view of this judgment. Please have a look to my lord, 2 paragraphs. My lord. Whatever, my lord, I have.
Sir, Dotto, I don't take up these kinds of matters before the holidays. Yes, which paragraph?
My lord, paragraph.
It's either liquor shop or now it's a jewelry shop.
Yes, yes.
No urgency.
Well, we must keep business running, my lord.
But so far state is concerned, my lord, state has, my lord, the police have nothing to do. My lord, unless and until, my lord, there is an order. My lord, the police have nothing to do. Only thing, the prayers are there. Their fundamental rights have to be protected by the police personnel. Now, my lord, what police will do when an association, they are, my lord, restraining them, that not to carry on your business on a particular day. Now, my lord, it is a fight between them. And my lord, another point, if your lordship allow me, my lord, to say, well, I think very technical, but since, my lord, a partnership firm is before your lordship, partnership firm is the petitioner number 1. And petitioner number 2, the partnership firm is being represented before the court by its manager, not by any partner. Order 30 Rule 1 that is not complied with. Lordship, kindly, my lord, if manager, even not a, my lord, any averment that the manager is, my lord, holding the power of attorney by the partners or other, the manager is now ventilating the grievance of the partnership firm in a writ court.
Yes.
Well, this is a registered partnership firm. My lord, the lordship will find from the cause title itself, and I'm told that the power of attorney has been filed with the original writ petition. Now, my lord, 2 paragraphs of this judgment. Please take, my lord, paragraph 12.2 at page 59. With the questions are framed, we are concerned about question number 2, 12.2.
Yes.
But this is a 4:1, my lord, the majority judgment that I'm placing.
Judgment.
Yes.
The Constitution itself sets out the scheme of claims of fundamental rights against the state or its instrumentalities, and it is also enacted in respect of breaches or violation of fundamental rights by persons other than the state or its instrumentality. My lord, rest, my lord, I don't trouble. Please now come to, my lord, page 83, para 83 at page 113. But lots of decisions might have been quoted, considered. Para 83, the last 2 lines, since your lordship is hard pressed with time. Last 2 lines at paragraph 83, my lord, in quotation in italics. A fundamental right under Article 19/21 can be enforced even against persons other than the state or its instrumentality. And, my lord, in question answer form, the last paragraph, paragraph 169.
Yes.
This, my lord, will find at page 1. I'm so sorry, my lord. 169 is at page 146.
Yes.
This is in the form of a, my lord, table. Please take question number 2. On the left-hand side, can a fundamental right under Article 19 or 21 of the Constitution be claimed against other than against the state or its instrumentality? The answer is a fundamental right under so and so can be enforced against you. Therefore, my lord,
So this was not known to the lawyers before this decision came.
no, it is there, my lord. In fact, all the decisions, my lord, have been collated in the previous paragraphs before para 83. My lord, I didn't trouble your lordship with those. And finally, my lord, it has been held that it is maintained. There are so many examples. For example, habeas corpus. Most of the habeas corpus, my lord, are against private individuals. And your lordship will find, my lord, from our writ rules also, it provides a separate paragraph that this can be moved against.
No, that's also 226(1), the language.
Therefore, these are, my lord, only to assist us. My lord, the law is always there. These are only interpreted, and my lord, these are tools in our hand. So, my lord, I respectfully submit, my lord, this is infraction of fundamental right. I can claim any order against the state also, provided I satisfy your lordship that Article 19 or 21 is being infringed. So, I respectfully submit, my lordship will kindly, my lord, pass appropriate orders so that I can run my business. And if required,
You are running your business?
no, not on Sundays. Saturday, up to Saturday, I'm running from Monday to Saturday.
Yes, Mr. Mondal.
Kindly come to page 22
Of
my lord, agreement writ petition. My lord, 7C.
Mr. Mondal, you have to come back on some other day, please. I can't carry on with this matter now. I have my partnered matters. When do you want to come back, Mr. Dotto?
Before the vacation, brother.
After vacation.
Any day before the vacation, brother. But I made my submissions.
Why I've been giving you leave to move the vacation bench.
Very
No, don't have the list of don't have the list of judges.
Not because of that, but it's very difficult to move pending matters before the vacation day.
Yes, heard learned counsel appearing for the petitioner and the respondent association, capital A, on the point of maintainability of the writ petition. Stop. List this matter tomorrow as prayed for.
Yeah. I'm grateful.
My lord, after that, there is a difficulty. My lord, so many matters faced. My lord, kindly after vacation.
Day after tomorrow.
What day after?
Day after tomorrow. On 18th August, on 18th May 2023.
I'm
as
grateful.
prayed. Yes, partnered matters, please.
Partnered matters, item number 285.
Mr. Sen, you were waiting. Mr. Mohammed, you were waiting for, yes?
29, my lord, demolition order has been given on mentioning it was upgraded. Yesterday we wrote the letter, matter is pending, so it has been stopped. Under the Jela Parishad who have applied, they are considering the granting lease. It is Jela Parishad land.
Dakota 289 to Dakota.
Under the wrong impression. I'm sorry for disturbing. Under the wrong impression that it is of 29. 160.
Oh, there's a demolition order?
Yes.
Item number 29.
Yes.
289. No, 29.
This is a Jela Parishad land. From page 18, it would appear.
Order issue.
Mr. Sen, what is it? Some demolition?
My lord, the order was passed, my lord, in terms of an earlier order of this court, whereby, my lord, may I tell only one thing, lordship, that here the private respondent, they filed a writ petition in earlier occasion when the writ petition was disposed of, directing the, my lord, the district magistrate to take appropriate step with regard to the said alleged unauthorized construction on private land. Now, my lord, what happened? On the basis of that order, my lord, the matter was taken up, and my lord, the district magistrate, my lord, passed the order. That is the impugned order.
Page 30.
And that impugned order is now challenged by the, my lord, the person who is now, my lord,
The writ petitioner.
writ petitioner. But my lord, only thing, my lord, may I tell, if you also kindly go through.
So where does it say that it will be demolished?
Yes. Yes. Now, my lord, the
No, where does it say that? Don't say yes. Where does it say that? That is going to be demolished.
page 30.
Yes.
The continuation of the earlier order. This is the order sheet. page 30 is the
To
final order.
remove the encroachment.
Yes, yes. Now, my lord,
But
But-
this is of December 2022. You have not taken any steps
now
till now.
certain, my lord, after going through this,
My lord, yesterday.
1 minute, please.
my lord,
Yes.
I think, my lord, this matter, my lord, the certain irregularities there is, my lord. I
Yes.
think hurriedly, my lord, though this point has not been taken by the writ petitioner,
Taken.
but after going through the, if your lordship, my lord, this, my lord, section 4, directly, my lord, he has gone to section 4 within bracket 1. Before that, my lord, he has to comply with section 3. That is, my lord, a preliminary inquiry first. Then, my lord, upon satisfaction, if your lordship, my lord, kindly come to, my lord, section 3
Yes.
of the act. Section 3 within bracket 1. But this is, my lord, my submission that the section 3 within bracket 1 has to be complied with first. Then, my lord,
So shall issue a notice.
yes, then, my lord, section 4. So this section 3.1, though this point has not been taken in the writ petition, but I think, my lord, being a, my lord, officer of the court,
Thank
my
you
lord,
very much, Mr. Sen. So
Huh?
he has
3.1
passed,
হয়েছে? কোথায়?
directed to
এখানে তো
remove.
নেই।
Yes.
Please, those who are coughing, leave the court. Yes,
Section 3.1 হয়েছে। কখন হলো? এখানে তো নেই।
the impugned order in the present writ petition is
Ma'am,
dated
শোকজ হয়েছে।
28/12/2022. Stop. And passed by the district magistrate, Purvo Medinipur.
এই তোমাদের
Stop.
শোকজ করেছিল আগে?
By the impugned order,
তাহলে তো বলতো।
the district magistrate has directed the subdivisional officer, Holdia, to take all necessary measures to remove all the encroachments over the government land.
Hold the.
হলদিয়া, yes.
Holdia to bollam.
হ্যাঁ। পূর্ব মেদিনীপুর, লর্ডশিপ, ডিস্ট্রিক্ট ম্যাজিস্ট্রেট পূর্ব মেদিনীপুর।
Subdivisional officer Holdia to take all necessary measures to remove all the encroachments over the land, as the land has not been given on lease under the provisions of the West Bengal Public Land within brackets eviction of unauthorized occupants, close brackets Act, 1962. Stop. Next. Upon considering the submissions made on behalf of learned of the parties, and particularly by learned counsel appearing for the state respondents, it appears that the impugned order was passed regardless of compliance of section 3 within brackets 1 of the 1962 Act, whereunder, under which, the collector is first required to form an opinion whether on information received
কারো পারমিশন লাগবে না, এখান থেকেই হয়ে যাবে।
that the public land is in unauthorized occupation of any person. Stop. The collector shall thereafter issue a notice calling upon all persons concerned to show cause before 15 days
At least before 15
show cause at least before 15 days from the date of the notice as to why an order under section 4 within brackets 1 shall not be made and shall also serve the notice in the manner referred to under section 3 within brackets 2 of the Act. Stop. Section 4 within brackets 1 comes at the stage after the cause shown by the person on who the notice is served is considered by the collector and a further inquiry is made if the collector so deems fit, stop. This is followed by the collector being satisfied that no bona fide dispute exists regarding to the title of the public land, and the public land is indeed in unauthorized occupation by the person concerned, stop. It is only then that the collector is empowered to make an order directing the person to vacate the public land and deliver possession to the owner, thereof to the owner. Stop. Where is the removal? Which section?
My lord, I think, my lord, the next section 5
Section 5.
refuses or fails to comply with an order made under clause 1 of clause A of subsection 4 within the time specified in the order within such further time, collector may allow again
Eviction of the person in unauthorized occupation is contemplated under section 5 within brackets 1 of the Act, and the collector is also empowered to take possession of the public land by evicting the person concerned. Stop. Next, the impugned order in the present case does not indicate whether the procedure under section 3 within brackets 1 and 4 within brackets 1 was followed, was complied with. Stop. The district magistrate has straightaway ordered removal of the encroachments without following the statutory mandate under the 1962 Act. Stop. Next, the impugned order dated 28/12/2022 is therefore quashed for the above reasons. Stop. WPA 1609.
Can you direct the authority concerned, my lord, to take steps according
the
to law?
authority shall not be precluded
Because there's an earlier
from
order of
taking
this court.
steps in accordance with law as provided under the 1962 Act. Stop. WPA 1609 of 2023 is disposed of in terms of the above.
I'm extremely grateful, my lord.
Yes, so call on the part of matter.
বলবে না।
Thank you, Mr. Sen.
Within the stipulated period.
Can't understand.
The period the district magistrate considered the second time, my lord, the
I have not said he's going to consider second time. Yes, next. Part of matter.
Parted matters, item number 285.
Lord, Lordship had kept this for two reasons. Lord, one is to file our notes. Lord, my note is ready. And Your Lordship had given me 2 minutes time to deal with the Bombay judgment.
But
Yes.
our notes are also ready. My lord, we've prepared a short notes as also my lord, we've prepared. My lord,
I can't hear you. Microphone, please.
My lord, we've prepared a short notes.
Yes.
Also, my lord, we've prepared a longer note with basically a distinction of all the judgments. There are around 30 judgments which have been relied upon by the respondent in their compilation, my lord. We've
Very well.
distinguished-
I will accept the notes if I feel like it. Yes, Mr. Sen.
Lord, insofar as the Bombay judgment is concerned, Lord, the Bombay judgment holds that the state legislature.
Let me have a copy of the judgment.
Yes, Lord. Acha, eta
My
copy.
lord, we had given a copy.
Yes, yes.
The Bombay High Court judgment. আমরা দিয়েছি petitioner. Bombay
Bombay High
High
Court এর জাজমেন্টটা দাও।
না না বম্বে সিঙ্গেল জাজমেন্ট আছে একটা এই জাজমেন্ট আছে
ওটা দিয়ে দাও।
My lord, your lordship can take my copy of.
No, 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 no. It's
Lordship.
already there.
Should be marked, my lord. ওইটাই হবে SLP আছে তার নিচে বলবে SLP নিচে রেখে আর ওগুলো SLP ডিসমিসাল হবে
Yes.
Lord, the first preliminary point, Lord, although it's not indicated in my note, Lord, this is a judgment of Lord Bombay High Court, only persuasive value. It's not binding on your lordship.
No, 1 minute, please. Mr. Sen, why this was placed for what point?
So this was placed by the writ petitioners on the ground that the Bombay High Court has held that the state itself does not have the legislative competence to fix rates for different charges in hospitals. If the state does not have, then Lord, the commission which is not created under a law made by the state will also not have.
Mr. Mukherjee, take your seat, please. Yes.
Now, Lord, the first preliminary point is this has only persuasive value. This is not binding on your lordship. The SLP from this judgment has been dismissed, but at the SLP stage itself. So, Lord, the judgment which we have to consider is the judgment of the Bombay High Court, a judgment which has only persuasive value. Now, Lord, I would like to, Lord, for a moment, take your lordship to, Lord, the Constitution, just, Lord, the 7th schedule for your lordship's convenience. If your lordship is pleased to first take Article 246.
Yes.
Lord, please take note, Article 246. 3. Lord, this gives the exclusive power to the state.
Yes.
To make laws. This is only subject to Lord list 1 and list 3.
Yes.
Now, Lord, please come to the 7th schedule. Lord, in the 7th schedule.
Yes.
Your lordship will not find any entry which relates to Lord, regulation of hospitals, except Lord, not in at all in list 1, which is the union list. There is no entry at all. Now, Lord, please come to list 3, which is the concurrent list. And the closest that your lordship will get in list 3 is entry 26.
Yes.
Which is legal, medical, and other professions.
Yes.
This, in my respectful submission, really is with regard to Lord, the profession of medicine. And it is in terms of this, Lord, that the Indian Medical Council of India Act has come in to frame regulations of how Lord, doctors would practice. Now, Lord, please come to the second list, list 2. In my respectful submission, Lord, our statute, Lord, the West Bengal Clinical Establishments Regulation Act, would be governed by Lord entry 6 of list 2.
Yes.
Lord, please have a look at entry 6.
Yes.
Lord, this is public health and sanitation, hospitals and dispensaries.
Yes.
Now, Lord, the point, Lord, which the Bombay High Court has considered says that in the Bombay High Court in its judgment says that although it mentions hospitals, it does not cover imposition of taxes, rates, fees, etc. And wherever the legislature has wanted imposition of rates, taxes, etc. to be covered by the entry, it has expressly said so. Now, Lord, this may be true with regard to taxes, because your lordship will find in entry in list 2 itself, taxes start from near about entry 46 onwards. the Lordship please takes entry 46 onwards,
Yes.
right till Lord, entry 62, your Lordship will find different types of taxes are mentioned.
Yes.
But so far as fees are concerned, fees is part of the residuary, Lord, entry 66. Lord, please see entry 66 and how it is worded. Fees in respect of any of the matters in this list, but not including fees taken in any court, because what is taken in court is covered by entry 63 and etc. So fees in respect of any of the matters in this list would cover the matter in entry 6, that is hospitals. But why tax is covered separately from entry 46 onwards is because insofar as tax is concerned, there is no quid pro quo required. The state can impose tax on any of the entries from entry 46 onwards. But for imposition of fee, there has to be a service rendered. No, that is the conceptual difference between a fee and a tax. In a tax, no quid pro quo required. In a fee, there has to be a service rendered. So when the hospital renders a service and it charges a fee, that would be covered by entry 6, read with entry 66. Therefore, there is legislative competence. That's the first point I would like to take. The second point is, there are.
But what is this with regard to the Bombay High Court judgment?
Bombay High Court judgment says in entry 6, it is not specifically mentioned that rates and charges, rates, taxes, fees, etc. are in entry 6.
Yes.
It says entry in nowhere in entry 6 do I find mention that it has the power to impose rates, taxes, charges, or fix rates, charges, taxes, or put a cap. I say, my lord, that entry 66 should be read with entry 6, and then the power is, my lord, read into entry 6.
Yes.
Lord, my second submission is, and Lord, this is well established by any number of judgments of the Honorable Supreme Court, that these entries are to be read in the widest possible terms. These entries don't give just the power, but they really give the field of legislation. And in this field, the appropriate legislature, whether it be the union or the state, as the list is concerned, has the widest amplitude of discretion to legislate on any aspect, which is incidental and ancillary or incidental, whatever is required to give effect to this is covered by the entry. So, my respectful submission is true that entry 6 should not be read in isolation. It has to be read with entry 66. And secondly, in any event of the matter, whenever there is a particular entry which gives the legislative competence to the legislature, then the entry has to be read in the widest possible terms and not in a narrow or restricted sense. So when a hospital is mentioned in entry 6, it means everything concerned with the hospital, including the power to fix rates, taxes, etc., rates, charges, the pricing, etc., everything. And it cannot be read in a truncated fashion or in a restricted or limited fashion. Lord, I've put this in my note, Lord, right at the end.
Very good.
Lord, our notes.
Lord, one other aspect which is covered by the Bombay judgment, which Mr. Banerjee had cited, is that insofar as Bombay is concerned, the legislative field is covered. Your Lordship will find in the judgment, it says that insofar as entry 6 is concerned, insofar as Maharashtra is concerned, there are already 2 state legislations which cover the field. Therefore, there is no scope for this legislation to be not allowed any further. In paragraph 19, the 2 prior legislations are mentioned, and the Bombay High Court says that the field is therefore covered. In our case, no, there is no field being covered. This is by repealing an earlier legislation. Lord, I put this in my note, Lord, right at the end, Lord.
Lord, our notes. Lord,
yes.
Lord, I'm sorry, I forgot one point. Lord, the last point, Lord, insofar as this judgment is concerned.
Mr. Sen, you better finish fast, because
Lord,
otherwise you will get a refrain every 2 minutes. Our notes.
Lord,
yes.
Lord, after today, I'm definitely going to take a dip in the Ganges. Lord, once this matter is over, so far as we are concerned, a dip in the Ganges. I was like the ancient mariner all along, Lord. Now the Lord albatross is off.
Yeah. Yes.
Now, Lord, the Bombay judgment has compared entry 6 with other entries in the same list and said, see, entry 23, entry 32 says XYZ things, which is not there in entry 6. Now, the Supreme Court says that when construing entries in a list,
Yes.
one cannot and one ought not to compare a particular entry with another entry in the same list. Each entry is to be read separately and independently. So, Milord, because the entry with regard to industry says it is with regard to regulation of industries, and the entry with regard to hospital does not say so, it doesn't mean that hospitals cannot be regulated.
Yes.
Look, this is the only point, Milord, that I had missed out, Milord.
Thank you.
Now, Milord, these two aspects of the matter that, Milord, the legislative, Milord, entries are to be taken in the widest possible terms, and Milord, one cannot construe one entry having regard to another entry. Milord, there are two judgments of the Supreme Court which I have indicated in my note.
Have you cited that?
I could not give, Milord, because this is, Milord, because of, Milord, the studying at
Mr.
the
Sen,
11th hour.
if you do that, then Mr. Mukherjee must have a chance to rebut or to respond.
These are very well established
No.
principles. Milord, I
If
put
there
it
are
in my
new
note.
cases, I will have to, then again, you don't want the matter to be,
I
the
wanted,
judgment to be
Milord,
delivered. What is it that you want?
the result of looking it up at the 11th hour, Milord, and I'm to be faulted, Milord.
Because he has already, he wants to file an exhaustive note distinguishing
Our
the
notes are
cases.
extremely short, my lord, because there were around 30 judgments. We've given a detailed distinction of those judgments, but my lord, it's just an additional note.
Mr. Sen, I am not going to keep this matter.
No, the proposition is well known. Milord.
Or maybe Thursday, just for 2 minutes for Mr. Mukherjee to respond to the cases. Is that what you want or no?
My lord, we have concluded, my lord. Those two judgments, the proposition
These are
of law,
well
my lord, we are not disputing.
What is the proposition of law?
Milord, one proposition is that the entries in the list are to be considered in their widest possible terms.
Yes.
And the second is when, Milord, one construing one entry, one should not have regard to the other entries.
Very good.
Well, we are not disputing this. Similarly, my lord, there's also a proposition, my lord, Division Bench of Calcutta High
You're
Court.
not
my lord.
disputing it because it's not relevant.
Well, I am not disputing this proposition of law. The proposition of law is absolutely correct. It's not relevant in the facts and circumstances of the present case. Also, my lord, importantly, there is also judgment, division bench judgment of this court, which says, my lord, when there is judgments on constitutional issues by other courts, then, my lord, this court is not going to not consider them unless there are compelling circumstances, my lord. So there are, I can cite that judgment
Very
also,
no,
Your Lordship.
please. I've had enough of
Yes,
this
ma'am.
matter. Yes,
Ma'am, we also
learned,
We also wanted to end.
the learned triple AG appearing for the commission, capital C, has distinguished the judgment, the division bench judgment of the Bombay High Court in Hospitals Association, Hospitals apostrophe Association, stop. Next, learned counsel appearing for the parties have also filed their respective notes in court today. Stop. This matter on 18th May 2023. Stop. In the event the matter is not taken up, the matter shall be treated as reserved for judgment.
Well, my lord is keeping it on 18 for any.
For my own benefit.
Oblige. We'll be there on 18th, my lord, if it's oblige.
It was part of matter. It's also only for them.
Yes, Mr. Sen, Mr. Mukherjee, I will at 18th तक कह रहा था
It's a partnered matter. My lord.
reserve. No, not for that. Not for that at all. I would
Any
be
queries,
happy
my lord,
to
we'll be happy to
palm it off to some other.
No.
Any query, my lord, we're happy to come back on 18th.
No. Reserve for judgment.
Yes. Deeply obliged, ma'am.
Original side.
Original side.
Original side, item number 1, Asif Latif versus the State of West Bengal.
Need please, Your Lordship. Extremely urgent matter, though it's a hearing matter, it has arisen. I am a bona fide tenant in respect of one shop room. The premises are owned by the Armenian church, my lord. The official trustee has now been given the power, my lord, to manage the properties amongst other powers. The official trustee acts under the Official Trustees Act. It can never dispossess a tenant. It can only take care of the management of the trust. If there's any problem relating to any tenant, appropriate applications can be filed, court can be moved for appropriate directions and the like. That's the Official Trustees Act. What the official trustee has done here is this is absolutely never heard of. The official trustee has come, threatened me to increase the rate of rent. I have said, no, I will not do that. Official trustee has said, you have violated the terms of your tenancy by inducting a third party. I said, no, he's my partner in an instrument business, which I carry on from there. As a counterblast, I have been locked out of my room. That is my writ petition.
No, and when did that happen?
This happened, my lord, December 2022. I am out of business since then. I have a number of instruments that are there, including a number of, I am told, German instruments, musical instruments, which are extremely valuable. The official trustee doesn't have the authority or jurisdiction under law to lock me out. It's unlawful restraint. It's a criminal offense. Had I, my lord, been a malafide tenant in breach of my
you
terms,
wanted your musical instruments back.
For the time being, my lord, my instructions are that those musical instruments can be taken out so that they can be sold if they are already not ruined.
You want to sell off the musical instruments? I thought you wanted to play them.
My lord, I deal in musical instruments, my lord. I wish, my lord, I was, but it appears that the only violin which is being played is by Nero, my lord, the official trustee.
No, but I thought that is the way, that is the reason why I decided to agree to enlist the matter.
My lord, my instructions are that, my lord, we deal in musical instruments, and there are a number of musical instruments, especially of German make, my lord, which are inside, which are now really not being taken care of. My interim prayer would also be, if your lordship will kindly consider, if the official trustee can show any layer of authority backed by any law to lock me out of my premises, my lord, I shall be out of court. Perhaps this is something which cannot be done.
But you have been locked out since December 2022.
I am penniless. I have mentioned, my lord, I've mentioned this matter, my lord. My instructions are about 5 or 6 times or 7 times. Immediate cause of action, my lord, was not there, my lord, because it had happened in 2022. I had mentioned it, I am told, in January, in February, in March, and twice in April, thereafter in May.
Yes, you are the official trustee. Yes, microphone, please.
My lord, we have no objection if they want. My lord,
Yes.
I have no objection if they want to take back their musical instrument, my lord. They have
How many? How many of them? Yes, Mr. Banerjee. How
My
many?
instructions are that there are many. I do not have an immediate list of what there is. But if someone goes, my lord, if I retrieve it in the presence of anyone appointed by court, so that I will not take out, my lord, those things. Second, and I'm saying this for the consideration of my lord, I am also entitled, my lord, to enjoy my tenancy. It's not been terminated by anyone. Until he gets a decree of eviction from a competent court of law and gets me out, I'm entitled to enjoy my tenancy, my lord. Even if I am assumed to be in breach, that breach can be taken care of by the courts of law by granting a decree of eviction. I cannot be locked out of my premises.
What is this locking out business for? Microphone, please.
My lord,
Microphone, please.
my lord, they have sublet to somebody else, my lord. That's why the official trustee has taken
Sublet.
sublet.
And that is not permissible under which law? Yes, who are you?
The respondent number 4, the
Who are you?
Armenian respondent number 4, your lordship. The
Who is
Armenian
that?
Church, the Armenian church, your lordship.
Yes.
At the Armenian college. Lordship, this premises belongs to me, your lordship. They were inducted as the tenant. It is governed by the Armenian church scheme, wherein the official trustee is the custodian of the property. Now, without my knowledge, your lordship, this has been there. The tenant has entered into a subletting, your lordship. Thereafter, this was being informed, and on that, your lordship, the official trustee has the authority under the scheme to they had come for an inspection.
Under which scheme?
Your lordship, is the Armenian church scheme, your lordship.
Yes.
Which specifically provides that any subletting and anything done with the properties of the Armenian church has to be by obtaining an order from the Honorable High Court. Nothing can be done. And the official trustee remains the custodian. So thereafter inspection was done and thereafter it was put
Very
under
well.
lock
Mr.
and key.
Banerjee, until this disputed issue is solved, I can give you that interim relief.
Yes, we'll take
That
out our
you take
instruments.
out your musical
We'll
instruments.
take out our instruments and deal with them. In the meantime, my lord, kindly hear us also on the other side of the vacation whenever it is convenient to your lordship. I would reiterate at the risk of being reprimanded, unless backed by law, I cannot be locked out of my premises, even if I am the most.
That we shall see whether the scheme provides or the scheme says that you cannot sublet and whether you have sublet.
I have not
That's a
sublet.
factual issue.
Braganza was my partner from the very beginning.
Lordship, if I may be allowed to only
Yes.
indicate your lordship, those instruments, those musical instruments which are lying, those are lying for the purpose of repairing your lordship. Lordship, perhaps he should be instructed on that, your lordship. Those are only
Repairing.
lying for repairing your lordship.
So let him take it out. What? How are you? How are you
There are
concerned?
other assets of the Armenian church also, your lordship.
So he has been locked out. So let him take out the instruments.
I'm deeply obliged.
Whether it's for repair, whether it's for sale, how are you concerned?
I'm deeply obliged.
Yes.
Lordship.
And who will? I'm going to appoint somebody who
Someone
will
will be-
oversee the.
Yes.
And your representative and
theirs will be present.
and the Armenian church.
Church will be present.
Lordship.
Some representative.
My
Yes. The petitioner is admittedly has admittedly been locked out of the premises in question since December 2022. Stop. Learned counsel appearing for the petitioner submits that the official trustee has virtually evicted the petitioner without authority, without authority of law. Stop. Counsel refers to the Official Trustees Act. Which year?
1913. 1913.
1913, to say that the official trustee does not have the power to take the impugned step. Stop. Counsel seeks a limited interim protection in terms of retrieving the musical instruments inside the premises. Stop. Next. Learned counsel appearing for the Armenian Church / respondent number 6.
Number 4, your lordship.
4 submits that the petitioner has unauthorizedly sublet the premises, which the petitioner is not permitted to do under the scheme of the Armenian Church. Stop. Next, the issue whether the petitioner has sublet the premises contrary to any existing scheme of the Armenian Church. It's Armenian College, not church.
College, your lordship. It is under the church.
Armenian College. Armenian College is required to be examined on affidavits. Stop. However, comma, as an interim measure, comma, the petitioner shall be permitted to take out the musical instruments which are lodged inside the premises. Stop. Mr. Blank is appointed as a special officer to oversee and supervise the retrieval / taking out of the musical instruments lodged inside the premises situated at
56C.
56C Mirza Ghalib Street, Kolkata.
56C Mirza Ghalib Street.
Kolkata 7,16,000.
Stop. Stop. Next, the remuneration of rupees blank of the special officer shall be equally borne by the petitioner or equally borne?
Borne by the petitioner at the first instance, my lord. At the first instance.
Shall be borne, BORNE, borne by the petitioner at the first instance. Stop. Next, the respondents shall be at liberty of filing their respective affidavits in opposition within
It's exchanged. My lord. It's complete. Affidavits are complete.
Where? List this matter. Affidavits are complete in the matter.
I'm
Stop.
filing my reply, not an opposition reply.
The reply is filed in court today. Capital R. Stop. List this matter on 14 June 2023.
Obliged, Your Lordship. Deeply obliged.
Grateful to Lordship.
Lord, the special officer appointed by court, Lord, will give a notice of the time and date when he will go.
Yes.
That part, Lord.
The special officer will give an advance notice of the time of the
Time and date of his visit, my Lord, for the
time and date of his visit, including for the taking out of the instruments to a representative of the petitioner as well as to a representative of the respondent number 3.
May I suggest, Lord, the respective advocates on record of the petitioner and the respondent number 3, because otherwise, Lord, their
Respondent
representative may
number
be.
3 is the officer in charge.
Respondent number 4, the learned advocates on record.
Four, Habib.
Learned advocates on record of the.
The representatives may be the respective advocates on record of the parties.
I'm obliged, Your Lord.
Next.
Your Lordship.
Adjourn motion, item number 2, square foot assets, management and reconstruction.
May it please, my lord.
Yes.
My lord, I appear for the defendant number 3. I've made substantially, I've completed my arguments. I'll sum up, and there are 1 or 2 other points that I want to press before my lord. If my lord sees the prayers at page 43 of the petition, what they are seeking, and then I'll just explain the points that we have contained.
Yes.
This suit has been filed by 1 Square 4 and then the trustees.
Yes.
So first they want an injunction restraining me from inducting third parties. And our main contention is the suit itself is not maintainable at the behest of the defendant, plaintiff number 1 in any event. So, and this application has been filed in 2016 and there's no interim order as yet, my lord. Then, my lord, receiver to make inventory, the same thing. Then what concerns us really is C and D, occupation charges payable by the defendant for the areas occupied by each be determined and ascertained by this court. At this stage, the suit is filed. Well, if I can show that I was a tenant or a lessee, more than the last paid contractual rent, there's no question of assessing occupational charges at this stage. Usually post decree in execution stage, courts sometimes direct that you pay the prevailing market rate, etc. So this doesn't even, this time has not even arisen. Then, my lord, prayer D is to collect the receiver to collect these occupational charges and to continue. And prayer F and G are to do with municipal taxes. Now, municipal taxes are being paid by Steel Authority of India directly to the corporation, and there is there was an assessment which was challenged. There's a division bench order by which all these claims have been stayed, and we are proceeding. So those 2 decisions I'll show, my lord. So if I may hand over, my lord, a compilation for the other side of the decisions that we will be relying on. I've already given them the citations to my lord during my earlier argument. If my lord see, I've just indicated the paragraphs. If my lord just notes down what each decision is. The first one, 1979.
Mr. Ghosh, you will have to at least give a heading as to who is giving this compilation.
I'm sorry, my lord. It's defendant number 3.
Yes.
So the first case, 1979 for SCC 60.
Use the microphone, please. Yes. Yes. What kind of print is this, Mr. Ghosh?
This is the.
You can read it properly.
Yes. It's small, but the pages are more or less clear, man.
Yes.
This is true print. True print. And paragraph 26. If my lord comes to page 10,
Yes.
The point we had taken was that when the suit was filed, all the trustees of the trust were
Yes.
not parties. They have been added subsequently,
Yes.
subsequent to this application being filed also.
Yes.
That's the one point, and the same point of law is applicable equally, that the trustees have given a lease to the plaintiff number one, but all the trustees have not signed on the lease. So, I had shown section 47 and 48 of the Trust Act, which say that they have to act in unison and all together. They cannot delegate their rights, the trustees. So, when the point was taken, they made an application to be added. Thereafter, the trial court refused to add them and says whatever the consequences is, the suit is bad. In the appeal court, they were given leave to cure, but there's one important part in the appeal court order. I'll again highlight that. Well, it says that whether this addition of party will relate back to the filing of the suit or not is left open. And directions were given so that the suit be heard out. But they took no steps to have the suit heard out. They revived this old injunction application, which was pending from 2016. So I'm saying that number one, the suit as filed is not maintainable, was not maintainable. Then this application, when it was filed, is not maintainable. And in fact, this application, the verification has been done only on behalf of 2 trustees. There are admittedly 4, or now 5 trustees now. And it was done by a constituted attorney. The trustees cannot delegate this power also. That was another point I've taken. So in that connection, to cover both the points, that the suit is not maintainable and the lease given to the plaintiff number one is not maintainable. These are the first 2 cases relate to that. If my lord takes paragraph 26, the law governing the execution of trusts is well settled. In case of a private trust where there are more trustees than one, all must join in the execution of the trust, and the concurrence of all is in general necessary in a transaction affecting the trust property, and a majority cannot bind the trust estate. So admittedly, my lord, all the trustees are not signatories to the square for lease. All the trustees are not signatories to the plaint as filed, and certainly not in this application. Then in order to bind the trust estate, the act must be the act of all. They constitute one body in the eye of law, and all must act together. This is, of course, subject to any express direction given by the set law. No such direction has been shown. Now, if my lord comes to paragraph 28 at page 11.
Yes.
And an earlier 1962 Supreme Court is quoted. This court observed that all the acts done by the trustee intend to take for executing the trust must be taken by all of them acting together, as provided under section 48, which provides as follows. When there are more trustees than one, all must join in the execution of the trust, except where the trust requires separately. Then paragraph 29, it is axiomatic that where there are more trustees than one, all must join in the execution of the trust, except where the instrument so provides. Therefore, it is laid down by this court in Janakrama Iyer's case, if the validity of an alienation effected by trustees falls to the considered only in the light of section 48, the fact that out of 3 of the trustees, only 2 have executed the sale deed would by itself make the transaction invalid and would not convey a valid title to the transferee. So prima facie, plaintiff number one has no locus standi, since the lease under which they are claiming is bad in law.
So, Mr. Ghosh, the point of this case is what? That all the trustees must join in the action for execution of a trust.
Yes, in a suit filed by a trust also.
That is
all
paragraph
the trustees
26.
Must, yes, paragraph 26, 28 and 29.
Yes.
And finally, my lord, paragraphs 30. Yes.
Yes.
That's under section 48. All must join. And my lord will see paragraphs 31 and 32, which also refers to section 47, that they cannot delegate.
Yes.
That's page 12, my lord, paragraph 31. It is not disputed that the trustee cannot delegate his functions except as provided under 47, which reads, page 12.
Yes.
A trustee cannot delegate his office or any of his duties either as co-trustee or a stranger unless the instrument of trust so provides and the delegation is in the regular course of business or the delegation is necessary, or the beneficiary being competent consents to the delegation. So, and in similar vein, my lord, the next case, 1973 Gujarat,
Yes.
my lord. So I'm relying on the first case. I've mentioned the paragraphs I'm relying on in the index. Then page 22, the next case begins. 1973 Gujarat 113 AIR.
Just give me the point, please.
Yes. Same point, paragraph 9, 10, and 11 about the decision of the trustees to act together. Paragraph, they are at page 25, my lord.
This is also on sections 47 and 48 of
47
the
and 48.
1882 Act.
And it's specifically, it's about granting of a lease. That's why I want to show this.
Yes.
Well, paragraph 9, this decision
Mr. Ghosh, don't place the paragraphs, please.
well, paragraph 10, if my lord sees that if granting of a lease is a matter which cannot be delegated by the trustee. So that is a repetition, my lord, of the same principle, but that's to do with a lease. Then finally, my lord, 1974 Calcutta 16 at page 28.
Yes.
I'm relying on paragraph 7 that begins at page 29.
On which point?
On the same point that the suit could not have been filed if all the trustees were not there, my lord. Paragraph 7. Mr. Mitter next contended.
No, no, don't place it.
Very well. So these three cases are on trustees.
Very well. Yes,
then
next.
The 1926 Madras, well, that is that the view of at least the Madras High Court was this cannot be cured.
Next case is some Law Weekly. What is that?
Yes, this is a very old case, 1926 Madras, my lord.
Yes.
Which is at page 33, it begins. It's taken from an old decision, my lord.
Where are you finding the citation? 1926 Madras?
Printout has revealed this document, but it is 1926 Madras. This is, of course, the printout of the Law Weekly. And on the top right-hand corner of at page 34, the 1926 is written. And the page number is, of course, different. It's 378.
No. So what is the citation?
Then we'll clarify that I should give the AIR citation. When I've given the reference from the AIR, I think this has come
So
from
the
the
index
SCC.
says 577. Is that correct or not correct?
Not 577, 377. Page 33.
Look at your index, Mr. Ghosh. It says AIR 1926 Madras 577.
Yes, that is the AIR.
Yes.
But the Law Weekly judgment has been given. Yeah.
Very well. What is the point?
Well, the point is, well, if the trustees were not on record initially, this cannot be cured. That is the point. I'll just point out the relevant line. It's just a one paragraph judgment, begins at page 34.
Yes, where is that line?
So here the suit was not held to be not maintainable. They carried out an amendment. Thereafter, the appeal court, they set aside. The last three lines on page 34, if my lord sees, we do not think that this is a case in which the amendment of this kind should have been allowed. For allowing an amendment, different sets of plaintiff different sets of plaintiffs were introduced into the case and their cause of action would be different from the cause of action set up by the present plaintiff. The committee of 1915, or if such committee is not existing now, the villagers are entitled to sue. When a person, this is the point, when a person brings a suit alleging he had the right to sue, and when it is found that he has not the right, the court would not be justified in directing an amendment of the plaint in order to enable the proper party to sue.
So there is an amendment here.
Yes, so they brought an amendment and they
Yes.
were allowed to bring in the other two trustees. Now there are 5 trustees. They have not amended their petition per se, the plaint has been amended. Now this now if my lord comes, before I come to the Nagpur point, page 80 of this compilation, 80. Nagpur,
Yes.
80. This is the order of the division bench, page 80, 23rd December. I had
Yes.
placed this before my lord.
Yes.
Now, here the other trustees were brought on record, but it is important that this incorporation was not deemed to be from the beginning. So if my lord comes to page 82, in light of the such legal position, the trial court was persuaded to hold that since the suit we had cited these 3 cases that I've cited before my lord, before the trial court, that since the suit was incurably bad and the plaint relating to the same had to be rejected, it is evident from the impugned order that nothing therein precludes the institution of a fresh suit in respect of the selfsame subject matter. The principal contention of the appellants is that since there may not be any question of limitation, the failure to implead all trustees should not be deemed to be fatal to this action, and the other trustees could be added as co-plaintiffs for the suit to be pursued. The appellants submit that an appropriate amendment application has been filed. Some of the defendants say that in view of the fact that the institution of a fresh suit will lead only to the multiplicity of proceedings, they are agreeable to accept the proposed amendment for the original and the newly added plaintiffs to carry on the action, but they say that the application under Chapter 13A of the original side must be abandoned. It is submitted by the appearing defendants that the very basis of the first plaintiff being a party to the action, that is the lease of his, and the purported rights claimed by the first plaintiff, here he is asking for occupational charges, eviction, etc., are in doubt, since only 3 of the trustees executed the subsequent lease.
Yes. I've read the order, Mr. Ghosh.
If my lord comes to the next page, 83.
No, Mr. Ghosh, I will give you 5 minutes tomorrow. Please complete the citations.
Yeah. My lord, I'll finish this point, my lord, that only one thing,
Yes.
page 83, where it says, it's important. Similarly, it is submitted that they do not object to the proposed amendment, but such incorporation would not amount to their admission of any statement in the plaint, and it may also not be deemed to be an admission as to the permissibility of the action, or any admission as to the rights of the first plaintiff or the trust to seek. So I had reserved, the defendant's right is reserved. And then the question is left open whether this will take effect from the beginning or not. There's a section in the Limitations Act, it's not in I haven't shown that yet, section 21, which says that when a party is added, his cause of action starts from his date, the date he is added.
Yes.
So, on that principle, my lord, we are saying that this application is not maintainable at all, because when it was filed, it was incurably bad. They have been given so that they didn't have to file a fresh suit. New trustees were added, and this division bench order directed the suit to be heard. Then all these issues are open in the suit. So my lord, I have my note. I'll shorten it a bit. It's 3 pages.
If finish with your compilation, then you can hand up your note.
Yes. So
Yes. Learned counsel appearing for the respondent number 3.
I've got 4 more decisions.
Relies on a compilation of cases. Stop. Counsel shall complete citing the cases on 18th May 2023. List this matter on that date. Call on the next matter, please.
court application, item number 3, Dinesh Kumar Birla versus Institute of Cost Accountants of India.
Well, the applicant is a member of the Chartered and Cost Accountants. Well, this is divided into different chapters depending on the zones.
regarding?
Well, Chartered and Cost Accountants.
Yes,
Well,
yes.
Cost and Works Accountant. I'm sorry. Well, this is divided into different zones across the country. Well, each zone, well, it has its own constitution, but well, ultimately there is the election rules of the Cost and Works Accountants which governs the matter of elections. Now, well, this gentleman, well, had applied, well, for filed his nomination. Well, his filing of nomination is well reflected. Then, well, he was well disqualified. Well, that is well the reason under.
So he was disqualified from
Malad-
being elected as what?
No, from being elected, Malad, he is filed his nomination for being elected to the post of chairman
Chairman
of the Ahmedabad chapter
Ahmedabad chapter of the?
of the Institute of Cost and Works Accountant.
Very well.
I should just show you, Lordship, it's very short. Well, kindly see, I should just show you, Lordship, the rules. Well,
So this is ICWAI.
ICWA.
Well, this, there is the Institute of Chartered Accountant and there's also Institute of Cost Accountant. Now, this is the one of the things where the headquarters are still, Milord, in Calcutta. Both Institute of Chartered Accountant and Institute of Cost Accountant.
But Mr. Shah
It's
mentioned
cost account-
Ahmedabad.
No,
Yes.
it's Milord.
No.
I will explain to
But
you.
Malad, the Malad office is here. So Malad, everything happens here.
No, yes.
The challenge is
that-
here.
no, about jurisdiction, I'm not
Yes,
saying
yes.
it.
But if your Lordship will just kindly take up the rules once. Malad, I've just handed up the.
No, I just need to understand the matter before council starts speaking.
Yes.
So this is with regard to the disqualification from
Of
the
my lord-
petitioner acting or being elected as a chairperson of the Ahmedabad chapter.
Yes, Malad. Malad West Zone.
Milord, let me clarify. You see, it's divided. This is the central zone elections which are being taking place. Every 4 years, we have these elections. Milord, 2019 was the last election, is going to end in 2023. So, Milord, central, Milord has to have its body. It is divided into 4 zones: north, south, east, west. Now, Milord, there are selected number of members from each zone. Apart from this, there is also at the same time something called a regional council. So, regional council, apart from western, eastern, southern, and
No,
northern.
so regional is different from a zone.
The regional election is different, but at the same time, through different notification, there is a different in gentleman here is already serving a part of the western region. He's already serving as a council member, but now he wants to stand for this election, Milord, as the central. That's my instructions.
Very well.
Well, my lord, very briefly, my lord, there are rules which says that who can, my lord, file nominations, who can, my lord, stand for elections, and who can, my lord, offer himself for elections.
Yes.
Now, my lord, these rules, my lord, say very clearly that you should not have any arrears or outstanding dues. My lord, so far as I am concerned, my lord, I have to have my certificate renewed every year. For that, my lord, I have to obtain a no dues situation. My lord, I have
Dues with regard to what?
my lord, dues with regard to membership fees and other things. Now, my lord, I have never, my lord, received any intimation of any outstanding amount. My certificate has been renewed. My lord, I have, my lord, been shown to have, my lord, nil dues, my lord, in the records of, my lord, the institute. But, my lord, thereafter, my lord, after I filed my nominations, my name is reflected in, my lord, the, my lord, nominations. But thereafter, my lord, I'm, my lord, disqualified, my lord, by saying that, my lord, I have not paid a sum of 472 rupees, which apparently was, my lord, a debit entry in my account in 2019. Now, my lord, 2020, my lord, no such allegation. 2021, no such allegation. 22, no such allegation. Now, my lord, this suddenly surfaces. My lord, obviously, my lord, to prevent me from contesting the elections because, my lord, as Mr. Bose has said, that I am already a standing council member, my lord, for the central zone.
Why would the institute be
No,
interested
well,
in
it is-
preventing you?
Because, my lord, the person, my lord, who is presently, my lord, the helm of affairs of, my lord, the institute, my lord, appears to, my lord, be backing a candidate. But, my lord, I'm not going into that. Well, I just want to show you, Lordship, the rules and, my lord, whether today, in terms of the rules, my lord, I'm, my lord, in violation and therefore, my lord, liable for disqualification.
No, but if it's 420 rupees you paid,
I would have happily paid it, my lord,
that is
yesterday.
the only reason given.
That is the only reason. That is the only reason. Well, that is what I wanted to show your lordship. And my lord, they my lord have
No,
kept
not
me-
in the metaphorical sense.
no, no.
Very well. Yes,
That is my lord in the real actual sense.
yes.
Well, Lord, kindly, my lord, just see, my lord, my lord, kindly see the rules once. I just want to show your lordship, my lord, the rules.
No, no, just show me, Mr. Mr. Shah, what is the challenge?
But
What
kindly
have you
see,
come
my
up?
lord, challenges to my lord, page 32. My lord, this is my lord.
30th April.
Yes, my lord,
What does it say?
30th April.
And the returning officer is who?
My lord, Kaushik Banerjee, my lord, is the returning officer. My lord, I don't know, my lord, what his designation is.
No, returning officer we usually have for elections.
Yes, it's for the elections.
Yes.
My lord, kindly see, my lord, this is addressed to the writ petitioner. My lord, on the 30th of April.
Yes.
This has reference to your nomination for election to the council for 2023 to 2027 from the Western Indian Regional Constituency. Your nomination has been rejected by the panel for scrutiny of the nominations constituted for elections to the council and regional councils 2015 at its meeting held on 29th April 2023. In terms of sub-rule 11 of Rule 12 of the Cost and Works Accountants election to the council rules as amended, the statement of reason for such rejection is quoted below, that it has been intimated by Ahmedabad chapter by email dated 21st April 2023 and confirmed by Director Finance by note dated 25th April 2023 that Dinesh Kumar Birla, membership number such and such, is having other dues amounting to rupees 472 since 12th July 2019, which is also reflected in the annual accounts of Ahmedabad chapter and admitted by him by email dated 17th
So this
July.
is the only reason given,
This is the only
472.
reason. That's right. Only reason.
Yes.
Now, my lord,
Mr. Bose, what is this? It's only 472.
Yes, yes, but my lord, this is a statutory body where notifications are issued upon scrutiny, my lord, and dates are published in the official gazette, my lord, notification. The election process with entire thing has been scheduled, ballot papers without his name is there, and my lord.
No, when is the election due to take place?
1st July.
But
1st July, the ballot papers have not yet been printed.
it has already been printed. It has already been printed and we
Mr.
cannot do
Bose, if
anything.
it's a matter of 472.
That is why,
what
because the rules say so. We are unable, we cannot do anything. The scrutiny committee headed by the government officials, they've scrutinized and found there's a shortfall, whether it's 1 rupee or 2 rupees.
Well,
is
they could have
immaterial.
simply called
It's not-
upon me to make payment. I would have done so, my lord,
It
without
cannot,
making an
it cannot be done. It can kindly see, my lord, what is happening. You see the rules. Just have a look at the rules and you will understand, my lord.
Very well. Yes, Mr. Shah.
My lord, kindly, my lord, just see the rules once. My lord, I have to just satisfy.
I
your
cannot
lordship
do
since-
anything.
My lord, I have
Yeah.
handed up a my lord, copy of the relevant rules. My lord, kindly see, my lord.
12-11.
No, before 12-11, my lord, Rule 5 once. Members eligible to vote. Now, my lord,
12-11 is not part of this. Of
no, my
the,
lord, this is my lord, 12-11 is where they've intimated to me the reason for my
No,
disqualification.
that is also under a notification.
Well, I shall
I
hand up
have
my
the
lord.
book. If you want the book,
Well,
I can
I'll give you a lordship 12-11.
That doesn't matter. I don't want to look at anything which you don't want to rely on. Yes, tell me which one.
No, but I want to rely on that.
My lord, Rule
Yes.
5.
Rule 5. Yes.
My lord, this talks about, my lord, members who are eligible to vote. My lord, this is relevant because, my lord, my name has been reflected as a member eligible to vote. My lord, kindly see, subject to the other provisions of these rules, member whose name is borne on the register and his entrance fees, annual membership fees and other dues are not in arrears on the first day of October of the year immediately previous to the year in which the election is to the council is to be shall be eligible to vote. My lord, I shall not read further.
Mr. Shah, what rules have you handed up? I don't find anything of all this. You've handed up the 1959 regulations.
My lord, let me, my lord, hand up. My lord, kindly excuse me, my lord, this is.
No, there is rules, election rules
No,
of
no,
2006.
you've handed up something else to me.
Why have you given that? Give the rules.
I can give you
Well,
the
I
entire
shall hand up, my lord, my copy. Kindly forgive me, my lord.
No, you use that, Mr. Bose. Give me your
I'll
copy.
give.
Yes.
My lord, Rule 5, my lord. Members eligible to vote.
Yes.
Subject to the other provisions of these rules, a member whose name is borne on the register and his entrance fees, annual membership fees and other dues are not in arrears on the first day of October of the year immediately previous to the year in which election to the council takes place shall be eligible to vote in the election. Well, I shall not read further. So, my lord,
This
my
is
name.
eligible to vote. You
Vote.
want to
Now, my lord,
contest.
I say that, my lord, my name appears in the voters list, so I'm eligible to vote. according to the council, which means, my lord, there are no arrear dues. Now kindly see Rule 7. Members eligible to stand for election. Subject to other provisions of these rules, a member who is a fellow and his entrance fees, annual membership fees and other dues are not in arrears on the first day of October of the year immediately previous to the year in which an election is to take place, and whose name continues to be borne on the register on the last day of scrutiny of nominations under sub-rule 2 of Rule 4, shall be eligible to stand for election to the council from the regional constituency in which he is eligible to vote. My lord, this is all that I need to show you, lordship. So, my lord, today I should have cleared all
Is there
my
a discussion in the matter or no?
No, my lord, I don't see, my lord, as to how, my lord, there can be no discussion, because if there's something outstanding, the normal reaction will please pay it up. Well, if there is, my lord, anything outstanding. Now, my lord, I shall just show you, lordship, 2 documents. Well, kindly see, my lord, my lord, my complaint at page 101, which has, my lord, not been responded to. Well, kindly have a look at page 102.
Yes.
The returning officer has issued notification number such and such, titled dates of elections. The said notification contains the voter list for the election to the Council for Western Region. In the said voter list, my name appears at voter list number 72, page 19 of the notification. My name, Birla Dinesh Kumar, membership number 7907 is clearly mentioned in the voters list. I would like to bring to your notice the cost and worst corresponding election to the council rules, my lord, which says, my lord, if today you have cleared all your dues, then, my lord, your name will appear in the voters list. So, my lord, that is the first point. My name appears in the voters list. Second, my lord, kindly see.
So that's it's a different rule.
No, it's the same election rules. My lord, members who can vote and members who can, my lord, offer themselves for election. Rule 5 and Rule 7. So, my lord, my first contention
So
is
this
you have.
refers to Rule 5.
Yes. My first contention is you've accepted me as a member who's eligible to vote, which means I've cleared all my dues. Then, my lord, kindly see. Then, my lord, I say, my lord, paragraph 2, I would further like to state that I'm a practicing cost accountant, and as such, I renew my certificate of practice on a regular basis. While renewal of the certificate of practice, it is ensured by the institute that there are no dues against my name. Even today, my membership login information was not showing any dues against my name. 3, I would also like to state that I had not received any communication from the institute regarding the debit note against my name in the books of the institute, and any reminder for payment of the same was never received from the secretary of the institute, and hence I was not aware about such payment due at my end. And then, my lord, I have quoted, my lord, Rule 7. I have said that, my lord, this is not, my lord, other dues. My lord, this must be, my lord, entrance fees, membership fees. My lord, it must be in that context, my lord, other dues must be, my lord, held. Now, my lord, kindly see just 2 more documents. My lord, we'll kindly have a look at page, my lord, 107, 106.
Yes.
Well, this is the members' online information. Well, kindly see, well, this is my information at the bottom of the page. Member number 7907, which is my number. Kindly see fees, well, then entrance fee, fellow, 0 amount, fellow membership fee, 0 amount. So, well, nothing is due.
Page 106.
106, my lord, at the
Yes,
right-hand
yes.
bottom.
Yes.
Well, at 107, and my lord, these are all 2023. 107, 17th March 2023.
Yes.
My lord, kindly see, my lord, a receipt issued to me by the institute. Fellow membership fee 1,500 paid up to 20th, 2022, 2023. Then certificate of practice fee renewal 2,000. Then, my lord, next page. My lord, this is, my lord, the renewal of my lord, certificate of practice till 2024, which does not happen without payment of fees. And, my lord, today, my lord, I have shown you, lordship, the reason. Says you have not paid 472 rupees. My lord, they have not shown me when, my lord, they had called upon me to pay these fees. It is possible, my lord, that at some point of time, there may be some, my lord, debit outstanding. But, my lord, the natural, my lord, consequence would be, please pay it. And, my lord, I am instructed that I had offered to make payment and they did not accept it. My lord, it's a valuable right. A right to, my lord, contest, my lord, an election is a valuable right. My lord, today, my lord, that cannot be trifled with, my lord, for 472 rupees. Obviously, my lord, there's a larger game at play. But today, my learned friend says it's inflexible, the rule. Now, my lord, my lord, do not have to go into that. The question is, my lord, whether, my lord, you have called upon me to make payment, I have refused to make payment. Or, my lord, whether I am actually in arrears, so far as membership fees, fellowship fees, practice fees, certificate fees, etc. are concerned. None of that is in arrears. My lord, this is the sole reason. And my lord, the object is clearly to, my lord, keep me out of the elections. Otherwise, my lord, 472 rupees cannot be, my lord, an issue. Cannot be, my lord, the real, my lord, object behind, my lord, really keeping me away. And where my learned friend says that ballot papers have been printed, my lord, processes have been started, my lord, the elections are to be held on the 1st of July. Well, I do not want the elections to be, my lord, postponed. It's an all India election held, my lord, for different chapters at the same time. But, my lord, I must be allowed to contest the elections. Well, what I was humbly praying for, my lord, at this, my lord, stage, if your lordship, my lord, allows me, my name to be, my lord, included in the ballot papers, and then here's out the matter, my lord, on the reopening of the courts.
So that's the final relief.
No, my lord, that is why I'm saying that kindly allow my name to be included. My lord, my name can always be directed to stock off before the elections. My lord, today, if my lord, ultimately my learned friend is already saying that, my lord, ballot papers have been printed. Now, my lord, today, he will, my lord, then, my lord, after, my lord, another 15 days, my lord, say that, my lord, the situation has become further irreversible. So, my lord, all that I'm praying for at this moment is let my name be included, subject to orders of the court, my lord, the final hearing of the matter. We can, my lord, come back, my lord, with affidavits, my lord, very shortly.
Yes, Mr. Bose.
Yes, my lord, just a few things. My lord, kindly take just 3 rules I will point out. My lord, if your lordship sees rule 3. My lord, rule 3 says that basically that regional constituency which I was telling your lordship, my lord, as listed in schedule 1.
Yes.
My lord, rule 3 mentions as listed in schedule 1. My lord, schedule 1, you just have a look at schedule 1. It's at the end of this rule. You will find, my lord, there are 4 constituencies mentioned.
Yes.
Now, my lord, we are concerned about the Western India regional constituency.
Yes.
And he says he's from the Gujarat chapter. My lord, you will find comprising of states of Chhattisgarh, Goa, Gujarat, etc., in the schedule itself.
Yes.
Now, my lord, so, my lord, for these Western, Southern, Eastern, Northern, my lord, simultaneously there is separate election going on for the regional. My lord, in respect of which for the he is already serving, my lord, in the Western region. He's already serving in the Western region.
Serving as what?
As my lord, as a council member of Western Regional Council member. That he has said, my lord, in the petition. Now, my lord, we are today only considering the central.
And this is election for?
The central council. Please call it as the central council.
Very.
Now, my lord, central council, my lord, will be represented by all these councils, and there will be, my lord, for example, from Western, there will be 4 members. I think Southern has the maximum because most members are there. It has 5. My lord, I can give you the breakup. My lord, for Western, it's 4, Southern 5, East and North, it's 3 each. My lord, now, there are 2 things, my lord, Rule 5 and Rule 7. Now, Rule 5 is regarding who will be the voter. Now, my lord, for the voter, it is said that subject to provisions and entrance, etc., my lord, that annual and other dues are not in arrears as on 1st October previous, my lord, only they are eligible to vote who are not in arrears. Now, my lord, what my learned friend wants to say is that the voters list was published on 30th March, my lord, 31st March 2023. My lord, your lordship can find it, my lord, at page 74, where in the voters list, his name was there, the entire voters list. My lord, it was there. So he wants to contend that my name was there, and he says, my lord, Rule 7. Now kindly come to 7.
Yes, I've seen it's different. 7 is different.
Yes. Now look at this, my lord. It says the subject to whose arrears continues to be borne on the register on the last date of scrutiny of nominations. So, my lord, there are 2 dates. First is a publication. If he says, I am willing to stand for the elections, then, my lord, there is 1 notification. My lord, that notification was published on 22nd April. Kindly make a note, 22nd April 2000 and my lord 23, my lord, that is at page 92. His name was there. We published it because
So page 90, page 74 is the voters list.
voters list, my lord, and
92 is the
the first publication of nomination, the list of nominees for the different zones.
for contesting.
For contesting. And his name was there. We published it. His name was there. Then, my lord, comes a different rule, which is not there for the voters. And that is rule 12. Just have a look, my lord. And my lord, these are all notifications published by the government of India. My lord, and I'll show you, my lord.
Rule 1211 is the one which is mentioned in that notice.
Yes, possibly, my lord. Yes, you are right.
Yes.
My lord, 12. Then, my lord, your lordship has seen, my lord, already rule 7, which talks about scrutiny, subject to scrutiny. Now, this is scrutiny. Scrutiny is only with regard to nomination. Scrutiny is not with regard to voters. Now, my lord, kindly see the scrutiny of nominations. Then council shall appoint for each election a panel of scrutiny of nomination of all candidates. And the panel shall consist of 3 persons, may not the returning officer, and may not all central government.
Mr. Bose, you just come back. This
Yes,
is
sir. Yes, sir. It will take them. I'll indicate to you, what has happened. It's not a question of 400 or it's a question of 300. I have published this all by
So
notification.
you're saying that even if it's 1 rupee, it's
Of course, it has to be, and he was aware. I will tell you why. Because he's, my lord, each year for all these regional, there is separate annual balance sheet, and his dues were carried over to as a current liability. He was aware. Now, by mistake, he may have missed it. By mistake, he may have missed it.
But you're saying that even if he has missed it, then it's irreversible.
No,
That's
I
what you're
cannot
saying.
do it. I published it. I published the papers. I published the notification under Article 13, 3, small a of the Constitution of India. This is law, the notifications. As per the Constitution, I cannot do anything. The postal ballots will start direction that postal papers. There's a question of postal ballots also. It has all come back. It has all been printed. Who the nominees? Now, the entire election process will stall, which is scheduled to be held in Delhi. On 2 different dates. Entire process will get stalled.
But that's in July.
That's in July, but the election postal ballot, there's always gap given. Within this, you must do it. Within that, all part of the notification, which I'll show you. I can't do anything. He's sitting here in the headquarters. And what is more important, the Ahmedabad chapter, where probably he belongs, wrote a letter in 25th June by the finance director. The dues are payable. When the scrutineers were saying how much is due, that's a job. And say the due, we can't. So we publish the scrutiny list on 30th April. He may have missed it, but what can we do? But there is no mala fide or anything on our part. This is something which the officers, the 3 officers, central government employee and returning officer, has to do and publish a notification.
So there is no discretion, Mr.
No,
Bose.
there is nothing. You see.
So if something is in, I've seen that. If something is in arrears, then there is no provision for calling over that person and
Because not after the date of scrutiny, because notification is being issued.
No. So if it is not after the date of scrutiny, then when is the time for calling that person? There's no provision at all.
For this portion, there is no provision given, that there are so many people, about so many thousand, everyone says like a club, often you haven't paid, you won't be entitled to vote. No.
No, in a club, there's always a defaulters.
There is a club, and this is, we are governed by, that's what the difference is. This is the statute, and there is nothing we can do.
I shall answer, my lord, all of this. This is.
I'm obliged at your lordship. I thought the first thing when it came, I said, what about club? And we are all getting, you pay.
Yes, you're all getting a chance.
Yes, you're getting. There is no provision here. There is no provision here. That's why, it's all statutory. Only thing you have to show, of course, that whether he was aware of this or not, he was aware, he knew it.
Yes, the petitioner has assailed a decision of the cost and works. What is it?
Institute of Cost and Works. Accountants.
Institute of Cost and Works Accountants to disqualify the petitioner from contesting the Central
Council.
elections. Stop. The reason given is an arrear of rupees 472 / hyphen. Stop. Stop. The relevant rules are the cost and works accountants within brackets election to the council close bracket rules, 2006. Stop. Next, heard the preliminary submissions of learned counsel appearing for the petitioner and the institute, capital I. Stop. List this matter tomorrow.
Great.
Yes, Mr. Pincher.
Keeping the book.
Your Honor, can you list my matter tomorrow in the first this thing?
Mr. Pincher, I've asked you, don't please travel to the court if your matter is going to be taken up. I will tell you that. All right. Very little chance. What do you want to do? Since you're appearing in person, that's why.
After the holidays, if there's a change in the roster of judges, then so maybe I'll have to again.
No. I will ensure that you don't have to do that. All right. Whichever way the decision goes, I will ensure that you don't have to again go and make your decision submissions before another court. All right. You rest assured about that.
Thank you, Your Honor.